Madam, bench clerk, madam. Bench clerk, madam.
Court officer.
ಹೇಳಿ ಸರ್.
Court officer, madam. Hello.
ಸರ್ ಹೇಳಿ ಸರ್ ಹೇಳಿ.
Madam, list number 2 serial number 15 ಅದೊಂದು ಸ್ವಲ್ಪ ಪಾಸ್ ಓವರ್ ಆಗ್ಬೇಕು ಮೇಡಮ್, ಆಮೇಲೆ ಮಾಡೋದಾ ಇಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾ ಮೇಡಮ್?
Sir, this kind of submissions I can't accept it. Whenever your case is called, you seek for pass over, sir. Unless your submission is there, I can't so moto pass over it, sir.
No, I am not asking for pass over. No. I am saying in starting ಅಲ್ಲಿ ಹಾಕ್ಬೇಕಾ ತಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾ ಇಲ್ಲ ಆ ಟೈಮ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾ ಅಂತ ಅಷ್ಟೇ.
What do you want? ಏನ್ ಬೇಕಾದ್ರಲ್ಲಿ ಹೇಳಿ, ನಾನು ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕರೀತೀನಿ ಪ್ರತಿದಿನ.
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಡ, ಪಾಸ್ ಓವರ್ ಅಷ್ಟೇನೆ. ಯಾಕಂದ್ರೆ ಬರ್ತಾ ಇದ್ದಾರೆ, ಸೀನಿಯರ್ ಬರ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ.
ಕರ್ದಾಗ ಹೇಳ್ರಿ ಮಾರ್ರೆ.
ಆಯ್ತು.
ನೋಡಿ ಸರ್, you see your convenience, sir.
ಆಯ್ತು.
ಅದಲ್ಲ ಅಲ್ಲೆತ್ತ ಅಲ್ಲ ಮಗ
Sir, fresh matter submission or something? Urgency ಬರಬೇಕಾ?
Part third matter.
ಮೇಡಮ್ 15th ಡೇಟ್ ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ ಮೇಲೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಮೇಡಮ್. ನಾಳೆ She's saying give the memos. Okay.
ಸೀಸನ್ ಇದೆ ಮೇಡಮ್, ಆಪ್ಷನ್ ಆಗ್ತಾ ಇದೆ ನಾಳೆಗೆ ಲಿಸ್ಟ್. ಹಾಂ ಬರ್ತೀನಿ.
Option. I want to end of the list. End of the list is submit this one.
ನಾಳೆಗೆ ಲಿಸ್ಟ್
Given the memos. They state given the memos.
ಮೇಡಮ್ ಸಬ್ಮಿಷನ್
Madam,
ಓನರ್ ಅಲ್ಲ ನಮ್ಮದು ನಾಳೆ 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 ಅಲ್ಲ ನಾಳೆ ಸಬ್ಮಿಷನ್ ಇವತ್ತು ಬರುತ್ತೆ ಇವತ್ತು ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು. ನಂದು ಎಜುಕೇಶನ್ ಇದೆ, ರೀಜನ್ ಬರ್ಲಿದ್ದೀನಿ.
ನೋಡಿ ಮೇಡಮ್, ಇವತ್ತಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. ಬರ್ದಿದ್ದೇನೆ.
ಇವತ್ತು ಡೇಟ್ ಇತ್ತು, ಬಂದಿಲ್ಲ.
Give to the memo.
RPFC ಬರುತ್ತೆ. I can't mention. RPFC. I need a
ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ಕೊಟ್ಟಿ 5,000 ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋದಿದೆ. ಬರ್ದಿದ್ದೀನಿ. ನಿಮಗೆ ಗೊತ್ತಲ್ಲ ಎಷ್ಟು ದಿವಸ ತರಂತ ಇದ್ದೀನಿ. ಗೊತ್ತಾಯ್ತು ಮೇಡಮ್. ಆ ಥರ ಇಲ್ಲ, ದಯವಿಟ್ಟು ಆ ಥರ ಬೇಜಾರು ಮಾಡ್ಕೊಂಬಿಡಿ. ಅರ್ಥ ಆಯ್ತು.
Lord, any rate tomorrow day after.
ಸಿಗ್ನೇಚರ್ ಮೇಡಮ್. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
Sir. Ma'am.
ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 17 ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ಸ್ ಅಂತಿತ್ತು. ಆ ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ಸ್ ಹಾಂ ಆಯ್ತು.
TRP ಇವಾಗ ನಮ್ಗೆ ಒಬ್ರಿಗೆ ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾರಿಗೂ ಇಲ್ವಾ? ಅದೇ ಓಕೆ. ಹೋದೆ ಅದ ಟೋಟಲ್ ಹೋದೆ ಅದ
Visham, he is spoken to me.
Take all them.
With my lord's
My lords.
kind leave.
Except for lunch motions, no mentionings. Give all the memos to the court officer.
My lords,
Forgive my lord.
Matter for tomorrow, my lord.
All to the court officer.
my lords, cause list 2, serial number 17, my lords.
Call.
My lords.
My lord's kind leave.
For the end of the list, my lords. Lords, the respondent bank, my lords, is going to take the possession, my lords, of the property where I am resides, my lords. They have scheduled, my lords, for tomorrow, my lords. Without notifying me, my lords, they have taken order, my lords, under section 14 of the Surface Act. My lords, day before yesterday only, my lords, they have affixed, my lords, the notice on the compound wall, my lords.
They will come tomorrow.
My lords, tomorrow is the, my lords, they have scheduled, any time, my lords, they have.
You can't do tomorrow.
My lords, please, my lords.
You can't do tomorrow. They will not do it before. If you, all of you, please mention the urgency on that. I have gone through all the memos yesterday and given the dates. That's how the 17 matters of DRT are listed today. So let's not waste time with all these mentioning. Whatever you want to say, write on that.
Please, my lords.
This matter also, I will take it up tomorrow as a first case. Take it as a first case.
My lord's kind leave.
Great.
It's one matter. Public auction is scheduled. Public auction.
Give the memo. Is it a lunch motion?
Yes, my lord, the public auction is tomorrow. For that reason, I am moving for the end of the list today.
When was the notification?
My lord, they have not issued the notice at all. It's only through e-bidding they have confirmed. From other parties, I came to know. My lord, in respect of loan of rupees 8 crores, my lord, they are bringing totally 50 crores property for public auction. That is my difficulty. For that reason, I am troubling your lordships at the end of.
Every matter can't be adjourned like
I
this.
can understand, my lord. I can understand the
This
difficulty.
also is number 2 tomorrow.
In my case, my lord, I am in possession of the property. I am residing there. They are trying to auction my property. Though I am not a defaulter, I am a defaulter of only 2 installment. They have treated as a
When is auction?
auction. They have.
ಆಡಿಯೋ ಬರ್ತಾ ಇದೆಯಾ ನೈಸ್ ಸರ್?
ಏನ್ ಕೋಡ್ ಬರ್ತಾ ಇಲ್ಲ,
ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ಎಲ್ಲ ಬಂತು,
ಆಡಿಯೋನು ಇಲ್ಲ. ನೀವು ಕಾಫಿ ಕುಡಿತಾ ಇರೋದು ಎಲ್ಲರಿಗೂ ಕಾಣಿಸುತ್ತೆ.
ಕಾಫಿ ಎಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಪ್ರೋಟೀನ್ ಎಕ್ಸ್
ಆಯ್ತು, ಯಾವುದೋ ಒಂದು ಬಿಸಿ ನೀರು ಹಾಕಿರ್ಬೋದು.
List number 4, serial number 1 to 4.
My lords, serial number 4, my lords.
Serial number 4, my lords. Seek time for 4 weeks.
Why?
Senior is undergoing angiogram. Your Honor. Hence, he is not available today.
Inform the other side.
We are here, my
We have informed.
Yes, this is matter on November 28th.
Because there's a connected matter.
ನಾನು ಈ ಕಡೆ ಕುತ್ಕೊಂಡು ಬರ್ತೀನಿ, ಮನೆಯವ್ರು ಕಾಣಿಸ್ತಿದ್ದಾರೆ.
My lord, in this case, my lord, insurance company also filed an appeal before the division bench.
That apart, what about the notice to R1?
My lord, R1 is the owner of the vehicle, my lord.
Liabilities on whom?
Liability is insurance company, my lord. They have
questioned it.
My lord, they have challenged the liability, my lord, before the division bench.
In that case, the owner is served.
I think no.
The notice to the R1 returned with the postal share insufficient address for 2 times. The petitioner shall come up with an appropriate application for substituted service by 27th of October, or else the appeal shall stand dismissed against the first respondent. List along with, give the number.
Please.
Yes, next.
9/20 of 2024, my lord.
Yes.
List number 2, Raghu R.
Appellant for appellant, my lord. Owner.
It's okay, sir. It's okay. Thank you.
Whether it says postal share. Sir.
Mobile number. Mobile number.
Petitioner shall come up with an the appellant shall come up with an appropriate application, say for the same date like in the other case. Yes.
Serial number
To
3,
substitute service, my lord.
Tantraj K.
What happened to the first time?
Notice may be dispensed with.
I'm for the petitioner, my lords.
He is for the petitioner. He'll not accept. How can you say? For R1?
Yes.
MMO is fetching a dispensation notice to R1. Dispense with, admit, also final hearing, call for the DCR.
Serial number 4.
Yes.
For respondent 2 minutes, we have filed the wakalat.
I number 1 of 24 is filed to condone the delay, condone on condition. Admit, post of final hearing, call for the DCR. Next.
Serial number 5. Jyoti, SK.
For the appellant, my lord. R3 and R6 are confirmed the copying being served and yet to file the wakalat. Kindly be posted for admission, my lord.
You are appearing for the claimant.
Appellant.
Appellant claimant.
Yes, my lord.
Admit, post of final hearing. Call for the
That's all.
DCR. Yes, 6.
Serial number 6, Chandrasekhar Swami KB.
Paper for appellant.
Waiting for Shivanya Godana. Going to file wakalat.
I number 1 of file the wakalat.
Yes.
Number 1 of 24 to condone the delay of 91 days in filing. Condone, admit, final hearing, DCR. Next.
Serial number 7.
Memo is for seeking dispensation.
Favor the appellant
R1.
claimant, madam.
The risk of appellant, I 1/24 to condone the delay of 49 days. Condone, admit, post of final hearing.
Serial number 8. Devi Nayak.
What happened for the first 2 times?
Insufficient address.
Same
madam.
in this also, substitute service.
Please.
That earlier it returned with the postal share insufficient address. Yes.
Same date, no?
Date also same like in the earlier case. Yes, 9.
Serial number 9.
Respondent.
Rajaram.
What is this for the first time?
For respondent number 1,
Dispense with?
respondent number 1, filing memo for dispensation.
Yes, memo is for seeking dispensation, dispense. Admit course of final hearing, call for the DCR. Next.
Serial number 10.
My lord, I am for appellant, my lord.
Serial number
I will file the necessary application for substituted service, my lord. Because
Shara left.
As per the postal share, notice to respondent for 2 times returned as left. This applicant is permitted to take out notice by a substitute. So the applicant should come up with an appropriate application, same date. Yes, next.
Serial number 11.
Admit post of final hearing. Call for the
Serial number
DCR.
12.
Memo is for second dispensation of notice to R1. Dispense with IA 1/24 to condone the delay of 50 days. Condone, admit, final hearing, PCR.
Serial number 13.
In this case, my lord, serial number 13, connected matter, my lord, Nagaraj already filed wakalat, my lord. Refer the matter to local. Yes, my lord, yes, my lord. Already, my lord, conclusion, my lord, refer the matter to local.
To condone the delay of 57 days, condone, admit, post of final hearing, call for the DCR. 14.
Serial number 14.
Refer the matter to local, my lord.
Dispense with. Have you served the copies on the resolution? Yes.
I have received
Admit,
it.
post of final hearing, call for the DCR. 15.
Serial number 15.
My lord, only official objection is, my lord, in
Give that file.
page number 12, my lord. Page number 12, my lord. Last title of the judgment, my lord. Date of the judgment is shown as first day of February 24, my lord. In operative question, my lord, in page number, my lord, 21, my lord. Date of the judgment, first day of February 2023, my lord. By overstake, my lord.
Sir, 2020.
2023, it's mentioned 20.
Get it? Page number?
Page number 21, my lord. Last.
Page number 21.
As my lord, order question, last. It mentioned as first day of
February 2023.
In award, my lord, it clearly mentioned, my lord.
In the award, what is it mentioned?
25, my lord.
20?
Page number 25, my lord. It mentioned as the first day of February 2024, my lord.
Office objection. With regard to the discrepancy of the date of year stated in the cause list. Cause list is over. Notice to which is the insurance company?
No, insurance is lapsed, my lord. Owner liability, my lord.
Notice to the respondent.
Execution file, my lord. Attachment of movables are issued, my lord.
Let's see. You are the owner of the vehicle.
I am a rider of the vehicle, my lord. My lord, jointly liability. My kindly see the order portion, my lord. In page number 21, my lord. The petition, second,
it is a case of death.
Death, yes, my lord.
So court has granted how much? The compensation is?
Well, in
14 lakhs.
76,112, my lord.
112. With the interest, the rate of so and so.
Jointly liable. Jointly liable. Owner and rider of the vehicle jointly liable. Mentioned.
On what ground you are before the court?
My lord, in police record, my lord, in charge sheet, my lord, rider, this is the riding the vehicle, my lord. In charge sheet, police record, my lord. But trial court is not mentioned, my lord. In police record, my lord.
Let's see. First respondent is the rider of the offending motorbike.
Please, my lord.
And respondent number 2 is the RC owner of the motorbike.
He not contested the.
The second, you are not contested.
I am contested, my lord. RC owner is not contested.
No. The issue is about who is driving the bike.
As per
not the owner.
I am not owner, my lord. I am a rider of the vehicle, my lord. Third respondent in before this. The second respondent is the owner of the vehicle, my lord. That is Gavagoda is the owner of the vehicle.
Then deposit 50% of the amount.
Yes, my lord. That is the.
And let them withdraw.
Yeah.
Let them withdraw half of it.
Please, my lord.
The rider of the offending vehicle is before this court. As a vehicle was not insured, the liability is fixed on the owner as well as the rider. And the court has granted compensation of 14,76,112. And counsel submits that he is not the rider of the
I'm
vehicle.
not right.
And the deceased was riding the vehicle.
Yes, please, my lord.
Riding the vehicle as per the charge sheet, considering the same, there shall be stay of all further proceedings in so and so. As far as the appellant is concerned, on the condition that he shall deposit 50% of the compensation amount, and in that from the 50%, half of the amount, on such deposit, the claimants are at liberty to withdraw. The amount shall be deposited within 8 weeks from the date of receipt of the copy of the order.
Please.
Yes.
Till number 16.
Notice to the respondent.
Insurance appeal on liability, please, my lord. Offending vehicle is car. Our vehicle is motorcycle. Liability fixed against us.
What is this non-filing of original certificate?
ECA, we have doubled the entire amount before the tribunal. There is some balance calculation by the office by this office registry. Calculation, there is a 215 rupees deficit.
231 rupees.
Please, madam.
231 rupees.
231 rupees. I will deposit within 4. Kindly stay the matter, please. Within 4 weeks, deposit. If it is not deposited, if I not deposit, kindly vacate the stay also, please.
No, stay is already granted.
Please, please, ma'am.
Stay is already granted.
Not to be granted. I will deposit within 4 weeks. Kindly stay the matter.
Why 4 weeks? 231 rupees.
Non-cutter, just now I will pay it right now. The company has to pay them. Throw
That's
check
not
to
company only. Why? Who is asking you to pay? Your company should do it if they want to stay.
Check to be done by the Madras head office. Therefore, I am seeking the 4 weeks pay. That is the problem.
It is a statutory deposit. You have to do it by the time.
Already done, please, my lord. 1 lakh rupees awarded by the tribunal. We have deposited the 1,30,80805 before the tribunal is ECA, entire amount deposit along with the interest. Now difference calculated by the office is 230. I'll deposit. Already deposited the entire amount, please.
What is this case?
ECA, please.
I understand.
Please.
What is the case of death or injury? What is the amount granted?
1 lakh rupees, please.
On what ground you are before this court?
Lord, there is no liability against. Policy is not covered under the policy. That injured is not covered under the policy. Offending vehicle is car. Motorcycle, you are driving on the rider of the motorcycle. Here, liability fixed against the motorcycle, please. Instead of the motorcycle. Last. Three vehicles are involved in this case, please. Lorry, car, and motorcycle.
Liability is fixed on the United India Insurance.
Please.
Oriental Insurance Company has insured.
Is the car, the lorry, please.
Hmm.
Lorry is not involved in this vehicle. Lorry is parked inside the campus. The rider of the vehicle riding the motorcycle with the met with the next car. Car dashed against the motorcycle. He died. Rider of the motorcycle.
Why you are not liable?
No, we are not the insurer of the offending vehicle. It is the ECA.
Let's see the finding. How liability is fixed on you?
Since deceased working under the first respondent, please. That is the second respondent. We have denied the vehicle was used for his purpose, his own purpose.
Let's see that finding. 1 lakh is granted.
1 lakh is granted, please.
So let's see why you are before this court. Where is that liability part? In view of the appreciation, it is crystal clear that Deceased Rakesh was acting under the instruction of respondent number 1 and accident had caused during the course of employment.
Please, ma'am. Under the lorry, please, ma'am, not under the motorcycle. Yes, having lorry also. First, second, owner of the vehicle is having a lorry.
That's a please.
He was working under the lorry, not under the motorcycle. Okay. Vehicle was taken by the deceased.
Please read the liability part. How you're held liable. Please come to the paragraph number 29.
May I please, ma'am? In this background, the discussion need the peruse the policy. Exhibit R4, the policy pertaining to the motorcycle number so and so, engine number so and so. Though sold with the pillion rider, he was sold with the pillion rider. As per the policy, rider of the motor vehicle allowed to carry the pillion rider. And from the fourth exhibit 4, it can be seen that the period of the insurance is so and so is valid. This court gone through the limits of the liability of the very important. This policy will not come into the picture of the accident if the accidentally lost, damage, liability caused by the loss sustained incurred outside the geographical area, and the most importantly, personal accident policy covered by the driver and owner extra 1 lakh rupees 1 lakh in view of this. In view of this coolly of the seal is there, please. The first respondent had gave that the billing is to the so and so Mr. Rakesh Devadiga. Bring the seal is that I am not unable to read, please. Lorry parked in the yard. The contents that the with the met with an accident now once insured bike given by the owner borrower of the vehicle steps to the show of the owner of the vehicle cause in the accidental loss damage caused with the liability of only reimbursement extra 1 lakh rupees, which clearly mentioned that the policy exhibit 4 page number personal accident covers for the owner driver not accident 1 rupees 1 lakh. So therefore since Rakesh Devadiga steps into the show of the first respondent,
the matter is arising under the ECI Act and the court has granted personal accident coverage of 1 lakh to the employee, which the insurance company is not able to pay, considering the submission of the then counsel, and has already entire amount is deposited. They shall be still for further proceeding. Notice to the respondent: the deficit amount of 231 shall be paid within 4 weeks. Or else the stay granted by this court stands vacated. Next.
Tell number 17.
Liability is the driver of the vehicle does not have a DL, please, as on the date of the covered by the Belly Ram's case.
What is this 10,399?
This is also difference amount, please. I have deposited the entire amount. Kindly peruse the immediately after the accident.
Calculation for you and for the office.
No, I have deposited the entire amount. Office calculated the interest up to date. I mean, up to filing of the date. That is the problem. I have deposited 15,12,502 rupees before the tribunal. Produce the original.
The condition precedent to filing the appeal.
Definitely. No, my lord. When appeal was filed, we have deposited the entire amount on 17/9/2025.
You file it and come back.
No, my lord. I will say.
Every case that you won't go like that.
One submission, please.
Once the deficit.
One deficit also. I have deposited the entire amount before the tribunal. The thing is the difference amount calculated by the office right now. Office calculated the up to.
What matters is what office calculates as on the date you are filing the appeal.
I can understand. I can answer entire amount deposit, please. Not the difference amount.
Every case, what is this?
Every
case it can be your calculation.
Now they are moving the. I will deposit the entire amount within 4 weeks. That 10,000 also. If it not deposited within time, kindly forget the stay also.
Please tell the court in these ECA matters. Are you not supposed to deposit the entire amount?
Entire amount deposited, please, not.
Again, you're going back to the same. Entire amount is along with this 10,399.
Interest. Office, now I have calculated the interest on.
By granting interim orders like this, no, it becomes a precedent in all the cases.
Not well. This is the execution they are filing. That's why I'm.
That is your problem. That's not the problem of the court. The petitioner.
Well, one submit. Kindly stay the matter. I will deposit
399 as required, as calculated. If the amount is not, once the amount is paid, this is matter. Yes, 19.
I'll answer the entire amount deposited, please, my lord. Difference amount only.
Difference amount is 40,399.
No,
Call
for
list
10
is showing 10,399.
All this to mention the
That's
10,000.
what it is, 40,399.
I will deposit that amount also.
Deposit, you should deposit and come back. Yes, once the amount is 40,399, it is deposited, then list is matter. 18.
There is interest portion, please, that is.
Whatever it is, please do it and come back. Yes, 18.
Cell number 18, Venkash Siddeshwara.
That I appear for appellant, that I have filed a memo for withdrawal of the.
You want to withdraw this?
Yes, all two appeals also. Two appeals,
Yes.
18 and 19.
Yes, memo is filed saying to withdraw the cross appeal. Same is allowed and dismissed as withdrawn. Yes.
Cell number 18, 19.
19 also same.
That is also same.
20.
Number 20, hearing on interlocutory applications.
56 days delay, my lord.
Claim petition is
Dismissed, my lord.
Claim petition is dismissed. This will condone the delay on condition. Yes, I have one of 24 to condone delay of 356 days, condone on condition, admit, post of final hearing, PCR.
21.
Appearing for appellant, my lord. There is a 488 of delay, my lord. And
Yes.
Delay will be conducted subject to denial of.
That's what. For 488 days, admit post. What is that?
connected matter is there.
Post along with so and so, take that. Yes, next 22.
Cell number 22. 22. Girish.
No representation, list is matter for dismissal on 10th of November. Yes, 23.
Cell number 23.
307 days delay in filing the appeal.
Who appears, Liberty Videocon.
Ravi Samprati is appearing.
Yes, Mr. Sampati. Mr. Ravi Sampati is directed to take notice on behalf of the insurance company. I number 1 of 24 to condone the delay of 307 days on condition. Admit post of final hearing.
Trial court records may be called for.
That's what. Call for
Please.
DCR. Yes, next.
Cell number 24.
KSRTC, who appears?
KSRTC.
Mr.
FS Dabali.
Ashok Naik.
Huh?
Ashok Naik.
So and so is directed to take notice on behalf of the KSRTC. I number 1 of 24.
Delay of 42 days.
Filed to condone the delay of 42 days. Condone. Admits post of final hearing. Call for the DCR. Next.
Number 25. Pramodar.
I'm appearing for the respondent. Formally, I had filed the objection. Delay
I number 1 of 24 is filed to condone the delay of 690 days in filing the appeal. You have filed already?
No, filing.
Huh?
This year.
Huh?
Now I'm filing.
What do you mean?
File it in the section.
Filing counter.
File it in the counter. List is matter. Next week someday. Yes, or list is matter no on 3rd of November. Yes, 26.
Cell number 26.
Okay, for the appellant.
Department no. 26. No condition to for two. Yours is 5979. No condition. I number 1 of 24 is going to condone the delay of 579. Condone. You are seeking stay.
Yes, but here, but the involvement of two vehicles.
Oh.
In my appeal, what the first response is the claimant. That Srinivasa appears not. He may be permitted.
Respondent number 1, my lord, I will take notice.
For respondent number 1, Mr. Srinivasan Emba is directed to take notice.
And third respondent, what insurer?
Respondent is Mr. S.V. Hegde Mulkar.
I appeal for the third respondent, my lord, in the first case.
You have filed any appeal?
My lord, delay may kindly be condoned and the matter may be.
I'll know like the insurer.
So, the entire liability is on.
Yes, madam.
What is the amount granted?
Amount for 1 lakh. A case of the involvement of two persons, not a settle.
Some disturbance.
From Srinivasan. Only on the ground that the FIR charge sheet has been filed against the driver of the corporation bus. The liability has been fixed more on the corporation.
You are on contributory negligence.
Yes, not.
You're on the apportionment of negligence.
Yes, madam. Negligence.
It is submitted that when two vehicles are involved in the accident, the liability is fixed only on the appellant insurance company.
Corporate case not.
Appellant KSRTC. The deposit 1 lakh.
50% we will deposit.
1 lakh to deposit. There's call for the on the condition that the appellant shall
I may permit it to withdraw the amount.
such deposit, the claimant is at liberty to withdraw.
Including what? Including statutory deposit amount. Including statutory deposit, we have deposited 25,000.
That is 1 lakh is what you are supposed to deposit. On that they are entitled to withdraw.
Including what? The statutory deposit which I have already deposited.
Statutory, whatever it is, they are entitled to withdraw 1 lakh. Yes.
In my case, my lord, R220 may be dispensed with. In my case,
No, just a second. Yes, next.
Cell number 27.
What is, let's see, any insurance company is there?
Yes. Oriental Insurance. Oriental Insurance R2.
Who appears for Oriental?
I appear
Mr. Ashok and Patil
For R2.
is directed to take notice on behalf of respondent number 2, issue notice to R1.
Cell number 28. Purandar.
Third respondent.
Delay of 141 days, condoned on condition, admit course of final hearing.
My lord, the matter is connected with the MFA 1158.
Write it on the paper and give along with, list along with so and so.
It is before the Honorable Division Bench, my lord. The matter is referred to Lok Adalat. There was an order connecting this appeal also, but this is not connected and listed today, my lord.
Then what happened to the
Lok Adalat? It did not get listed the other day. Next Lok
So then
Adalat.
we'll list this matter along with so and so before the Lok Adalat. No admit course of final hearing. Yes, 29.
29.
I am for the respondent, my lord.
Krishna Kumar.
Yes. I number 1025 to condone the delay of 343 on condition. Admit course of final hearing. Call for the DCR.
Cell number 30.
My lord, I am for appellant, my lord. There is a delay, my lord.
8 days.
The respondent number 2, my lord.
On condition. Admit course of final hearing.
Cell number 31.
Records may kindly.
Everything will be called for.
Cell number 31.
Delay of 44 days.
31, I already served the copies, my lord, for the Lok Adalat.
IA number 1025 to condone the delay of 44 days. Condone, let council submits that. He has already served the papers of the council for the respondent. Admit course of final hearing. Please call for the DCR. 32. 35 days. Condone.
32 also, my lord. 32 also.
Papers are already served for
Yes,
the respondent. Yes, admit course of final hearing. Call for the DCR.
BPS Associates.
I pay for appellants in this case, ma'am.
There is Mr. Ravi Shankar.
Yeah,
Case of death, my lord. Claimants appeal for announcement, my lord.
Where is Mr. Ravi Shankar? There is no representation on behalf of the insurance company. I number 1025 is filed to condone the delay of 933 days for the reasons stated. The delay is condoned. However, on the condition that he will not be entitled for interest, admit post of final hearing. Call for the DCR.
Cell number 34. 89.
Claimants appeal for enhancement, 49 days delay in filing the appeal, my lord.
Yes, condoned.
Only short
Admit
question, my
post
lord.
of final hearing.
Cell number
Short or
35.
long will be heard.
Please.
Yes.
35. Girish B. Baldare.
84. The notice, let us see. Which is the insurance company. Look at the cost item.
That is Reliance Insurance.
Reliance Insurance, who appeared? You appear? Ashok and Patil is there to take notice on behalf of the insurance company. Who are the other respondents? And the learned counsel shall show the copy of the appeal memo on the council. R1 is insurance company or R2?
R2 is insurance.
R1 notice to R1. Yes, next.
35.
This is 35.
36. R. Shashidhara.
Notice to respondent number 1 and 2 make and leave it. Dispense.
Memo is facing dispensation of notice to
Number
1 and
3
2.
maladu IFCO Tokyo General.
3 is
IFCO Tokyo General Insurance Company.
IFCO Tokyo. Shivanagowda appears.
Either.
Mr. Shivanagowda is directed to take notice on behalf of the insurance company. Serve the papers on him.
Please, madam.
Admit, IA number 1 of 25 is filed to
68 days,
condone the
sir.
delay of 68 days. Condone, admit post of final hearing, call for the DCR 37.
37.
Ma'am, for appellant, dispensation to R1.
Memo is filed seeking dispensation of notice to R1. R2 is
United India.
United India, who appears? Mr. A.M. Venkatesh. Yes, madam. Mr. A.M. Venkatesh is directed to take notice on behalf of the respondent insurance company.
Delay.
Admit, there is a delay of 145 days condoned on condition. Admit post of final hearing, call for the DCR. Next 38.
Serial number 38.
Admit final hearing.
Serial number
DCR
39.
39. This also same order 40. Notice is dispensed with. Yes, 38 admit, 39 admit, 40 also admit.
Serial number 41.
41, my lord, another case RTC appeal filed, another appeal, my lord, that is in division bench, my lord, to call along with that matter. My lord.
It will go along with the other matter, the division bench matter.
Yes.
In 41.1, IA number 1024 is filed to condone the delay of 189 days on condition condone. It is submitted that the other matter, the matter is pending before the connected matter is pending before the division bench, placed along with so and so
Yes, ma'am.
Serial number
before the
40.
division bench.
42. Vingraj HS.
Yes, admit, post of final hearing, call for the DCR.
Serial number
Next
43.
43. Admit, 44.
Serial number 44.
Yes, admit, 45.
Serial number 45.
44.1, notice may be dispensed with respect
Already
of
wakalat
R1.
and all filed,
Notice not yet ordered, but
not ordered.
it is connected with 44.
A memo is filed seeking dispensation of notice to
R1.
R1.
Yes.
Memo is taken on record and notice to R1 is dispensed with. There's 45.
For appellant, my all cases.
Serial number
My lord,
45.
45.6, my lord.
Yes.
Respond number 1, kindly notice may be dispensed with, my lord.
Till 45.6. Notice to R2.
So there is one more connected appeal, my lord.
No. It is notice is to dispense notice to R1 and R2.
R1, my lord.
And then
R2 is the insurance company, my lord. Geeta Raju appear the some cases, my lord. Kindly direct to.
No. R1 is only no dispensation to R1.
R1.
Memo is filed seeking dispensation of notice to R1 dispense with R2. Ms. Geeta R is directed to take notice on behalf of the insurance company. Admit post of final hearing.
Please.
Or for the DCR.
There is one more connected appeal in this, my lord.
Oh,
It may be listed.
list along with so and so. Yes, next 46.
To appellant, my lord. This claimant's appeal under.
Yes, admit post of final hearing. Call for the DCR. 47.
Serial number 47.
Yes, same.
Serial number 48.
48 also.
Serial number 49.
No, in 48, it's fresh matter.
First time matter.
Yes.
Notice to respondent number 1.
Who is respondent number 1?
Owner of the vehicle.
Is to dispense with.
Please.
Memo is filed seeking dispensation of notice to R1, dispense with, and what is the insurance company?
National Insurance Company.
Who appear for National Insurance Company?
But I can take notice, my lord.
Mr. Venkatesh is for AM Venkatesh is directed to take notice on behalf of the insurance company. Admit post of final hearing, call for the DCR.
49.
What about 49? BMTC,
49.
which is a respondent, take the file.
Managing Director. No, that is BMTC.
BMTC,
Case notice.
KSRTC. Who appear for the KSRTC?
That FS.
Dabali appears.
Hmm.
Mr. Dabali is permitted to take notice
For R2.
on behalf of the respondent company.
R2.
R2, R1, notice to R1. Yes, 51.
Number 50.
Memo is filed seeking dispensation of notice to R1 dispense with, which is an insurance company.
Oriental Insurance.
Oriental Insurance Company.
C.R. Ravishankar.
K. Nagaraj.
So and so
K. Nagaraj.
is directed to take notice on behalf of the insurance company. So notice service is completed. Admit post of final hearing.
In all matters, wherever not notices.
Yes, next Ashok and
Serial number
Patan.
51,
If merits, company appeal merits on the ground of merits, negligence and quantum.
14,
What is the compensation that is awarded?
Merits, the compensation awarded is 29,16,520 minutes.
16,520.
520, yes.
It's a case of death or injury.
Case of death minutes.
On what ground you are before the court?
Minutes, the quantum minutes which is awarded minutes is on the excessive side. The bank
According to you, how much it should have been?
minutes, it would have been minutes 20 lakhs according to me.
So deposit 20 lakhs.
This
It is submitted with the land council that the court has granted the compensation on the higher side. And it is submitted that. On what count it is on the higher side?
They make submission, but may be permitted to undertaking the.
You will take for, yes.
So I'm filing dispensation notice to respond number 4. 1 to 3, my learned friend minutes will take.
A memo is filed seeking dispensation of notice to R4. Memo is taken on record and notice to R4 is dispensed with. Mr. N.R. Rangegowda submits that he has instructions to file wakalat on behalf of respondents 1 to 3. 1 to 3.
Yes.
1 to 3. Considering the submission of the land council for the appellant, they shall be stay of all further proceedings on the condition that he shall deposit 20 lakhs with the 20 lakhs within 8 weeks.
With accrued interest, your lordship.
20 lakhs with accrued interest within 8 weeks on such deposit. The respondents or 1 to 3 are at liberty to withdraw the amount as apportioned by the tribunal.
Before the tribunal, I'll deposit.
Before the emergency.
Admit post of final hearing. Call for the DCR. Yes, next. All these matters from 52 will take up in the afternoon. All the final hearing matters. Just call the next list.
number 2,
66, your lordship, next week.
Afternoon.
66. 2 weeks.
Inform the other side.
Yes, Dabari, I will learn from.
66.
2 weeks.
66 on November 10th. Yes.
My lord,
serial
number 55, my lord. Refer to
serial number 1,
Sorry, my lord, serial number 65, my lord.
Yes.
Serial number 65.
list number 2, serial number 1.
Yes.
Sandhya, you
I think suddenly the list is jumped from there to the advocates are not there. You know, you updated the. This matter password 1.
serial number 2,
All your final hearings at 2:30, Mr. Shivanagoda.
Kindly pass over the matter.
2 also pass over. Yes, pass over.
serial number 3,
Okay, for petition in this case.
serial number 3,
Yes.
For short accommodation.
I filed for vacating my lord. The outstanding is around 33 crores. This is a third petition. I just filed my.
What is question sale before this court?
Section 14 has been challenged and then say account is, declaring NPA is challenged, then 13.4 is challenged, position, all this is challenged. On the grounds that Pronit's case is to the rescue, there is a MSME account and they have to get the benefit of MSME resolution of 2015 is what they have contended and have obtained a stay. Lord, I just want to take your lordships to the counter which I have filed. If your lordship may
Are
see.
you arguing or you are assisted by senior counsel?
I'm led by senior counsel. I not file my rejoinder.
But all these matters, I will not adjourn any of the matters where vacate petitions are filed.
Please, madam, I'm not.
Because first of all these writ petitions which we are not supposed to entertain are being entertained. We will not.
Interim order, madam. This was granted, madam, because there is a legal lacuna in.
Anyhow, that's how we'll see.
Madam,
But
two- Any
vacate
next week,
petitions,
madam.
whenever the
Please,
other
please,
side
madam.
comes with the vacate petition, I'll not adjourn the matter.
I understand what, madam.
When do you want?
Any date next week.
My lord,
24th,
your lordship may
madam.
kindly see, 2 writ petitions have already been filed, these are pending. They have gone before the essay.
No, what we do is,
They have filed
anyhow,
same-
they have been enjoying the stay. We'll give them the benefit of it till the next date and
For
no
a
further.
short date, my lord, because the
24th,
outstanding is
madam.
huge.
24th, madam.
20?
Next week itself, 24th.
We'll take it up
That
on
is
24th.
after Diwali.
And let him celebrate Diwali with this stay.
Sure.
This is matter on 24th, no further adjournments.
Top of the
Interim order
list.
may kindly be.
Interim order granted earlier is extended till then.
Great.
The cause list should also reflect that no further adjournments.
Great.
Top of the list or something, my lord,
Huh?
where it can reach top of the list or something.
It will come. Yes, next.
Cell number 4.
For the petitioner, my lords.
My lords, I appear for respondent number 5, my lords. I filed my wakalat on 13th. My name is not reflected, my lords. Let my name be reflected and I'll file my objections. I'll seek for a short time.
Led by senior counsel. Also seek.
You have a stay in this?
Please, madam. Stay.
Yes, at the request of learned counsel for the respondent, this is matter on 10th of November. Interim order earlier granted is extended till then.
My name may be reflected, my lords. My name,
What is your name? Give it-
Ajesh Kumar Shan.
So and so submits that he has filed wakalat, which he is directed to print his name. Yes.
Very grateful.
Yes,
Ayomi me.
Cell number 5.
Ayomi
Yes.
me.
Preliminary hearing 5.
Hearing for petitioner, madam.
Petitioner MD.
Challenging the order dated 4th August 2025 in series number 1027 at 20.
Where is the order? Please refer to the page number.
Page number 24, sorry, 14 to 20, 17.
20?
14, my lord. 14 to
14.
17.
Yes.
Petitioner availed the loan amount of rupees 3,50,000 from the respondent bank, my lord. He said amount not paid.
The authorized officer of the petition company filed the present petition so and so against the respondent. On what ground you are questioning this order?
My lord, the scheduled property is different from the petitioner filed by the series number 1027, filed by the respondent.
There are proceedings before this, 13, your notice is given to you under 13 too.
My lord, the notice was not received me in the series number 1027.
Not about this. Before that, they must have given you a notice under 13 too.
Please,
Then where is the 13 to notice?
I'm not placed before this.
Then,
Notice may
If-
be issued.
huh?
Notice may.
We will not issue notice just like that unless and until I am convinced.
My lord, I will pay the amount of rupees, the loan amount, my lord, some
It is not, no bargain of that nature. First of all, you should make out a legal ground. Why this court should entertain this writ petition? And what is wrong with the order impugned? Unless and until you satisfy that, we can't pass.
Maybe
Huh?
2 weeks time.
No, 2 weeks time.
Weeks
This is matter on 20, on 27th.
That's okay.
Cell number 6. Cell number 6.
Yes. Password, 7.
Cell number 7.
Appearing for petitioner, Your Worship.
MA Rajendra.
Appearing for petitioner, Your Worship, in this matter, there's a demand notice given.
Huh?
There's a demand notice given for a vehicle, but that vehicle is in a garage for since long time. the master kit is going repair, again continuous repairs. So what we asked them to settle the CGTMC loan, the vehicle loan only. So we give us the permission to sell this vehicle and we'll settle that loan. It will directly go to the loan proceeds. But what they've done is they will involve the other loans too, the cash credit loans, which is in the company. We want them to like permit us to sell the vehicle and complete this loan. We will regularize the other loan, cash credit loans and other things. So for that, kindly issue notice to them.
Give that.
Permission may be granted.
What happened to the other loans?
Your Lordship, that will we are ready to regularize. Due to some inconvenience in
You should have
COVID time,
approached them. Where did you approach the
yeah,
bank?
we have approached them twice.
Where is
Your
that?
Lordship. The,
No, 13-2 notice is issued. Where are your objections or representation?
representation is on page number 32, Your Lordship.
32. Notice is given to you on 15/4/2023, 1/5/2023. What is happening from 23 to now?
Your Lordship, they're not ready to settle the matter. They're like including all the loans in one only. They're not ready to settle this hypothecated vehicle loan.
Then you will come to the High Court.
Yes, Your Lordship, just to grant us the permission, like direct them to permit us to sell the vehicle, and because it's in the garage only and it's continuously depreciating, you're not even able to use the vehicle. So on that basis, the garage owner is like he will not take the vehicle, and he's ready to.
No. After issuance
purchase
of
the
notice and after receiving your objection or representation, what did the bank do?
They're not ready to settle that.
They must have done something if they're not ready with that.
No, Your Lordship, they're giving this again. They want to settle all the loans. If you want to settle, you have to settle all the loans. You are not supposed to settle the only single loan.
No further action they have taken.
No, Your Lordship.
Huh?
Before that, they have given a position notice on basis of that cash credit loan, which in DRT it got allowed on our side. Our essay got allowed. But in this,
Where are those orders?
Those are Annexure B, Your Lordship.
Annexure?
Annexure B.
Let's read.
Page number. Page number 17, Your Lordship.
What happened after this 13/4 notice is set aside by the DRT? After that?
After that, they have again given this notice, demand notice.
Where is that? Where is that?
13/4. This one, Your Lordship. Annexure A. In that, they have given demand notice for all the loans. Like
Mr. Counsel, this demand notice is dated 15/4/2023. And the possession notice is 1/7/2023.
Yeah. Okay. Then for further proceedings of bank here also. That's not there in this. Like they the representations made by him.
What is this writ petition?
You know, just the permission to sell the vehicle and complete the hypothecated vehicle loan.
For that you will file a writ petition and High Court will pass orders.
Just to direct the bank to let us permit us to sell the vehicle. Because the vehicle is continuously depreciating. Even if the bank people, if they
look at your prayer, what is the prayer you got?
Lordship, to issue writ of mandamus directing the respondent bank to permit the petitioner herein to sell vehicle model as requested by them with their letter dated 1/5/23 and the legal notice.
Can there be a writ of mandamus to the bank to do this?
Your Lordship, but they are not all listening. They are not ready to listen for this, because if the vehicle keeps on depreciating again, even if they possess the vehicle, it will go. They have to sell it to a scrap dealer. Even they won't get that value, and again the case will come upon us to fill the remaining amount. So to stop that harm, we are requesting you to make any settlement.
Where is the latest representation of yours?
Lordship, the latest is a legal notice 17/3/25.
Where is that?
It's Annexure C. Just a minute. Annexure D, Your Lordship, page number 34. For that they haven't replied.
For that, we can't issue a mandamus.
But also at least the settlement can be made because this vehicle is continuously depreciating. It's not coming to any use to us. And even if they sell, it won't come to any use to them. It will again be a burden to the petitioner to pay the whole amount.
That is your problem and the bank's problem that.
But they are not ready to listen your step. That's why we are.
Can the court compel them to do something which they are not, are they legally bound to do it?
But your lordship, OTS should be available to everyone without discrimination. OTS should be available to everyone without discrimination.
We should compel the bank to enter into a OTS thing. In the terms of how you want it.
Your lordship, but the inherent power of your lordship and
No inherent powers.
Inherent powers of the
Supreme Court said don't use those powers like this.
No, your lordship, it's not like we are not paying the loans. We are ready to regularize the other loans as well.
What are the other procedures that is available for the one-time settlement? And
We are continuously making representation in front of the bank, but they're not ready.
I'm not inclined to pass any order.
Kindly, Your lordship, once if any settlement is made here only, it will be so much help to avoid harm causing to the
Please
petitioner.
notice for respondent.
Then number 8. Going for the petitioner, my lords. Lords, impugned order is under Annexure D, my lords, at page number 40, my lords. Notice under section 13(2) has been issued, my lords, under the surface proceedings, alleging that from 3/4/2025, the account has become irregular. Whereas, my lords,
Then what did you do?
my lords, we have responded at Annexure E, my lords.
Let's see that.
Yes, my lords.
After that, what happened?
My lords, thereafter, without complying with Rule 3A, my lords, 13(3)A, where they had to give reasons as to why this has been rejected. My lords, the primary concern of the petitioner is that the classification of NPA itself has been erroneously done, because after
Let's see that.
3/4/20,
Let us see your representation.
Please, my lords. Lords, my representation is at Annexure E, my lords, at page number 44. Lords, dispute over NPA classification. We challenge the classification of our account as NPA on July 2, 2025. The records indicate that our account remains in the special mention account category with payments overdue for less than 90 days. My lords, on May 29, I have made a
Please
payment
read it further.
Please, my lords. As per the Reserve Bank of India guidelines for NPA classification, we have been managing our financial obligations despite significant challenges, and we believe the NPA declaration is premature. We request a detailed statement of accounts, including payment records and overdue calculations, to verify the classification. An incorrect classification would invalidate the demand notice and necessitate its withdrawal. My lords, in addition to this NPA classification, we have taken other grounds, my lords, of MSME status, women-led enterprise, whereas, my lords, also the bank's conduct and the lack of cooperation. My lords, my Annexure B, my lords, is a compilation of the correspondence that we have made to the bank from 2023, my lords, seeking a conditional.
There is a 13(2) notice.
Please, my lords, that is at page number 40. My lords, may kindly see the relevant part at page number 40.
This
My
is
lords,
dated?
This is dated 7/7/2025. Within 60 days, I have replied, my lords, via Annexure E to the demand notice. My lords, here, my lords, may kindly see the last paragraph. However, from 3/4/2025, operation and conduct of the said financial assistance credit facilities have become irregular, and as such classified as NPA on 2/7/2025 is the last
And
line.
thereafter, what did they do?
My lords, thereafter, they have issued a frivolous reply, my lords, just to be in compliance with 13(3)A. My lords, that is.
Yes, so you said they have not given.
Please, my lords.
They have not given. They have not given the reply.
My lords, they have not given reply in compliance with 3A. My lords, as per section.
Where is the reply?
My lords, may kindly see at Annexure F, page number 47. My lords, may kindly see the response that they have given me, which is relevant at 48. We acknowledge receipt of your representation dated 4/9, received at your end through our so and so. In response to the demand notice served under 13(2) of the SURFACE Act. At the outset, we confirm that all details provided in the said notice, dated 7/7/25, including the date of classification as NPA, outstanding amount, applicable interest rates, and particulars of secured properties are accurate and in accordance with the records. Below are the particulars of the credit facilities. Loan accounts were classified as NPA on 2/7/2025 in compliance with prevailing guidelines by the RBI. Interest has been levied on the account in accordance with the terms and conditions stipulated in the loan documents. As on 16/9/2025, outstanding is so and so. You are requested to arrange for the funds of loan closure. Please note that the failure to comply with stipulated in the demand notice will compel the bank to initiate appropriate legal action under the provisions of the SARFAESI Act 2022. Millards 2002. Millards thereafter, in fact, Millards may kindly see that annexure G that I have produced, that is the RBI circular for classification of NPA. Millards, the mandate is that for 90 days there has to be an irregular account. Millards, I have produced the bank statement at annexure C, Millards, which is at page 32. Millards, the relevant page is at page 33. Millards, may kindly see the entry on 29th May 2025. I have made deposits of 5 lakhs and 5,42,380. This is, my lords, after 3/4/2025. That is the date that they consider for calculating the 90 days. My lords, because 3/4/2025 ninda 2/7/2025 is 90 days complete agate. And the 90 days that account has to be irregular as per their demand notice. However, my lords, on 29th May 2025, I have made a deposit of more than 10 lakhs. Which ensures that my account does not go into an NPA. My lords, may kindly see the annexure B that I have
Before
produced.
that, when is the amount paid?
Please, my lords.
Before that, when is the amount paid?
When is the amount, my lords? My lords, again on 28th April. My lords, on 38th page 2, it's on page 32. 28th April, there is 5,61,000 deposit, 65,000 deposit. Then, my lord, 7th May, 46,000, that interest amount, NEFT transfer is done. My lords, my lords, may kindly see my annexure B, which will highlight, my lords, the conduct of the bank and the lack of cooperation. My lords, I have repeatedly from 2023 sought for two things, my lords. One is renewal of the OD facility.
And please show,
please,
what is this, what is your account before 3/4/2025?
My lords, I have not produced the statement.
That is what is relevant.
My lords, the submission here is from one.
You have just because you have paid some amount in the month of May, you cannot say that
my lords, my submission is not that at all, my lords. My submission is that the classification of NPA was possible only if my account remained irregular for 90 days. My lords, that is the RBI regular circular.
To demonstrate that, you have to show. They said 3/4/2025.
Please, my lords,
what is there? What has happened to prior to that? The account you should have placed before the court.
Well, it's from 3/4/2024. I have placed from 1st April 2025. I have placed the statement.
No, they say that
outstanding is 5.5 crores. There is no doubt in that, my lords. We have made that 5.5 crores outstanding is there.
They say that from 3/4/2025, the operation conduct of said financial assistance have become irregular.
From 3/4/2025. My lords, their statement is categoric that it is from 3/4/2025. And I have statement on record to show that from 3/4/2025, it is not irregular for 90 days at all. And hence, my lords, as the section 13.
What is the amount that is supposed to be paid?
My lords, as per the demand notice, it is 5.9 crores.
Monthly?
Please, my lords.
Monthly.
Monthly, my lords. I'm not exactly aware of what is the interest rate. I will verify that, my lords. But in the meantime, my lords, the other two loan accounts, that is the loan in the demand notice, my lords, there are 3 loan accounts. Two were for 50 lakhs. One is for 1 crore and one is for 50 lakhs. Both those loan accounts have been closed. Only pending account, my lords, is today, that is 5.5 crores. That is the OD facility that we have availed, which, my lords, in our submission is not irregular. My lords, it is not to be classified as an NPA as per the RBI regulation. My lords, the bank, in accordance with section 13(3)(a), should have given me at least an opportunity with the statements, with the classification as to how it has come into a NPA. My lords, I have made several representations which I have produced at annexure B.
Just stated that how it has become NPA.
My lords, they only say that it is as per the records, it is NPA. There is absolutely no accountability, accounts or statement or any reasoning as to why they are saying that it is an NPA today. My lords, in fact, in my reply, my lords, I have also given.
Please look at that.
Please.
The reply that is given under 13.3A, 48.
Yes, my lords.
No, if you're regular, liability as on date 16/9/2025, it is 5,74,000. In respect of the other account, it is so and so.
Yes,
and
lords.
but in respect of the other account, it is
20 lakhs.
20 crores
20
11
lakhs. 20 lakhs.
20 lakhs 11,411.
These two accounts I have recently
You know,
closed.
how much amount you are ready to pay now?
My lords, my submission is that
We will not, if you want, I'll issue notice to the respondent. We will not grant any interim order unless and until you pay the money.
my lords, my submission is only two front, my lords. I will pay the EMI that I am due this month, my lords. I will deposit that money. My lords, the classification itself is erroneous. And I do not have any other recourse.
No, they have not taken any other, no.
My lords, now I have been informed after the filing of this WP, my lords, that they have also issued a 13-4 notice, my lords. I have been informed. I will seek liberty to amend this petition also.
Take out handsomens to the bank.
Please.
Once the bank is here, then we'll hear them and pass orders.
Please.
The petition is permitted to take out handsomens on the respondent bank and shall file a memo to that effect. Once the memo is filed, this is the matter. Yes, ma'am.
My lords, a date may be fixed. I will.
Once you file the memo, it will be listed. Once you file the memo, it will be listed.
Please.
That's what I said.
Please. Great.
For the petitioner, my lords.
Yes.
My lords, I'm the agreement holder in this case. The bank has issued a sale notice. Respondent number 3 is the actual owner of the scheduled property, my lords. He's availed a loan facility.
First, how you are before this court by filing the writ petition? Why you shouldn't go to the DRT? What is the exceptional nature of this case where this court has to exercise a jurisdiction? First, you argue that, then you can tell the other facts.
My lords, I got the intimation about the sale notice only on 3rd of this month, 3rd October. And then when I approached the bank, they told your representation is not valid, and which I have not produced, my lord.
Why you can't go to the DRT?
My lords, the e-auction is tomorrow, my lords. So I'll need some time to figure out.
It is never intimated to him any of the proceedings?
No, he knows that. He is neither a borrower nor a guarantor. He claims from the borrower he has an agreement of sale. He has no locus to file this.
How can agreement sale order will come before the court?
My lords, I have invested about 2 crores with respondent number 3, my
How can
lords.
it be?
He has filed a suit for specific performance, my lord.
There
He
is a
can ask
stay,
for
my lords.
refund of his money in that suit because my mortgage is prior to him. My mortgage is 2013.
Then,
His agreement is he cannot go to DRT
will
also.
prevail, even otherwise also.
His remedy is to recover money by filing in a
A
specific
separate suit
performance.
against.
He's already
filed
filed.
the suit.
He's already filed. He should ask for.
My lords, I'll deposit
No.
20 or 25%. My
No,
lords.
no.
Let the e-auction be
But what
delayed.
is your locus?
That is shows
The
the collusion.
securitization proceedings are initiated by the bank against the borrower. You are not a borrower. Your agreement of sale that is executed by the borrower is itself is a subject matter of the specific performance suit.
Yes, my lords.
So you have no locus in this writ petition to file this writ petition, questioning these proceedings under the Surface Act.
My lords, but I'm ready to deposit the amount, my lords.
Tell your client that I'm going to dismiss tomorrow and dismiss it. This is matter tomorrow. Password. Password.
Bank has issued, my lord, sale notice Action should be held on 17th, my lord.
That's what I'm saying.
My lord,
In
day
all
before-
these matters,
Please, my
only
lord.
one question.
Submission, my lord. Even day before yesterday, I paid even 10 lakhs, my lord, amount to the bank. Property, my lord, worth is more than 2.5 crores. They have quoted 45 lakhs, my lord. I will ready to in 6 months' time if given, my lord. I'm ready to pay, my lord. That's why I'm paying this. Even yesterday, my lord, 30th, my lord, I paid 10 lakhs to the bank.
If it is, if on that ground you're before the court, then the bank has to agree. Because court can only pass an order on basing on,
17th, my lord, is action.
let the bank come. I can't pass any order because there is no irregularity, nothing.
Please, I'm
And
seeking only time to deposit them. I'm ready to
further,
pay.
they have to should also accept. They issued the notice. All these proceedings must have started long back, isn't it?
I'm paying regularly, my lord. Even 27th also I
Further,
paid
the
10
bank
lakhs.
has to be here. Any interim order you're seeking, bank has to be here. We
I
cannot
lost my
interfere like
commercial
that.
property, my lord.
Huh?
Last auction will held, my lord.
When was the auction notification issued?
My lord, last week, my lord. I ready
Is
to
the
pay.
bank, Karnataka bank, who appears? Or the panel counsels? You appear?
Besides,
On the panel.
Karnataka.
Yes, my lord, I am on the panel of Karnataka Bank.
Karnataka bank.
Take notice.
So papers on the.
Please.
And please get instructions. I'll have it tomorrow.
Yes.
List this matter tomorrow and counsel the petitioner is, the so-and-so is directed to take notice on behalf of the respondent bank. This, whatever he is saying, will you please get instructions?
Yes. Lord, I take notice for the bank, my lord, in this.
Today, my lord, the date fixed for action. I'm ready to deposit, my lord, 20% of the claim, my lord. Petitioners are the guarantors. Instead of, my lord, the second respondent is the principal borrower, and the mortgage has been made by the second respondent. The property, my lord, the offered by these petitioners, my lord, they are the guarantors, my lord. They have already deposited 70 lakhs before the respondent.
Who principal borrower?
No, myself, guarantors. Principal borrower, my lord, has not paid any amount. It is, my lord, guarantors, my lord, they have already deposited 70 lakhs. At present, my lord, I'm ready to deposit 20% of the entire claim. Entire claim itself, my lord, the 7 crores 21 lakhs, my lord. Let them first proceeded against the property of the principal
What
borrower.
has happened? Why the bank is not proceeding against the principal borrower?
Principal borrower, my lord, is no more. In fact, the guarantor is
No,
Mr. Harish Kumar, who's the
why he is
petitioner, my
there?
lord.
Why
Yes,
he is
there are legal heirs, but then he's the mortgager, my lord, and the bank has the, in fact, bank is in physical possession.
That their liability is coextensive. There is no dispute on that.
Yes, my lord.
Why the bank is not taking any steps against?
Both the properties are put on sale, my lord. Both the properties. In fact, it's the 5th time it's coming up for sale. 7 crores is the due.
Which when it has become NPA, the account?
My lord, NPA is in 2021 itself, my lord. 34/2021. 34/2021 is the date of NPA, and demand notice was issued on 15/5/2021.
What is the outstanding amount?
My lord, 7 crores, my lord. This is an OD limit. It's not even a housing loan or something. It's an OD limit. 5 times it has gone for sale. We are also in physical possession of the property, my lord.
Loan sanctioned to the extent of 4 crores 77 lakhs 95,000 out of the 3 loan account. Now the outstanding due, my lord, it will comes to 7 lakhs 21,000. As on today, my lord, I am ready to deposit 20% of the entire claim.
20% of.
So OD, it's not possible to regularize,
What
my lord.
happened,
They
my
have to
lord?
close the loan.
My lord, they
Let
have
the
not
sale go
proceeded,
on,
my lord. So far as my lord, first let them proceed it against the property of the prince. I am also ready to deposit,
Because they
being the
cannot be-
guarantors.
Mr. Counsel, there can't be any order of that nature. Court cannot tell them you proceed against the principal
Lord,
borrower.
today, my lord, they have fixed the date for action.
To stay there, there should be some legal ground.
My lord, so far, my lord, the 30 days advance notice, my lord, they have failed to issue. My lord, whatever, my lord, they have issued notice, my lord, and under
It is the first
annex 30.
sale or the second sale? First
sale.
time or second
No,
time?
my lord.
22
No, I'm saying 5 times it is put up for sale. First sale is on 33/2022.
No personal notice, no personal notice on the guarantors. My lord, no electronic communication also, my lord, for the, my lord, the bringing the property for sale. There is a procedure irregularities, my lord, rule
That you
8.
point out, let's see, that you point out and let them, you have instructions right now?
Lord, they've not served a copy. They just
I
sent a
will- I
notice
will-
that this matter is listed. So I don't know. I don't have the
Yesterday,
copy
my
of
lord,
it.
I made a communication.
Just a letter.
Today is the sale or tomorrow is the
Today
sale?
is the sale, my lord. Today is the sale.
Ready to deposit 20%. Let them, my lord, they fix the date. I'm ready to.
Pass
try-
over, pass over. Please get instructions.
Let them serve a copy.
Serve the copy on her.
I'll just- Yes.
Pass over.
Like come.
If he satisfies the court on any of the procedural irregularity, then we'll stay. So please get instructions on the procedure, what is followed by you.
Yes.
So the petitioner will.
And inform them
Okay.
the matter is passed over, so let them not do anything till after.
Yes.
Let's see. For the petitioner, kindly pass over, my lords.
Pass over.
Please,
Get the
ma'am.
instruction till
Huh?
2:30, my lord.
Huh?
Get the instruction till 2:30, my lord.
2:30?
Please, please.
Yes.
Kindly pass over.
For 2:30 minutes, I have my personal inconvenience. I have a doctor appointment. May I request?
What is urgency?
My lords, the e-auction is going to take place.
My lords.
on Schedule 17th, my lords.
Tomorrow.
Tomorrow.
My lords, kindly put the
17th is day after tomorrow.
senior may not be here, my lords. Only.
But you have to look at his difficulty also.
Yes.
Yes,
Tomorrow.
tomorrow.
Because this is an auction called by the DRT, not by the bank. And NPA is in the year 2015. From 2015 till date, they have not even paid single rupee.
Please, my lords. Agriculture property.
You appear for the
I'm for
respondent.
respondent number 5, ma'am.
What is this?
So they have challenged, my lord, the action
You filed the
taken.
vacate stay or stay is there?
There was no, my lord. There is
No interim order.
No interim order is there.
This is matter on 11th of November, no representation on behalf of the petitioner. Then 16.
Serial number 16.
Please.
My Rajendra PM.
My lords, serial number 15, my lords. My lords, serial number 15, my lords. Mr. Medumpara will appear in this regard. I'm just bringing him, my lords. He has come just landed. I'm just bringing him, my lords. Kindly pass over, my lords. Serial number 15, my lords.
In serial number 15, I appear for respondent 1, my lord, for bank.
Pass over.
I for the petitioner, my
Much
lords.
over.
Yes, yes,
Pass
16.
Serial number
Pass over
16.
serial number 15, my lords.
Sir, pass over, sir. Serial number
Yes, my lord.
16.
Yes, my lord.
Lord, undertake to appear for the respondent bank. My lord, we found out it is not the first, it's a second sale, my lord. First sale, in fact, took place on 21/2/2022. This is the second sale, my lord.
So that's a 15 days.
That's why it's 15 days notice, my lord. And whatever amount they paid, my lord, in fact, they had made an OTS offer. So it is not appropriated. 8 lakhs that they paid is taken as upfront amount. But unfortunately, OTS cannot be considered because as per the policy, 2-3 times the property has to be put on sale. Only then the OTS can be even forwarded. So, my lord, it is a 15-day sale notice. They have received it. In fact, the paper publication has happened on the 28th of September. My lord, in respect of the postal receipt that they submitted, that they've received on 4/10. Actually, the sale notice was issued on 26th. And then the postal endorsement is that it was lying in the post office for 1 week before they could collect it. So, but paper publication has taken place within the 15 days period, my lord. So therefore, there is no statutory.
My lords, my only submission, my lords, now that they have received 8 lakhs also, my lords.
What is the outstanding amount?
My lord, as per the sale notice, is about 30 lakhs, my lord. At the time of taking physical possession, they made 8 lakhs payment, but specifically mentioned that it is for OTS, which is why we cannot appropriate it. We've kept it in an OLEN account. So therefore, we've not appropriated it. If they provide permission to appropriate, we can appropriate it. But OTS is not possible because as per policy, only first or second time the property is gone for sale. So the amount which they've paid, it has not gone towards the loan at all. So let the sale go on, my lord. Then let them.
Prepared to pay further amount, my lords. Somehow we are prepared to pay further amount also.
How much?
I'll pay another 8 lakhs, my lords, in 1 or 10 days, 1 week or 10 days time, my lords.
Lord, in fact, the sale is already
reduced to
started.
50% of the amount, my lords. Total payment will come to 15 lakhs.
What about the remaining 15 lakhs?
I will make my efforts to clear it off, my lords. Maybe another 3 months
It
or
has to
4
be
months.
assertive. When is that?
Maybe 3 months or 4 months, my lords, for the balance payment, my lords.
With interest, it is 30 lakhs.
Yes, ma'am.
Yes, ma'am. My lord, it's mentioned in the sale notice. A particular date will be given.
10.85% per annum compounded.
My lord, this
half-yearly,
30
my
lakhs is as on 31/8/2025. So this includes with further interest, cost and expenses is what is stated in the sale notice, my lord. Lord, sale is already underway, my lord. It's at.
What is the nature of the property?
House property.
House property, my lord. It's house property.
Where is it?
It's in Kolar only, my lord.
Mulbagal.
Possession is taken.
No,
Symbolic.
possession is not taken. Symbolic possession, yes, my lord. We've also obtained the CJM order. So when we went to execute it, they made a payment of 8 lakhs saying OTS, but we couldn't appropriate it. And so we were hoping that they would make some further payment. They did not, and so we were constrained to proceed further.
Then why don't let them within 2 days, let them pay an amount of rupees 10 lakhs.
Yes.
So that another for the remaining amount will grant another 1 month time.
Yes, ma'am.
It's a residential property.
Yes, ma'am.
2 days I can't arrange 10 lakhs, my lords. 2 days not possible. Little further time, my lords, at least
1 week maximum. Because this court is not at all inclined to
I
interfere
understand.
in this
I understand.
because it's a residential property and the amount is less.
Yes.
30 lakhs is the
Yes.
amount. That's why the court wants to show some indulgence in this. Please, I'll pass over.
Please.
Or not pass over, just get instructions from your client.
Please.
With regard to the amount, when and how he is
Please.
going.
Please.
I'll call immediately, tell the court officer will call the matter.
Please.
17.
Please, my lords, I appear for the petitioner, my lords. On the last date of hearing, the matter was heard and it was posted for dictating of orders, my lords.
Let's see what is it.
List the petition for dictating orders on 15/10/2025, my lords. 15/10/2025, that is today, my lords. It was for dictating
bench.
orders. Yes, my lords.
Then let it be posted to the other bench. Yesterday she showed, I thought it was before me. The list is smarter before the very same bench.
Interim order may kindly be extended.
Order earlier granted is extended.
List number 3.
Grateful, my lords.
Call the list.
List number 3. Serial number 1 adjourned. Serial number 2.
When is it adjourned? Serial number 1?
Morning.
No.
Oh, list number 2. 3 got it. Allah, list number 3 name right now.
It is not adjourned. Nobody has mentioned.
List number 3.
Yes, call the list.
List number 3, serial number 1.
Yes, Mr. Counsel.
Serial number 1, list number 3. Firoz Nazam.
I appeared for the petitioner, my lordship. Last hearing, I was not present, so it was posted for dismissal, my lordship.
Yes, argue.
My lordship, it's against the order of the trial court, my lordship. Kindly pass over, I'll make my submission, my lordship, because my colleague had come to the court with the file. I am in front of the online. Please, please.
Pass over. Next.
Oblige.
2.
Serial number 2.
2 is adjourned. 3.
Serial number 3.
Petition in this matter, my lord.
Serial number 3.
The appropriate steps has been taken in this matter and no arrears have been remaining in this. No arrear is remaining, my lords. All the,
It is about issuance of notice to R1 for the first time.
it is for hand summons, my lords. I have approached the pending branch.
Have you taken issue notice in addition to that, counsel for the petitioner is permitted to take out hand summons on the land counsel appearing for the response.
Yes, ma'am. My lords, I had approached the pending branch, but I couldn't avail that hand summons. I have approached twice.
Petitioner shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by November 4th.
Interim order, maybe.
If it is not filed, the stay granted by this court stands vacated.
Interim order, maybe.
Interim order earlier granted is extended till then. Yes, next.
Much obliged.
Serial number 4.
List after service of notice.
Serial
You
number 5.
served on 9/10/2020.
How?
By hand summons, my lordship.
This court has permitted you to take out
Yes,
hand
please.
summons. Have you filed a
As per
memo to
order.
that effect?
Yes, yes, my lordship. On 13/10/2025, we have filed in.
Memo?
Yes,
Where
please.
is that memo?
Serial number 4.
13/10.
It is submitted with the land council that he has already filed a memo, as per the order of the court, he has already served the hand summons. These three is directed to put up the same. This matter on third. Any interim order is there?
Please.
Interim order earlier granted is extended till then.
Till number
Next.
5, adjourn 6. Till number 6. Soya Gerale.
User.
Lordship, appearing for the petitioner.
Hmm.
The court fees paid, we'll produce the receipt. That is the office objection.
There is no office objection. It's coming up for preliminary hearing.
We were being, apologies, Your Lordship.
20673.
20673, yes, Your Lordship. Okay, I'll check, Your Lordship. Apologies. This is related to
The
maintenance.
respondent is hereby directed to pay interim maintenance of the tune of 10,000 per month until the modification or set aside the order. Petition is wife or husband? Husband.
Husband.
What is his income? You have the file?
He has no income, Your Lordship. He's
How
a,
it is dealt with by the court? Come to the order. The respondent is working in his brother's hotel on daily wages and is still paying the loan amount of rupees 15 lakhs taken by him. With these contentions, it is prayed to dismiss the petition.
Lordship, at page number 14, it is mentioned that he's not working about last 1 month. His
Why
account.
is not working?
Because he's a patient of schizophrenia, and recently, because of hypertension, he has lost his job, and his loan account has also become NPA of 15 lakh. And the wife left the matrimonial house herself. It is a childless marriage, and she is well educated. She can take care of herself.
Have you filed the medical records to show that he is suffering from schizophrenia?
Lordship, that I'll have to check.
Please file it. The necessary medical records will be produced before the court. This is matter on 12th of November.
Grateful, Your Lordship.
Till number 7.
Yes.
Amrutesh NP.
I appear for petition in this case. In this case, interim maintenance of 10,000 has been awarded, 10,000 per month, Your Honor.
You are for the husband.
Husband.
What is the salary of the husband?
Salary, he is working on a contractual basis for 179 days, Your Honor. So his salary was stated to be 37,000, Your Honor. 37,000, Your Honor.
Yeah.
So he's on page number 22 was specifically stated in the statement in para C that petitioner is working on a contractual basis for 179 days in a year, Your Honor. So he will not be getting much amount of 10,000 will be a burden for him. So it may be reduced to at least 50%. We are ready, Your Honor.
Land counsel for the petition submits that he's working on a contractual basis and his income is 37,000 and odd per month. 37,000 and you work, he's working for 179 days in a year and paying an amount of rupees 10,000. Children are there?
No children, Your Honor. Only about 4 months she was married, she has left the house of the petitioner, Your Honor.
10,000 to the wife is a burden to the husband. Considering the same, they shall bestow all further facilities. Same 50%. 50%. He shall pay an amount of rupees 5,000 per month, a fifth of every succeeding month, and the arrears also at 5,000 within 12 weeks. Notice to the respondent. In addition, the petitioner shall take out hand summons on the counsel appearing for the respondent, shall file a memo to that effect by 11th of November. If the memo is not filed, Even on that ground, the stay granted by this court stands vacated. Yes, next.
Entry matter.
I grant. Yes,
Number
nine.
8, Dilip Kumar Gowda.
Yes.
My lords, the impugned order is at Annexure G, my lords. The operative portion is at 95 page number. My lords, the trial court, operative portion is at page number 95, my lords. The trial court has granted 7,000 interim maintenance, my lords. My lords, the wife is also working. There's no children out of wedlock, my lords. She stayed with the husband.
What is your income?
My lords, my income is 51,000,
Our
whereas
income?
20,000. And I'm paying 42,500 monthly EMI.
For
For the
what?
my lords.
For what purpose?
My lords, I've taken 35 lakhs house loan.
When did you take?
My lords, in the year 2023, my lords.
When is the criminal miscellaneous fine in 25?
Please, my lords.
Let's see how the court has dealt with it. Where is the discussion about this 42,500?
My lords, my assets and liabilities at page number 52, my lords. At page number 51.
No.
In the order sheet.
An amount of rupees 3,000 is deducted.
My lords, at point number 23, my income is 51,500.
No, not that. Come to the order. 24. Paragraph number 24.
Please, my lords.
Read. Read that paragraph.
As could be seen from the pay slip produced by the respondent, that towards loan amount, an amount of 3,000 is deducted. My lord, this is the loan that I've acquired from the company, that is 5 lakhs rupees, my lords. Other than this, from HDFC Bank, I've availed 35 lakhs loan, my lords.
That your account should show.
My lords, I may be permitted to pass on the documents.
Absolutely, that 45,000 is nowhere forthcoming in the order.
My lords, I'm ready to deposit 50%, my lords.
There should be some reason
My
to
lords,
interfere with
she
the
did
order.
not stay with the husband even for a year, my lords. She did not even come to.
Those are all once they enter appearance, we will see. No, you have to make out when you are earning
51,500, my lords.
Court had granted 7,000.
She's also employed, my lords, and there's no children out of the wedlock, my lords. She's earning 20,000, my lords. She's
We'll see. Notice to the respondent.
But still, then interim order may be, my lords. The urgency is this, my lords. FLW has been issued to the
If
petition.
you don't pay, they'll issue. Notice to the respondent. Petition is permitted to take out hand summons on the counsel appearing for the respondent once a memo is filed is the matter. Case 9.
9, TG Malail.
Apologies, Your Lordship. In
My
serial
lords,
number 6, interim prayer, maybe please.
Yes, 9.
Great.
My lords, I appear for the petitioner on serial number 9, my lord. Kindly pass over, my lord.
Pass on. Yes, 10.
Serial number 10. Serial number
Petitioner, my
10.
lord. This writ petition, my lords, arises of the application, my lords, on I number 9, permission to file objections, my lords. The objections, my lords, is filed after a lapse of 3 years and 1
Let's
month.
see
my
where
lords.
is that. Where is the order?
My lords, the order, my lords, is at page number 58, my lords. Just one. For reasoning, my lords, whatsoever. There are 2 IAs filed, my lords. One, my lords, to file objections on the main. And then, my lords, IA number 10, my lords, is to recall PW1 for further cross-examination. If you were to see the observations, my lords, it's
What is this application?
IA number 9, my lords, to permission to file the objections on the main petition, which is filed after a lapse of 3 years and 1 month, my lords. IA number 10, my lords, is to cross-examine PW1. In fact, this matter, my lords, was posted for arguments. I've adduced evidence. I've been cross-examined. I've not been cross-examined. Cross-examination I've taken as
This order
nil.
is passed well.
My lords?
This order is passed well. What is the date of the order?
My lords, 7/12/2024, my lords.
What are you doing till now?
My lords, she was abroad, my lords. Now, after that, my lords, the matter was posted, my lords, for cross-examination.
Already this must have worked out.
My lords?
They filed their objections, everything must have gone now. Why should
My
we
my
interfere
lords,
with
she's
this
not
order?
been cross-examined even till date, my lords.
No.
My humble submission, my lord.
Just because there is no limitation for filing a writ petition under 227, that doesn't mean that we will entertain the petitions after 1 year.
My
Almost a
lords,
year.
my lords, she was abroad, my lords, because she's every hearing date, my lords. You have to peruse through the order sheet. She's been present before the court. She's been contesting. In fact, the matter, my lords, is gone.
Please place before the court the order sheet from
Yes, ma'am.
7/12/2024. What has happened?
My lords, 7?
From 7/12/2024
Yes, my
till
lords.
now, the order sheet of the court.
7/12/2024, my lords.
From the date of impugned order till now,
Yes,
what
ma'am.
has happened? Please place before the court the order sheet.
I will place it, my lords. I
Yes.
will place it, my lords. I will place it.
Yes.
In fact, my lords, there was another application, my lords, which was filed by respond number 2.
What is that number?
My lords, respond number 2, my lords, is an adulteress. So, my lords, an application was filed, my lords, seeking deletion of her name. The reason, my lords, it is procrastinated to all this while, my lords, because she files an application for deletion of her name, which, my lords, was rejected by the trial court. Again, my lords, they prefer, my lords, writ petition. Again, in the writ petition also, my lords, the writ petition was also rejected. So that is the delay, my lords, wherein anyways, my lords, I'll place the order sheet, my
After
lords.
1 year, we can't entertain that.
My lords,
petition.
my humble submission, my lords, is that, in fact, my lords, if you had to see the reasons, my lords, not even a single whisper, my lords, as to the reason.
Who stopped you from coming? After that order is passed, if the court acted upon it and somewhere, I mean, unnecessarily the court's time, we can't, you can't waste the court's time like that.
No, my lords, I'll anyways place the
Place it.
entire
Place
order
it.
sheet, my lords. Entire order sheet will be placed,
Yes,
my lords.
the entire
Take
order
date,
sheet
my lords.
from the date of the impugned order shall be placed before the court. This is matter on 11th of November.
Much appreciated.
Yes, what happened in 16?
Issue serial number 16.
What he says is his retirement benefits are not yet released, my lords.
His
retirement benefits are not yet released.
Retired from service.
He's retired from service. Lords. So therefore, my lords, my request is, my lords, he will pay 5 lakhs in 1 week, my lords. And for the remaining amount, 3 installments may be granted, my lords.
Running in a span of?
3 months, my lords. Each 1
3
month.
months is too much, my lord. 6 weeks. Let them, in fact, that amount 8 lakhs which is deposited, let them give.
Let them appropriate, my
If
lords. I
that
have
is
no
recorded,
objection.
that is recorded, then yes, my lord. Let that be recorded, my lord. We'll appropriate the 8 lakhs. And
it's like
around
this.
3 months is too much, my lord. 6 weeks, my lord. 3 months is too much, too long.
You
my
should
lord.
concentrate on all those borrowers of crores of rupees.
Yes,
Don't
my
it
lord,
is
but
just
then
30 lakhs.
my lord,
So,
what-
the
30
concentration,
house.
concentration should be
No,
less on
that is
these
true, my
people.
lord. But then this is a small branch, and so every NPA will actually reflect on their performance.
He's
my
a
lord. So-
retired employee. We'll just, no, these are all the cases where we need to consider, not the big cases. So now already 8 lakhs is paid, which will be
appropriated, my lord.
appropriated by the bank.
Yes, my lord.
Then, when are you going to pay this 5 lakhs?
My lords, immediately after Deepavali, my lords, 23rd, my lords.
23rd, you're going to pay 5 lakhs.
Please, my lords.
So you pay 6 lakhs, not 5 lakhs.
Please, my lords.
No, not 7. If it is, then it will be 15.
Please.
So 7 lakhs, so 15 lakhs. So for the remaining 15 lakhs, we'll grant them 3 months, every month to 5 lakhs.
Yes, madam.
Please.
And that is from 23rd of October. So 23rd November, 1 installment, 23rd December, 1 installment, and 23rd January, last installment.
Please.
Last installment includes
And
all
we'll
final
keep-
balance.
And
my
I'll
lord.
keep this writ petition pending, so that it'll be easy. It's like an interim order. If they don't comply with the order, anytime you can move the court to vacate the stay. If you
Lord.
want, I can dispose it off.
Yes, my lord, it can be disposed of, my lord. With that any one installment not paid, then the bank is at liberty to proceed in accordance with law.
The present writ petition is filed.
If it is 7 lakhs, may I request till 25th, my lords, another 2 more days.
Yes.
Please,
So other things also from 25th.
please.
The writ petition is filed with the following prayer. Extract the prayer. The petitioner is a borrower from the respondent bank. He has borrowed an amount of rupees. Where did
20
you
lakhs,
say?
my lords.
Huh?
20 lakhs. my lords. My lords will get that at the order of the tribunal at page 23.
Page 23.
Please. Para 3.
The petitioner, borrower, has borrowed an amount of rupees 25 lakhs.
20 lakhs.
20,
Applied for 25 lakhs, they granted only
approached the bank for agriculture cash credit loan of rupees 25 lakhs. After considering the proposal, the bank sanctioned agriculture cash credit loan of rupees 20 lakhs. And the borrower has agreed to pay the amount in 3 years, subject to annual review on or before December 2018, and agreed to repay the same with interest at 10.85% per annum. And the petitioner has mortgaged the house property. The borrower has failed to repay the loans, and the account has been classified as a non-performing asset, and a demand notice was issued on 2011-2021, and legal notice dated 1/12/2021, calling upon the borrower to pay the entire outstanding loan amount. As there is no response, they have issued they have filed the OA to report the dues. The tribunal has allowed the OA number 59 of 2023 filed by the bank, and the bank is permitted to recover from the defendants an amount of rupees 21 lakh, from the borrower an amount of rupees 21 lakh 97,024 by order dated. When is the order?
That's at page 22, my lords. That's
By order dated
2nd April 2024.
2nd April 2024. Pursuant to the same, the bank has obtained an order under section 14 for possession of the has obtained an order under section 14 on 9/7/2025. The court commissioner, by a notice dated 9/7/2025, called upon the petitioners to vacate the scheduled property. On 22/7/2025, the petitioner has paid a sum of rupees 8 lakhs for a one-time settlement.
As an upfront amount for
As
a
an
one-time
upfront
settlement
amount
request.
For the one-time settlement. Thereafter, the bank has issued the notice under Rule 8 of the rules. And the e-auction was scheduled on 15/10/2025. Next one. When counsel appearing for the petitioner submits that the bank has to issue a notice for a clear notice of 30 days before putting the properties to sale. According to him, in this case, that the bank in less than 30 days has issued the notification, has issued the notice, the sale notification, which is bad, as there is clear violation of the procedure contemplated on the Surface Act. The petitioner is constrained to approach this court. This court, it is submitted that he is a retired employee. In fact, he wanted to clear the dues and is waiting for his terminal benefits. Once he receives the same, he will be paying the amounts. Then counsel appearing for the bank submits that, in fact, that 8 lakh amount is paid as an upfront amount for the one-time settlement. for, as per the bank, as per the RBI guidelines, for a one-time settlement, they have to keep the property for auction on
At least 3 times, my lord, 3 to 4 times.
at least 3 to 4 times. In this case, it is second time.
Second sale.
In this case, it is a second sale. And as such, the amount was not, the amount of 8 lakhs that is paid is not appropriated by the bank. Further, it is submitted that it is not a first sale, but in fact, a second sale notification. As such, 15 days is contemplated under rule.
Lord, Rule 8, 9, yes, ma'am.
Rule
9.
9 of the
Security interest
case of Rule
enforcement.
8, it is 30 days.
First sale is 30 days.
30 days. And
After that, it's 15
in
days.
case of a second sale, it is 15 days. Then council submits that there is no procedural irregularity, and the writ petition that is filed is not maintainable before this court. Next paragraph. Having heard the counsels on either side, produce the material on record. In a matter of this nature, generally as a matter of course, this court do not interfere. However, considering the facts and circumstances of the case, where the borrower is a retired employee and the outstanding amount is 30 lakhs, and he has come forward to pay the amounts provided and he seeks for a reasonable time. In those circumstances, in his submissions on instructions, it is submitted that he'll be paying an amount of rupees 7 lakhs by 23rd of October. And
25th.
8 lakhs to be
October.
appropriate.
No, that one said in his submissions, I'm saying that by 7 lakhs he'll pay by 23rd of October, 5th of October, and if another 3 months time is given, every 5 months on instructions he submits. On instruction that on every month he'll be paying 5 lakhs, and within 3 months he will pay the entire amount. Now coming to the order, and considering the fact that they're ready to clear the entire amount within 3 installments, and also that it is a residential building. This court is exercising the jurisdiction in the facts and circumstances and passing the following order. Where is that the impugned order?
Annexure A, my lords, page 12, page 13.
Page 13. The order dated, the notice dated 23/9/2025 is set aside on the condition that A, petitioner shall pay an amount of rupees 7 lakhs by 25th of October. The amount B, the amount of 8 lakhs that is lying with the bank as an upfront amount for a one-time settlement, the bank is permitted to apportion the same. Number 3, by 25th of November, the petitioner shall pay 5 lakhs. 25th of December, 5 lakhs. 25th of January, 5 lakhs.
Lord, 25th of January, the entire amount, whatever charges is
That's
balance
what-
amount.
So by 25th of January, along with 5 lakhs and whatever or the other
Outstanding.
miscellaneous charges, amounts that are pending with regard to the sale notification and other, not required, any other miscellaneous amount shall be cleared. Next, number 3, if the petitioner fails to pay any of the installments as stipulated in above, the bank is at liberty to proceed with the auction.
Grateful.
Grateful.
Yes, next. Accordingly, the petition is disposed of.
Serial number 15, serial number 15,
Now, what is called is serial number 10.
10, okay, it's called now.
Yes. Next.
My lords, I appear for the petitioner, my lord. My lord, there is a petition seeking speedy disposal of the divorce petition filed by the petitioner.
Which court?
My lord, it is in Malur Court, my lord. My lords may come to Annexure D, my lord, page 73.
Kolar. Which year
Yes,
is
my
the
lord.
MC?
Yes, my lord, it's an MC petition, my lord.
Which year?
My lord, original is of the year 2020, my lord. Thereafter, this was transferred.
Please come. The present petition is filed, seeking the following prayer. Land Council submits that originally it is filed in the year 2020 and renumbered as MC number 68 of 2022 after it is transferred to Malur.
Please, my lord. My lord, a
After
kind
it is
submission, my lord. My lord,
Yes.
page number 73, my lord. We had earlier filed a writ petition, my lord.
Yes.
My lord, till date, the learned trial court is adjourning the matter on
Then
one
why
of the
did you
views.
file another petition? How many times the court will grant direction?
My lords, my lords, any specific date may be given to dispose of the matter, my
How
lord.
can it be? How many times the court will pass orders and how many times whenever there is no complaints you will come? This court has passed an order on 5th of June 2024. And now the another writ petition strike off all that. This court on 5th June 2024 has passed an order directing the family court to dispose of the MC expeditiously without granting unnecessary adjournment. Now, even after more than a year, it is the grievance of the petitioner that the pending MC is not disposed of. What is why this matter? Why even after 1 year this matter is not disposed of? The registrar judicial shall call for a report from the concerned judge and list this matter on 10th of November, not 10th, on 12th of November.
Grateful, ma'am.
Yes.
For petitioner, my lord, petitioner's writ petition, my lord, challenging the order passed by the family court, granting 50,000 per month.
What is your salary?
My lord, my salary was 1,80,000. Since 1.5 years, I am not in job, my lord. I have quit the job, my lord, because of the force.
When is the impugned order?
Impugned order is 1925. That is.
Then did you not bring all these facts to the notice of the court?
It was stated.
Let's see the order. Come to the order.
Page number 105, my lord. 105, Annexure G. Order starts at 105, my lord.
Let's read. Very short order.
Very short order.
Read.
The petitioner, the wife has filed a so-and-so application seeking maintenance from 1 lakh per month and litigation is not 2 lakhs. The petitioner in support of their IA has shown to reiterating the stand seeking maintenance, content like litigation. The respondent has appeared before the court and contested the case by filing his detailed objection statement. The respondent side have adopted their side objection as objection to IA. Both the petitioner and the respondent have filed their side of affidavit disclosure of assets and liabilities. The petitioner wife has filed the main petition seeking resolution of her marriage by decree of divorce based on the cruelty. The petitioner has contended on so and so the marriage of herself and petitioner was solemnized at Davangere. The petitioner has contended the marriage she started her matrimonial life here in Bangalore at the abode of the respondent. The petitioner has contended since inception their marriage, both the family members continuously harassed her both physically and mentally. The petition side have contended the respondent and his family members did not use to respect both the petitioner and her parents. The petitioner has contended out of their marriage they have blessed with one daughter by name Snigdha, born in the year 2003. The petitioner side have contended their daughter is pursuing her master in UK. The
20,000.
master's degree.
20,000.
My lord.
20,000.
My lord, his income, present income, he is aged 58. He is having one property. As a rent, he is getting 25,000 as a rent every month. Except that his job was not pensionable, my lord.
Why he was not working?
My lord, because of he is suffering from, my lord, higher diabetes. Kindly see now para number 6 of the petition, my lord.
Having diabetes is not a ground.
Suffered eye problem, diabetes, pleural effusion also. That is also I have stated. I have produced all the documents before the trial. Trial court has not considered all these aspects. And I have filed, my lord, brief synopsis of the case. In the last 2 years, 37 lakhs 37
When
lakhs.
counsel for the petitioner submits to the court without any basis of granted maintenance of an amount of rupees 50,000. He submitted that from last 1.5 years he is not working. And this aspect was also stated before the court and the same was not considered. It is submitted that now he is having a property, one property where from he is getting an income of
25,000 per month.
As rent, and apart from that, he has no other income. And the court, without considering all this, has granted an amount of rupees 50,000. Considering submission to petition, they should stay of all for the proceedings. On the condition that he shall pay
12,500.
an amount of
12,500. Because my daughter is now getting.
he is ready to pay an amount of rupees 12,500 per month. 12,500 per month, and the arrears also at 12,500.
Arrears beda.
Shall be paid
No, my lord.
within 12 weeks.
My lord, because in the last 2 years, my lord, my wife has
12,500. That's the order.
from now onwards, my lord, because in the last 2 years, I have paid 37 lakhs, my lord. 37 lakhs. That I have stated in my synopsis. That is not considered by the trial court. That's why, my lord. From today onwards, my lord.
Yes. Next, what is the respondent and summons? Give a date. Same like in the other case. November 13th. Yes, next. Yes.
I appear for respondent husband, my lords, as against interim order dated 12/8/2025 passed by the family court Mangalore.
How much is granted?
15,000, my lord.
15,000.
15,000.
What
Fact
is your
remains-
salary?
Sir,
What is your salary?
I have no income. Fact remains, I was an agriculturist. I had a plantation, rubber plantation of.
Just with the matter.
Yes, my lord.
Have you filed a statement of assets and liability?
Yes, my lord. I produced before this.
Please come to the order, reasoning part.
Next year, my lord. Reverend, page 26.
Read para 12.
It's their contention. It's the case on hand. Both the parties have filed affidavit of assets and liabilities along with some documents, compliance of the direction given on the High Court of Karnataka, High Court, Apex Road, in Rajinishwar so and so. On the perusal of the affidavit, the assets and liabilities of petitioner is very clear that she has shown her general monthly expenses 15,000 per month and education fees 25,000 per month. Further, she has also shown the school fee of so and so, tuition fee of so and so. She filed another memo giving the particulars of monthly expenses. She is getting a rental of 8,000 per month, though she has shown the income of the respondent 2 lakh per month, and from his reconnect business and rubber plantation, she did not produce any document to that effect. On the other hand, the affidavit asset liabilities would show that the monthly expense of the respondent 8,500, and he has shown the dependent as his mother and daughter only having their expense of 4,000 per month. He has narrated that the present he is having no income for the further conditions since they have become old, and he has no income for the next 7 years. He is getting income of, my lords.
50%.
Should it be 5,000, my lords? Because I produced, may kindly refer to the last wound certificate. He is unable to work. He has met with the accident, my lord. I produced wound certificate also.
What about all this at paragraph number 13?
13 impugn orders.
You have
I do have 5 lakhs. I do have 5 lakhs. What remains is my rubber plantation is being cut because it's more than 30 years.
You have a daughter to take care of.
I
Who
do
will take
consider
care
my
of the
lord.
daughter?
I would pay 5,000 per month, my lord.
What about the wife? Wife and
No,
daughter?
I had income, my lord. I had income. I constructed a house for her. She is in the house. She is getting the rent. Wife.
How
When
much rent she is getting?
she is, according to me, she is getting 25 for a month, 10,000 rentals, and she is giving the tuition also. She is getting 15,000 from my profit. And I met with an accident in 2023, my lord. Thereafter, I have no income, and it has also been cut. I get only 6,30,000 towards the deposit which I am getting, and the trees has to be cut after 1 year from today, and then after 7 years, we will have no income. Now, except a sum of rupees 5,20,000 which I have in my hand, out of which a sum of 2 lakh was paid by the motor vehicle tribunal, whereas compensation towards the motor vehicle accident, and another 3 lakhs I will get in another 2 years. That is the only amount I have. I have to fetch my life for the another 9 years from out of it, my lords. And I produce wound certificate also.
3,000 per month. And he has no income. He's an agriculturist. And apart from that, he has suffered an injury in a motor vehicle accident and is not in a position to work. And all these aspects were not considered by the court. Say 5,000, arrears also at 5,000, 12 weeks. Memo, hand summons, same order. Yes, next.
Much obliged.
No representation. This is matter on 18th of November.
Here for the petitioner, my lord. There's a stay in the Supreme Court, my lord. The petitioner, the respondent has sought for a transfer from Karnataka to Odisha. There's a stay granted by the Supreme Court.
Stay of these proceedings.
Stay of the MC proceedings and writ petition 19954 of 22, my lord. On the last date of hearing, I had given the transfer petition numbers. Your lordship had noted the same, my lord.
It is submitted that the matter is pending for the Honorable Appellate Court with regard to the transfer petition moved by the wife.
Please, ma'am.
Right, this matter on 2nd of December. Yes, 16.
But I appear for the respondent in this case, my lord. Lord, as per the interim arrangement made by this honorable court, the visitation with the boy is going on, my lord. The boy is happy and is adjusting. So far as girl is concerned, my lord, as your lordship passed an order, a report has to be secured by the psychologist.
What is the name of the parties? Where is the advocate?
My lord, I am for the respondent, my lord.
No,
I am for
no
the respondent.
I understand that, Mr. Counsel. There is
Yes.
no representation on behalf of the petitioner. Then it counts for the respondent is present. This is matter for dismissal on 4th of November.
My lord, interim arrangement may continue, my lord.
Interim arrangement shall continue.
Please.
17, my lord, the wife is also filed one more petition. It may come complete.
List along with that. List along with that on 29th of October.
Please.
Yes.
For petitioner, my lords. The petition.
Appearing for respondent, my lord.
The orders has been complied by both the parties, my lords.
We will suppose to talk about here.
Yes, my lord. This honorable court directed me to pay 50,000 to the education of the child.
Subject to condition with the custody of child, my lords. With subject to condition, this honorable court has ordered.
Holidays for 10 days, my lord.
First of all, let's see what's the order impugned.
Please,
Let's see.
please.
Where is the order impugned?
My lords, it's a vacation bench, my lords, on 39 to 2020.
That's already granted, my lord.
It is over.
Yes, my lords.
over.
Where is that? That's why I asked you. Where is the impugned order?
No, my lords, the respondent has filed a JNWC before.
Application is filed. The respondent number 1 is directed to hand over the custody of minor son to petitioner at 10 a.m. on 2/10/2025 to till 7 p.m. The director to take the custody of the child. So and so. No, it worked out.
Yes, my lord.
Please come.
The only
petition
submission
is
is, my
filed.
lords, the respondent has never let the petitioner to speak on the phone call, my lords, during the custody of child.
This court, the petition is filed, agreed with the orders passed on I number 6 in JNWC number 10 of 2025.
50,000
Dated
transactions.
23rd of that we are not concerned. 23rd of September 2025, whereby the court is directed to hand over the custody of the minor son at 10 a.m. on 2/10/2025 to 12/10/2025 till 7 p.m. And the petition is the mother therein, father. Who is
There-
the petitioner there?
here there it is the father.
There is directed to take the custody of the child at 10 a.m. on 2/10/2025 and hand over the child to the mother at 7 p.m. on 12/10/2025. The agreed with when the order is questioned before this court, a coordinate bench of this court has passed an order This court has passed an order that the father shall forthwith transfer a sum of rupees 50,000 to the bank account of the mother towards education expenses of the minor son. The payment of the amount is without prejudice to the rights and contentions of the parties in all matters. The mother shall hand over the custody of the minor son to the father on 2/10/2025 10 a.m. and the father shall return the custody of the minor son on 10/10/2025 at 7 p.m. And the respondent father will not be entitled for visitation rights on 11/10/2025 and 12/10/2025. Both the parties shall not in any manner prejudice the mind of the minor son with regard to the other parent during the time when the child is in their custody. And counsel appearing for the respondent father submits that he has already transferred an amount of rupees 50,000. And counsel appearing for the mother submits that during the visitation, when the father was exercising the visitation, mother was not permitted to have a conversation with the son, which is denied by the learned counsel appearing for the respondent, considering the fact that already the order that is passed by the family court is modified this court and the parties have exercised the visitation rights. This court do not want to go into any other merits of any other submissions that are made. Accordingly, the writ petition is disposed of. Yes, next.
My lords, I appear for the petition in this matter, my lord.
What has happened to this?
This is still pending before the Honorable Supreme Court, my lord, this matter.
When it has come up last?
I think.
Not before this court, before the Supreme Court.
I'm not able to.
No, you should have
6
a tax,
months,
but
almost.
when you're submitting before the court, at least you should say when the matter has come up, what is the order, when is it live, when is it going to be listed next. You also don't have the information.
Please.
This is matter tomorrow. By the time both the counsel shall place before the court when the matter was listed before the Honorable Apex Court on the last occasion.
My lord, by Passover, I will submit it.
Yes, Passover. It's 20.
Appear for the petitioner, Lord.
I appear for the respondent in this.
My Lord, may kindly recollect, this is a case where the father, my Lord, had said.
Lord, I filed my statement of objections, an affidavit statement of objections. Request your Lordship to kindly turn to.
No, according to your client?
According to me.
Has he paid the money or not?
Yes, my Lord, he has paid the entire sum.
Not the money. The last installment, not the last amount, the fees, whether it is paid by
Lord,
you
her
or
fees, may I submit? Her fees, even as per the affidavit filed by the petitioner here, is 20 lakhs per annum. Her fee at Leeds University is 20 lakhs per annum. Her living expenses is about 6.7 lakh rupees per annum. So totally her living expenses and everything is about 26.75 lakhs. We have paid much more than 3 times that, and more than 60 lakhs has been paid towards her fees. That I have pointed out in my statement of objections. I request your Lordship to kindly.
Arun Govindraj, have you gone through the statement?
I have gone through, Lord. I have also placed an affidavit on the last occasion where the university wrote to both the parents saying if the fee is not paid, she will not be given a degree certificate. That was the last installment of the fee to be paid.
No, he has come up, the respondent has come up with in a different angle.
I've seen that.
This is the fees, I have paid it. No, what is his response to that communication from the college? Are you paying it to the college? Are you paying it to the mother?
It is paid to the college, my Lord.
Then what do you say about that communication?
My Lord, these sums of money have been paid to my daughter because except for the first fee of paid on 26th of August 2022, that was paid to the college. All other sums of money have been paid to my daughter. And unless that fee has been diverted to the petitioner here and now, she is retaining that money in Leeds. There was no reason whatsoever for us to pay any sum of money towards her education. It's not that we have to continuously pay money which is in excess of what is required by the university. We have in fact.
Please respond. So you file your affidavit or your response to that, whatever he has stated.
Very well, my lord. I will do that.
Then counsel to the respondent submits that the respondent has paid, has borne the entire educational expenses of the respondent, and he has filed an affidavit in that regard. Then counsel for the respondent submits that he'll come up with instructions. Then also the petitioner submits that he'll come up with instructions, and also will file an affidavit in response to the same. Yes. When do you want?
Within 10 days time, I will be able to get all the details. my lord.
This is matter on 4th of November. Yes, next.
List number 3. Hearing on interlocutor application, serial number 1, Mahendra G for petitioner, Sarwan G for respondent.
I'm for the respondent. my lord. They have not furnished a copy of the petition and documents.
You are for the respondent.
Yes, I'm for respondent.
This is matter for dismissal. No representation on behalf of the petitioner on 8th of October. Yes, next. I mean, November. Not 8th, 10th of November. Yes.
Serial number 2 for admission matter. Serial number 2, Lakshmikant K.
I have for the respondent, my lord. For the petitioner, my lord. We have
List number 4.
List number 4, sir.
Arrears, we have paid all the arrears, my lord.
No, 2 months arrear is balance.
They're not on the arrears. Please argue the main matter. We'll hear the matter.
Kindly seek short accommodation.
I think this is how on the last occasion also you have asked for. When counsel for the respondent submits that the arrears are cleared till July 2025. And
Thereafter,
the
1 month paid, my lord.
The month of August 2025 is pending. This is matter on 1510. If the petitioner fails to pay the arrears, the stay granted by this court shall stand vacated. According to you have paid.
For the month of August, I have
August paid, my lord. September, October, they are required to pay.
For that again in
And,
another order is required.
No, my lord. I will pay, my lord.
Earlier, you used to pay the execution
Matter
expenses of the daughter, my lord.
On 27th of October, by the time, if the amounts as on today, outstanding as on today, as on today are not paid, the stay stands vacated, and the matter will also be dismissed on that ground.
Much.
Number 3, Halima Amin.
The petition, my lord. I have sought for enhancement of maintenance awarded under section 125 CRPC, my lord.
How much is the amount grant?
9,000 is awarded, my lord.
9,000.
Yes.
Husband has also questioned it.
Yes.
How's-
He has sought for.
What is the income of the husband?
He is running a medical store, my lord, and he is having income more than 1 lakh per month, and he is having his own
What
house.
is the evidence on record with regard to the income of the husband? Have both of you have filed your statement of assets and liabilities before the court? It's a matter of 2022. Have you filed your statement of assets and liabilities?
Yes, my lord.
Before
I
the
have no
family
any
court?
income. I have no any income, no any job, my lord. I have filed.
Have you filed?
Yes, yes.
Counsel for the respondent. Have you filed?
My lord, I had filed my objections.
No.
Not objections, sir. Statement of assets and liabilities before the trial court.
Declaration I had filed, my lord. Declaration by way of affidavit I had filed.
Submission. What he has done is he has transferred the house in his name to his sister's name, Lord, after this episode.
That's a property.
Yes.
We are talking about the income.
Yes. And then that he has showed that he has no income. He has no any.
So on what basis now the court has to enhance it?
No, the respondent, the petitioner here in this case has no any income. She is suffering from diseases like she's having a attack of this migraine frequently, and then psychological disorders also. She is not employed at all. She is staying with her parents. Father is sick and only brother is taking care. He is also married. She's not in a position to search for any.
Can't help it. Unless and until there is evidence on record with regard to his income. What is that? Already court has granted 9,000 without any basis. First of all, enhancing it will not arise without any material.
Well, he has got there is a case against them under section 490 and allied offences. All that he has got stayed and he is not attending the case in spite of proceedings to be continued against him in the trial court. His matter is not stayed. For rest of them it is stayed, but it's not being done now because of the stay pending against others. That is one aspect. And then this lady is not able to manage with this 9,000 rupees per month.
That's what, if you want the court to enhance it, you should place some material on record.
But she is not at all having any income. 9,000
His
is per
income,
month.
not your income. About his income.
See, he himself has placed. It is a medical store. How can he say that he is having only 30,000 in medical store? He is having a medical store in a prominent area.
Have you filed your bank statements for the last 3 years from the date of this application?
Malad, except the declaration of the affidavit, Malad, I have no other material.
Then I'll set aside this order. Both of you file your statement of assets and liabilities as per the judgment.
Yes.
And let the trial court decide it. And pending consideration.
When your lordship referred it for mediation, he did not.
Yes. What is the interim order in your case?
There is no interim order, Malad.
Is he paying that 9,000?
No, there is arrears, my lord. He himself is admitted. Yes. There is arrears.
Please come.
He says, come what
Agreed
may,
with
I will
orders
not
passed
pay,
in criminal
says.
miscellaneous number 213 of 2022, dated 19th October 2024, whereby the court had granted maintenance of an amount of rupees 9,000. Both the wife and husband are before this court. The wife's petition is RPFC number 259 of 2025, and the husband's petition is RPFC number 256 of 2024. IA order, IA number 1 of 25, is filed to condone the delay of 234 days in filing. For the reasons stated, the delay is condoned.
Malad, one submit. Malad, I have not entered appearance. In fact, I informed him, but he has not turned up, Malad.
For what?
I have not filed the wakalat in the.
In 259 of
259 of 25, Malad. Malad, I informed as per the Malad last time the matter.
That I will record. Anyhow, you are contesting. He has filed a petition.
He has filed a petition.
Then the wife had filed the petition under section 125 CRPC, seeking maintenance of an amount of rupees 50,000 from the husband. It is a case of the marriage was solemnized on 35/2021.
One submission in the middle, Lord. OS filed for a divorce by him is dismissed.
That's not relevant at the time of marriage. It is stated that the petitioner has the husband has taken her to the parents' house and left there, and thereafter he has not come back and filed OS number 18 of 2022 seeking divorce. It is stated that the husband is running a medical shop in the name of Star Medicals and is earning rupees 1 lakh per month. It is a case of the husband that his monthly turnover of the business is 30,000, and out of which he is getting 20% profit, which comes to rupees 7 to 8,000, and out of which he has to pay rents of rupees 7 to 8,000 and electricity bill of rupees 3,700, and remains only rupees 4,300. The husband is not getting any such income to pay maintenance to the wife, and is not having any mobile or immobile properties. The father of the husband is reading loud life out of his pension. While leaving the house, she has taken all the gold ornaments. She is educated and she is in a position to maintain herself. The
She is
court
ready to
had
go and
granted
stay,
maintenance
but
of
she-
9,000, and while granting the maintenance, the court has observed that the respondent in his objection statement as well as evidence admits that he is running a medical shop but denied his income. During the course of cross-examination of PW1 on behalf of the respondent, tried to contend that the wife is working in AINN Square Water Supply Company and she is getting salary of rupees 15,000 per month. The same was denied by the wife. Further, the husband in his affidavit of assets and liabilities kept the column of occupation and income of the petitioner as blank. Sorry, income of the wife as blank. Further, in the cross-examination, he admits that the car belongs to him and also admits that B registered the car as per Exhibit P4 and also is owning a two-wheeler. If the husband has no sufficient income, it would not be possible for him to maintain a car as well as two-wheeler. In the cross-examination, he admits that his father is a retired ASI and is getting pension of rupees 16,000 and odd per month. And no material is placed. And it is the case of the wife that he is getting 40,000 per month as pension and no material is placed. Considering all these aspects, the court has granted maintenance of 9,000 and also litigation expenses of 5,000. Then counsel appearing for the wife submits that when he is earning 1 lakh and granting maintenance of an amount of rupees 9,000 is the lower side. The wife is suffering with certain ailments and she requires money. In fact, during the pendency of the petition, he has transferred the property in the name of the sister, which shows the intention of the husband not to pay the maintenance to the wife. Further, it is submitted that the husband is running a medical shop on the main road, and court has also considered that he is having a two-wheeler and a four-wheeler, and only for the purpose of not paying the maintenance. He's come out saying that he's getting a meager amount. It is further submitted that, as per the judgment of the apex court in Rajesh vs. Sneha, all the documents were not filed with the husband. It is submitted that, considering the income of 1 lakh, the court may grant the reasonable amount of maintenance to the wife. Next paragraph. Learned counsel appearing for the respondent, not respondent, the learned counsel appearing for the husband submits that the learned counsel appearing for the husband submits that though he is not having his income is as it is stated that his monthly turnover itself is 22. 30,000. 22 is 30,000, and he's getting 20% commission on that, on the sale. But the court had granted 9,000, which is on the higher side. It is submitted that the amount of maintenance that is granted needs to be reduced. Next paragraph. Having other counsels on either side, there is a material non-record. In the RPFC that is filed by the wife, the husband has not filed his wakalat, but however, He has already filed an RPFC 256 of 2024. He is represented by an advocate in that view of the matter. This court feels that even though in this matter there is the order, both the RPFCs are filed, including the same order, and already the husband is represented, and non-filing of the wakalas at the 3.1 has no consequences, as is heard in that RPFC 259 is no consequences, as is already heard in RPFC number 256 arising out of the same impugned order. Next part. When the
Yes,
when
intimate.
the honorable apex court
Intimated
for
about this
Rajneesh
one to
versus
ಹೇಳಿ
Neha,
ಅದ್ ಬರೀಲಿಲ್ಲ.
When I duly intimated him.
it's okay. In when the honorable apex court in Rajneesh versus Neha has issued the guidelines, like what are all the documents that have to be filed while along with the statement of assets and liabilities. Conveniently, the husband has not filed any of the documents before the court. Even for this court also, to enhance the compensation, there is no material. No material. In those circumstances, this court deems it appropriate to set aside the order impugned and remand the matter back to the trial court for fresh consideration. Next paragraph. Accordingly, this court is passing the following order. The order dated so and so is set aside, and the matter is remanded back to the court for fresh consideration. Within 15 days from the date of receipt of the copy of the order, both the parties shall file their respective statement of assets and liabilities as per the judgment of the apex court in Rajneesh versus Neha. Thereafter, the court shall consider the same and pass appropriate orders within 4 months from the date of filing of the statement of assets and liabilities. Next, till the said application is decided, the petitioner shall continue to pay an amount of rupees 9,000 as maintenance if there are any arrears in the petition. The respondent, the husband has not paid the amount as per the order till now. The wife is at liberty to file the execution petition.
A date could be fixed, ma'am.
Huh?
A date, so that they could appear before the trial court.
After 15 days. That is from the date of receipt of the copy of the order.
Great.
Yes. That is already told. Yes, next. Yes, next.
Serial number 4 again, serial number 5.
Hello, I'm the
Serial number 5.
petitioner, my lord.
Petitioner. Rajesh Gowda.
Yes.
My lord, the marriage is not in dispute. The marriage is occurred on 3/5/2020.
What is the amount?
My lord, the trial court has been ordered 20,000 out of 50,000 they sought. She had been earning as on the date of the cross examination. She has been earning on 30/11/2024. She had been cross examined. She categorically admitted 1 month ago she left the job. She filed a petition on 7/8/2023. Well, prior that, my lord, we filed a divorce petition on 9/8/2021. The both parties has been reunited, and we withdrawn the MC petition, divorce petition, and she rejoined me. And thereafterwards, she went. The maintenance petition, she has not been withdrawn. The same has been continued, and she filed a 498 case against me and my parents, which has been stayed by this honorable court, this honorable court, my lord. And the trial court has been observed, my lord, in page number 43, para 37, my lord. She had been working.
What is your income?
My lord, according to me, I am getting 60,000. But no one has placed any document. The wife or husband has not placed any document. The trial court has to come to conclusion in para number 35. The husband is working and is getting 1,20,000. But based on the complaint, she sent a letter to my company. I lost the job, and I am staying with the parents in Seen Hospital. That is the Kolar district. Now I am jobless, my lord. I am not working anywhere. However, I am ready to pay, and I also reunited. And 12/7/2024 reunion with her, and again she left me. My lord, she categorically admitted.
Without any basis, considering the sufficient, same 10,000 for 5th of every succeeding month, and the arrears also the same. Yes, next. All the passwords wherever.
My lord, stay, my lord.
Stay.
Great.
Pass over matters, list number 2, serial number 1.
For in this case, Lord, sought for a writ of mandamus, directing the bank.
List 2, serial number 1.
List number 2.
CH-20 is
Lord,
Non-comprehensive office objection. IA 1 of 25 for posting, IA 2 of 25 for early hearing, IA 3 of 25 for posting. What is this? You're filing IS for posting?
for posting, my lord. Because the previous bench, my lord, was entertaining the matters only if there is a IFO posting in the
Where
pending
is this
matters.
counsel, Vignesh Shetty?
My lord, Vignesh Shetty,
You represent?
Vignesh Shetty, colleague, Vignesh Shetty's colleague,
Ask him to come afternoon.
2:30.
Cell number 2, Ravin Kumar.
My lord, I am
Nirvani.
appealing for the respondent company, my lord. In this matter, 3.4 crores is the outstanding. And tomorrow is
First
the,
of all, non-compliance of IA advocate and so. What are the office objections why you are not complied with?
I have complied the office objections minutes. I have complied the office objections minutes.
You have complied or you will comply?
I have complied minutes.
That's called, it says non-compliance of office objections.
That was with regard to payment of court fees minutes. I have
It's
paid.
on 14,
Court fees minutes.
Look at it. When is this? It's on, it
17,
appears on 14th.
17/9/25 I have paid the court fees minutes.
What is question?
I have filed the IA number 3 of 25 minutes to stay the auction tomorrow. That is
Why
scheduled.
should we stay the auction?
Due amount is minutes for the period of 6 months. EMI have not paid minutes. If a short period time is given minutes, I'll regularize the loan amount, loan account minutes. It's of 20.
Why should we interfere? That's what I'm asking first.
Notice was not served minutes. My ground minutes. 13 to 13/4 notices were not served to me minutes.
How the 13 to notices?
my lord, it has been served. I'll produce the acknowledgements, my lord. My
Where
lord,
is it?
My lord, I'll produce it, my lord.
When you're taking, when they're, you must have seen their grounds, have they served the copies on you?
Please, minutes.
Then you should get instructions by this
It was
time.
already listed minutes in the last day.
Lord, last date of hearing, it is listed. The copy of the
A
petition.
learned standing counsel with the respondent is permitted to enter appearance with the respondent submission that the sale scheduled today could not complete because no bids were received.
Please, minutes.
Shall ensure that the copies of the petition, no, she has served the copies. Their main ground is there is a procedural irregularity. Then you should have got instructions by this time.
Problem is, my lord, my petition copy got misplaced. That is my mistake, my lord. That is the reason I'm submitting. If
No,
they provide
please
me,
take it, get instructions from the bank. If, at what time is the sale?
my lord,
Tomorrow, minutes.
Tomorrow, we'll take it up at 2:30. Get instructions from the bank.
Please, my lord.
Yes, next.
Apply.
Cell number. Password. Please. Tomorrow.
Password, not tomorrow.
Password, na?
This is password. Yes. Yes, next.
Cell number 3 and cell number 6.
With the petition.
Password cell number 6.
Pay for a short accommodation.
Pick one.
So the matter is listed for preliminary hearing. The counsel is not present, my lord. So he told me to take a short adjournment.
Short accommodation is not possible. This is matter on 29th. Yes. Yes, next.
Cell number 10. Cell number 10. Gopal KB.
Call it up. Pass again.
Password, na?
Yes.
Yes.
Cell number 11.
No, 10.
10. Cell number 10.
That's,
What is question?
this, issue the possession notice already issued, my lord. That's why I'm filing this. I'm suffering from the COVID and all. My
What is the amount due?
amount due is 31 lakhs and that.
What is the property? Mortgage.
Property, house property. My grandparents' house property. They are residing in that house. I'm suffering.
Then when are you going to pay?
8 weeks and 8 weeks. 8 weeks and 10.
There is entire amount.
Tender amount is 31 lakhs and and interest.
Karnataka Bank one advocate was appearing in the morning also, she was here.
No.
Who is she? Morning one advocate appeared, lady advocate. Karnataka Bank. Call her, you have the number, find out. Informer, we'll see afternoon. When is the auction?
Action date is not, position notice was issued, my lords.
Oh, we'll ask her to come. This is matter tomorrow. What's her name?
Divya Purandar.
Police print her name. You can serve the papers on her.
Yes.
Yes.
Cell number 11.
Lordship, I'm challenging the section 14 notice order, your lordship. There is a peculiar circumstances in this matter, your lordship. Petitioner's husband had availed the loan, your lordship, for construction, and petitioner was the co-borrower, and there was an insurance coverage for this loan, and petitioner's husband demised in last year June, your lordship. And since there was an insurance coverage, we approached the bank to cover the insurance, but they have outrightly denied it. So I went for a consumer court, your lordship. I had filed the consumer case on 6/3/2025. And surreptitiously, your lordship, when they are filing the version, that time they tell me that they have issued a 13-2 notice. There is no documents to prove that there is a service of 13-2 notice. And thereafter, they even tell that there is a
respondent.
Respondent is a home finance bank, your lordship. It's a NBFC.
Take out handsomens.
Your lordship, till the time some stay may be granted, some protection.
Not grant any stay without hearing the other side.
Some protection, your lordship.
This is matter, immediate, the petition is permitted to take out hand summons on the respondent, and once a memo is filed, list the matter. Yes.
Cell number 13. GB Nangesh Gowda. Cell number 15.
May I please your ladyship, in Supreme Court, it is, the petition is on the left side. I was told that here it is on the right side. I will go to the other side.
Yes. Where is the respondent? I think they are, because it is passed over, they must be, they'll come in at 2:30, I think.
2:30, and ladyship, I'll be at 2:30. I have a matter at 1:45 at Kerala High Court. Maybe that I may be 5-10 minutes, your ladyship may have to
The
accommodate.
other passovers are there.
Yeah.
Yes. Next.
List number 3.
Yes.
Cell number 1. List number 3.
No, he said he'll come physically. I will call it after 2:30. Yes. Yes.
My lordship, serial number 2, 1.
You said you will come to the court in the afternoon.
No, my lordship, I'll argue it. I've already got it by WhatsApp, my lordship. Just 2 minutes, my lordship.
Then you have the file?
Yeah, I've got it by WhatsApp, my lordship. I can just, it's an
You're
application.
ready to argue?
Yeah, my lordship. I'll argue.
Yes, argue.
My lordship, it's against an application filed by the respondent for visitation rights. On that so-called date, the case was sent to mediation in the previous hearing. It came for hearing, page number 20, my lordship. And immediately, without our filing the objection, an order has been done that on the first and third Saturday, we have to give visitation rights. And third and fourth Saturday, he has to speak with the father. My lordship, there is a separation from almost like 9 years, my lordship. After the birth of the child, they have been separated. I don't deny that I'll not show the child because she has a blood clot in her brain. So at least monthly once.
From the capital dismissal, notice to the respondent.
Obliged.
Petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect.
Cell number 9.
Obliged.
Cell number 9. CG Malail.
Yes, afternoon.
Cell
Next.
number 19. 19. That is
Yes, I appear for the petitioner. The matter was listed in the month of January on 27th of Jan this year, 2025. I'm filing a memo. The matter was supposed to be listed after 4 weeks. from the date of.
Interim order is till when?
Yes, my lord.
Interim order is only for
Till
4
further.
weeks.
No, my lord. 27/1/2025, the matter was listed for this one, to file their affidavit or something. And for this, the matter was supposed to be listed after 4 weeks, which so far the matter is not listed.
I'm saying here.
Is not come up.
What is this? The stay is granted till when?
Yes, it is extended, my lord.
When?
As on the next date of hearing. So we don't know when the next date of hearing is going to be listed.
No, that's not the answer.
I'm
Well,
filing
they
this
have to
memo.
extend it till the next date, they said. Take that, take
I'll
take that.
The interim stay of operation and implementation of directions given in paragraph order dated 23.
Till the next date of hearing.
Past till
So
the
that
next
it
date
has
of
never
hearing.
come up after that.
Yes, my lord.
Huh?
It came up in the month of January also, my lord. But the interim order is extended. But
Where is
after that, it is
copy?
not listed.
Where is that copy?
That's what I have filed now, memo. The last date.
That's what I'm saying. After 27/1/2025, it is not listed.
No, my lord. It's not listed. 4 weeks it was supposed to be listed, but it is not come up still.
Yes, please.
I filed the memo with regard to that one.
It is not lost whether it has come up. This is matter in the month of, on 19th of November. Yes. Done.
Other side one.
Yesterday I filed a memo for posting. It's supposed to be posted today, sir, but it is not posted. And I went to the pending section. They said the memo is not come to the pending section.
Thank you.
ನನಗೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಲಿಲ್ಲ ಬೆಳಗ್ಗೆ ಹಂಗಾಗಿ ಆಗಿದೆ ಆಗಿದೆ ಅದಕ್ಕೆ ನಾನು ಮತ್ತೆ ಮೂವ್ ಮಾಡೋದು ಹೋಗತ್ತೆ
ಹಂಗೆ ಕೊಡ್ನಲ್ಲ ಸರ್ ಒಂದು ವಾಪಸ್ ಕೊಡ್ರಲ್ಲ
ಲಿಸ್ಟ್ ಅಷ್ಟೇ ನೋಡಿದೆ ಎಲ್ಲ ಡಿಸ್ಪ್ಲೇನೇ ಇರಲಿಲ್ಲ ಇದೆ ನಾಳೆ ಯಾಕಂದ್ರೆ ಅದೇ ಸರ್ ಬಂದಿದೆಯಲ್ಲ ಹಂಗಾಗಿದೆ ಅಂತ
ಕಳ್ಸ್ಕೊಂಡಿರ್ತಾರೆ ಬಂದು ಕ್ಯಾಂಟೀನ್ ಹೇಗಿದೆ ಅಂತ ತಿಂದು ನೋಡ್ಲಿಕ್ಕೆ ನಾವು ನಮ್ಮ ಹೊಟ್ಟೆ ಹಾಳಾದ್ರೆ ಆಗ್ಬೋದು ಚೆನ್ನಾಗಿದ್ರು ಇರ್ಬೋದು ಹಂಗೆ
ಹೊಟ್ಟೆ ಹಾಳಾಗಲ್ಲ
ಅಲ್ಲ ಫಸ್ಟ್ ದಿನ ಚೆನ್ನಾಗಿ ಕೊಟ್ಟಿರ್ತಾರೆ
ಆಮೇಲೆ ಹಾಳಾಗೋದು. ಆಮೇಲೆ ತಿನ್ನೋರು ಹಾಳಾಗೋದು. ಮೇಡಮ್ ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್
ನಾನು ಯಾರ ವಿದ್ಯಾನ ಅಲ್ಲೇ ಹೇಳ್ತೀನಿ ಶಾಂತಪ್ರಸಾದ
Madam? Put up, sir. Court officer?
ಲೀಸ್ಟ್ ಕೇಳಿದ್ರೆ ಯಾವ ಬ್ಯಾಂಕ್ ಅಪೇರ್ ಆಗ್ತೀರಂತ ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ, ಬರ್ತಿದ್ದೀನಿ ನಾನು ಇನಿಷಿಯೇಟಿವ್. ಬರ್ಕೊಡ್ತೀನಿ. ಕೆನರಾ ಬ್ಯಾಂಕ್, ಕೆನರಾ ಬ್ಯಾಂಕ್. ಮೇಡಮ್ ಬರ್ರಿ. ಆಯ್ತು ಹಾಂ ಆಯ್ತು. ಹಲೋ ಸರ್, ನಾನು ಹೇಳ್ತೀನಿ ಮೇಡಮ್. ಥ್ಯಾಂಕ್ಸ್. ನೋಡ್ರಿ ಕೆನರಾ ಬ್ಯಾಂಕ್, ಎಸ್ ಬಿ ಐ ಎಲ್ಲದೂ ಇದೆ. ಮತ್ತು ಥ್ಯಾಂಕ್ಸ್ ಮತ್ತೆ ಸರ್ ಹೇಳಿ. ಬೇರೆಯವರು ಇರ್ತಾರೆ. ಯಾರು ಇರ್ತಾರೆ. ಹೌದು. ಅಲ್ಲ ಮೊದಲು ಎಲ್ಲರೂ ಅದೇ ಮಾಡ್ತಾ ಇದ್ರು. ಮೋಸ್ಟ್ ಆಫ್ ದ ಟೈಮ್ ಕೆವಿಟ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಮೋಸ್ಟ್ ಆಫ್ ದ ಟೈಮ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಎಲ್ಲ ಆದ್ರೆ ವೆರಿ ಸ್ಪೆಸಿಫಿಕ್ ನೆಕ್ಸ್ಟ್ ಡೇ ಮ್ಯಾಟರ್ ಇರುತ್ತೆ. ಅಲ್ಲ ಇದೆಲ್ಲ ನಾನ್ ಪ್ಯಾನಲ್ ಇರೋದು. ಹಾ ಹಾ ಆಯ್ತಾಯ್ತು ನೋಡಿ. ಹಾ ನೋ ಪ್ರಾಬ್ಲಮ್. ಹಂಗಾರೆ ಕೆನರಾ ಬ್ಯಾಂಕ್ ಆಫ್ ಬರೋಡಾ ತಂದ್ಕೊಡಿ. ರಿಮೈನಿಂಗ್ ಯು ಕ್ಯಾನ್ ಗಿವ್ ಟು ಸಂಬಡಿ ಎಲ್ಸ್. ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
Madam?
Before this method is there, now that method is changed. Then once again same method. Before that, ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದ ಯಾವ್ದನ್ನ ಇಲ್ಲ ಅಲ್ಲ ಆನ್ ದಿ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಬರ್ತಿದ್ದೀರಲ್ವಾ ಹುಡುಕಿದ್ದು ಏನೋ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಇನ್ನೊಂದು ಮಿಸ್ಟೇಕ್ ಬೇಡ ನಾನು ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿಲ್ಲ ಈಗ ಅಲ್ಲಿಗೆ ಬಂದ್ರೆ ಆಮೇಲೆ ಇನ್ನು ಸೀರಿಯಲ್ ನಂಬರ್ ಬಿಂದಿಯಾಗ ಆಗಿದ್ದಲ್ಲ ಡೇಟ್ಸ್ ಎಲ್ಲ 54 ಮತ್ತೆ 66 ಫೈನಲ್ ಇಯರ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಫೈಲ್ಸ್ 54 66 ಕಾಲ್ ಫಾರ್ TCR ಅಂತ ಬೆಳಗ್ಗೆ ಮಾಡಿದ್ರಲ್ಲ TCR ಬೇಕು ಅಲ್ಲಿ TCR ಅವೈಟೆಡ್ ಇದೆ ಆಕ್ಚುಲಿ ಅದೇನು ಹಾಕೇ ಇಲ್ಲ ಬೆಳಗ್ಗೆ ಏನೋ ಇವ್ರದ್ದು ಲೋನ್ ಮತ್ತೆ ಹೋಯ್ತು ಪಾಸ್ ಓವರ್ 1 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ 1 2 13 and 15 ಸೆಕೆಂಡ್ ಟೈಮ್ ಪಾಸ್ ಓವರ್ ಆಗಿರೋ
ಗೊತ್ತು ಕೊಟ್ಟಿಲ್ಲ ಹೋಗ್ತೀನಿ
ಮೇಡಮ್ ಯಾಕಂದ್ರೆ ಲೇಟ್ ಆಗುತ್ತೆ ಸಿಟ್ಟಿಂಗ್ ಎದ್ದು ಸೈನ್ ಮಾಡೋದು ಹೇಳ್ಕೊಂಡು ಹೋಗಕ್ಕೆ ಅಲ್ಲ ಅದೆಲ್ಲ ಇಲ್ಲ ನಮ್ಗೆ 24 and 25 ಎರಡೇ ವರ್ಷ ಇರೋದು ಅವ್ರಿಬ್ರನ್ನ ಕೇಳ್ಕೊಂಡು ಹೋಗಕ್ಕೆ ಹೇಳಿ ಹೋಗ್ ಕೇಸ್ ವರ್ಕರ್ಸ್ ಕೇಳ್ಕೊಂಡು ಹೋಗಿ ಅಲ್ಲ ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ ಕಡೆ ಕೊಡಿ ಹೇಳ್ತೀನಿ ಕೊಡಿ ಅವ್ರಿಗೆ ಬೇರೆ ಇವಾಗ ಮೆಮೋಸ್ ಎಲ್ಲ ಮೇಡಮ್ ಸೈನ್ ಮಾಡಿ ನಾಳೆಗೆ ಯಾವ್ದಾದ್ರು ಇದೆಯಾ ಅಂತ ನೀವು ಚೇಂಬರ್ ಅಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡೇ ಹೋಗ್ಬೇಕು ಯಾಕೆ ಮೇಡಮ್ ಹೋದ್ಮೇಲೆ ಡೇಟಾ ಸೈನ್ ಮಾಡೋದು
ನಮ್ದು ಎಂಟದಲ್ಲಿ ಮುಗ್ದು ಆರ್ಡರ್ ತಗೊಂಡು ಕೈಯಲ್ಲಿ ಬಂದೈತಿ
ಹೌದೌದು ಟೋಟಲ್ ಮೆಮೋಸ್ ನಾವು ಡೇಟ್ ಕೊಟ್ಟು ಕಳಿಸ್ತಾ ಇಲ್ಲ ಇವಾಗ ಮೇಡಮೇ ಕೊಡೋದು ನಾಳೆಗೆ ಯಾವ್ದಾದ್ರು ಬೇರೆ ಡೇಟ್ ಅಂದಾಗ ನಾವು ಕಳಿಸಿರ್ತೀವಿ ಅದು ವಾಪಸ್ ಬರುತ್ತೆ ನಾವು ಅದನ್ನ ಎಂಡಾಸ್ ಮಾಡಿ ಕಳಿಸ್ತೀವಿ ನಾಳೆಗೆ ಏನಾದ್ರು ಮೇಡಮ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ ಅದೆಲ್ಲ ಫೈಲ್ಸ್ ತಗೋಬೇಕಂತ ತಗೊಂಡು ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡು ಯಾಕಂದ್ರೆ ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಹೋಗಿ ಅಲ್ಲಿ ವೇಟ್ ಮಾಡ್ತೀವಿ ಮೇಡಮ್ PS ಬಗ್ಗೆ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಅದೇನಾದ್ರು ಹೈಲೈಟ್ ಆಯ್ತಂತ
ಅವಳದೆಲ್ಲ ಬೇಕು.
I'm only reading the notification. There's a conflict with the notification. Application reject again. Reasons
ಇಲ್ಲ ಇಲ್ಲ ಕಂಟ್ರೋಲ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಅಡ್ಮಿಟ್ ಕಾಲ್ ಪರ್ಮಿಷನ್
ಮುಂಚೆ ಒಂದು ಬೆಳಗ್ಗೆ ಓದೋದು
ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡೆ ಹೋಗ್ಬೇಕು ನಾಳೆದಕ್ಕೆ ಅದೆಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟರೆ ಬರುತ್ತೆ ಹೋಟೆಲ್ಗೆ ನಾವು ಕಳಿಸ್ತೀವಿ ನಾಳೆ ಮಾತ್ರ ಹೋಗಿ ಕನ್ಫರ್ಮ್ ಮಾಡ್ತೀವಿ ಸ್ಕೂಟಿ ಅವ್ರು ಹೇಳಿದ್ವಿ ಇವಾಗ ಸಂಬಂಧಪಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಕೂಟಿ
ಏನಿಲ್ಲ
ಇದೇನೋ
names.
ಅದಕ್ಕೆ ಒಟ್ಟಿಗೆ ತಗೊಂಡ್ಬಿಟ್ಟು
No, it is no, yes, arrangement. No, yes, arrangement. Is it there? Is it there? No, it is not there. The arrangement is there. It's there. It is from both. I take from the.
ಯಾರೋ ಹಳ್ಳ ತೆಗೆದಿದ್ದಾರೆ
It is possible. Instruction ತಗೊಂಡಿದ್ದೇವೆ.
ಇದಾರೆ
ನಾಳೆ ಅದು ನೆಕ್ಸ್ಟ್ ಡೈರೆಕ್ಷನ್ ಅದು ಸೇಮ್ ಕಂಟಿನ್ಯೂ ಒಂದಿನ ಅವತ್ತೊಂದು ಅನ್ಕೊಳ್ಳೋದಿಲ್ಲ ಎವ್ರಿ ಡೇ ಯು ಹ್ಯಾವ್ ಟು ಫಾಲೋ ದಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬೈ ಕನ್ಫರ್ಮಿಂಗ್ ಬೇರೆ ಡೇಟ್ ಬಂದಿದ್ರೆ ಅಪ್ಪ ಕಳಿಸ್ತಾರೆ ನಾವೆಲ್ಲ ಮಾಡ್ತೀವಿ
ಮೆಹಂದಿ
ಏನಂತೆ ಏನಾಯ್ತು ನೋಡಿ ನಂದೆಲ್ಲ ಲಿಸ್ಟು ಅಲ್ಲಿ ದಿವ್ಯಾ ಪುರಂದರ್ ನೋಟಿಸ್ ಆಯ್ತಲ್ಲ ನಾಳೆಗೆ ಅದು ಸರ್ ಅವ್ರಿಗೆ ಇವ್ರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ಇವ್ರಿಗೆ ಮೇಡಮ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ನಾಳೆಗೆ ಟುಮಾರೋ
ದಿವ್ಯಾನ ಅದು ವಿದ್ಯಾ ಅಂತ ಹೇಳಿದ್ರು ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ನನ್ನ ಹತ್ರ ಕೇಳಿದ್ ನನ್ನ ನಂಬರ್
ದಿವ್ಯಾ ಪುರಂದರ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅವ್ರಿಗೆ ಓಕೆ ನಾಳೆಗಿದೆ ಮೇಡಮ್
ನನ್ನ ಹತ್ರ ಕೇಳಿದ್ರು ವಿದ್ಯಾ ಅಂತ ವಿದ್ಯಾ ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ ಶ್ಯಾಮ ಪ್ರಸಾದ್ ಇದ್ದಾರೆ ನೋಡಿ ನಂಬರ್ ಕೊಡ್ತಾರೆ type of resignation. ನಾವು ಬೇರೆ ಇವರಲ್ಲಿ
No, I already told. No issue.
Of the passwords in other
That
than
other lists.
other lists.
Then we verify. The further date is not. Last date. That is the last date of posting date. Whatever date submitted along. Passover matters, list number 2, serial number 1. Sandhya U. Prabhu.
Lord, the property of the petitioner was sold by the banker. Lord, after that, the sale proceedings was with them. There was some dispute between sister and the brother. Sister had given a complaint to the banker, given a representation to the banker that she is also entitled to. Initially, there was some dispute, and banker was holding the amount, and what I had sought for was release of that sale proceeds. The bank to both were my clients only. Both agreed, and initially the petitioners, both petitioners had. Sister went and collected the amount, whatever they have given, without opposing for the amount. They gave 20 lakhs, which is a very meager amount, and they have mentioned recovery amount 3 lakhs. There were so many recovery amount mentioned without any documentations. If they are recovering,
No, we will not adjudicate on that.
please, Mila.
No, we cannot adjudicate what is the amount, whether it is right or wrong.
I'm entitled for the
Valid or not.
detailed explanation from their end.
Let it is for them to consider.
Please, Mila.
In fact, this honorable court passed an order in the previous writ petition number 16155 of 2023.
Annexure B.
I just produced the order.
Annexure B.
Annexure B.
It's marked.
Filed by both the sisters. So what is this?
Brother and sister.
Brother, what had happened, I sold a property. Pursuant to that, series of writ petition filed by the borrower when I initiated action under the act. Some of this honorable court protect their interest subject to deposit. None of that, not even one interim order complied. Finally, I sold it. For recovery of some 45 lakh odd. Wherein I sold a property for 1 crore rupees odd. They came before this honorable court. They filed a present writ petition. Release of remaining money, which we agreed from the day one. And later, this honorable court directed me to file the memo of calculation on what basis that money has to be returned. What is the money? I filed a memo before this honorable court on dated. Kindly see the memo. 23 November 2024. Detailed memo I placed before this honorable court.
Where is that? Dated?
23rd November 2024.
24.
Okay. 23. This memo. In fact, I stated, memo of calculation which I filed, how I read the figure. And finally, total expenses, I sold a property for 1 crore 1 lakh 250, wherein 62 lakh 92,000 rupees total expense I incurred, and demand draft to be given, paragraph number 7 in the page 2, 38 lakh 32,000, and interest at the rate of 2%, because it is not in FD. It is, I have taken a DD on the very same day when I sold a property.
That is not the policy of the bank. When it is my turn, my lord, they charge me 9%, 12% for the borrower. And when it is time of return, my lord, they have made it into DD, which none of the court informed them to make it into DD, my lord. If they have kept it in a DD, I will not get anything. When it is a turn of their recovery, they collect 9%, 10%, 15%. And when it is a turn to return it to the borrower, they are giving me 2%, which is less than the SB interest also.
Two more points, I'll just clarify. Paragraph number 8, what is the money, my lord? What is the rate of interest which I given for the money which I have, best money? And my lord, paragraph from 9 and 10, 2 demand draft which I kept ready.
So come to the particulars at paragraph in page number 2.
Page number 2, my lord. Oh. Paragraph from tableau number 7 and 8, and 9 and 10, 2 demand draft. In fact, my lord, I enclosed along with this memo. My lord, kindly come to my lord, page number 6 and 7, 2 demand draft, which my lord, it is I kept ready in favor of my lord, the petitioner. One of the petitioner is none other than sister of the petitioner came, my lord.
Where is the DD? Copy of the DD?
DD, my lord, at my lord, page number 6 and 7 of the memo.
What is it is dated?
Dated, my lord, 17 to 2020. My lord, it is revalidated 2024 or 23. That original DD also I'll produce before this honorable court. Petition idalla. Idalla. Idena. My lord, there one more point, my lord. There are two petitions before this honorable court. The one petition is the petition number 1, 2 is accepted as demand draft.
When was the auction?
Auction conducted on, my lord. Dates and event coding. At the previous order level. In the year of 2022.
You received the amounts on the same day.
One more it is a clap. In the year of 2022 itself, and my lord, after issuance of sales certificate, they filed this petition, refund of money.
That money is lying with you right from 22 till now.
It is not in dispute. My case
Now what is this 2.5% interest?
My lord, when it is, I have taken a DD, or my lord, if they are entitled for FD interest, then they have to come to bank. There are certain procedure, my lord, to adopt, my lord, a particular period I am keeping as a FD. Then, my lord, they are entitled for FD. Otherwise, my lord, they are entitled only saving bank interest. That is at the rate of 2.75%. They are not kept the FD with me. Otherwise, my lord, they would have entitled for 6 or 7%, whatever they are claiming. The money which they are not came and collected.
Hey, the whole problem is that because you are responding, they have to come to the court again and again.
No, my lord, in fact, they would have, I kindly see the letter. How many letters I wrote to them? My lord, kindly come to the very same memo. There are 3 letters which I stated. My lord, kindly come to page number 8. It is in the year of 2024. I stated to the petitioner number 1. With reference to the court order, we sent a letter to Ms. Meena received on dated so and so. One more letter is there. At my lord, page number 4. Let's also in the 2024. With reference to the order, and in fact, detailed calculation I have given to them. And I requested to come and collect it. And page number 8 also, my lord, I kindly come to my lord, page number 8. I return a letter to them.
No, it is in the month of, it's in the year 2024.
2024.
But it is, no, the money is with you from 2022.
2022. It is not in dispute, my lord. It is their duty.
DD was the first DD was you have taken.
That I will, my lord, I'll just.
In the month of, in the year 2024.
I'll just, my lord, exact date, my lord, I'll place before this honorable court.
Bank also has to be fair.
Please, definitely, my lord. It is my duty, my lord. In fact, it's a public, my lord. In fact, the duty of the petitioner would have come to me and they would have taken my lord remaining money. I can't, it is not my money. The next day when I sold the property, it is their aware. They sold, they filed a writ petition, they suffered an order. They would have come to me and they would have collected. I can't keep that money. Now I have to keep on litigating. How many writ petitions they filed before this honorable court after one? And my lord, now in this juncture, they are saying that I am entitled for the FD rate of interest. It is not correct. FD, my lord, if they are entitled, there are certain mechanism. They have to come to bank, they have to keep the money for a certain period and with some seal and it is required. Now, my lord, I accept, my lord, that SB rate of interest, what my lord in this, my lord, saving bank account, they are not entitled for anything further. And therefore, I filed a detailed memo before this honorable court on how I arrived the figure and they are entitled for 2.75%, which I am ready to pay. And one of the petition is already accepted. Only there are 2 petitions filed the petition before.
The other petitioner has accepted because there was no investment from her side. She was only entitled to as per the will of the parents. That she's
equal amount you are also entitled.
Please,
equal amount you are also entitled.
Please, Lord. Because I had invested, I'm a brother. And she's a married sister. She came and collected the amount, whatever she is getting, and she never disputed because for her, it was that 20 lakhs was sufficient. But I raised a dispute with regard to the amount, why they are holding the balance. When they were holding the balance, 16 lakhs, for which they are not answering also. Apart from the interest part, the amount, the sale proceeds, the property for the recovery of the what was amount, what was
settled between you and your sister.
Dispute initially, banker wanted her to come and sign the papers. Then only they were supposed to give. They agreed after I filed a writ petition and there was a court order that petitioners are entitled to the amount with the interest.
That order.
That annexure B, my lord.
Which placed
date.
Which placed
annexure B. The date is my lord 21st December 2023.
I produced, my lord.
From 2023, what has happened?
2023, my lord, she went and collected. The bankers immediately gave 20 lakhs.
Why you didn't go?
Not I went to the banker. I opposed. I told them to give the explanation about the balance.
What explanation?
My lord, property, the recovery amount, what is mentioned in the sale notice, and the property, the amount was somewhere around, my lord, 44 lakhs. 44 lakhs 78,000 was the amount for which they proceeded to recover. 1 lakh 1,000 was the amount, the sale proceed what they have received.
1 crore.
Property, yes. Sorry, 1 crore. 1 crore, 1 lakh is a the sale proceeds. The balance, my lord, whatever is there, in that, my lord, we both were entitled to 50/50.
What is the balance amount?
The balance comes around 66, my lord.
Hmm.
Out
According
of
to
the
your
60,
entitled
now
for
they're
the-
giving DD for 20 lakhs. 20 lakhs they have collected.
How you
20
arrived
lakhs
at
they're.
that- How you arrived at that calculation?
My lord, kindly come to page number two of my memo,
Yes,
which I
yes.
My lord, there are 3 loans. One is OD and 2 housing loan.
Hmm.
And some TDS which I deducted and bank charges of rupees 3 lakh put because account became NP in 2015. After almost 7-8 years, my lord, we sold we put the property multiple locations. Every time, my lord, they say challenge before this honorable court.
No.
Total
Outstanding amount is how much?
how, my lord, as on
44
sale,
lakhs.
selling the property, the 44, which is recorded in this previous, my lord.
Let's see.
44
My lord,
lakhs.
44
In
lakh.
Page 13.
Lord, kindly come to paragraph page number 3 of in the order passed by the honorable court on 25th December 2023 in writ petition number 16155 of 2023. Paragraph number 3, I'll just read, my lord.
In page
The
13.
amount due was 44 lakh 78,000.
44 lakh 78,607 and we sold a property for 1 crore 1 lakh rupees. And my lord, other charges, my lord, we have from 2015 the property was in possession with me. I have put a security guard. I have put the property for multiple location, my lord, notices to them.
So how do you, what is that amount?
My lord, that amount is put together, my lord.
There should be a calculation for that.
My lord, kindly come to that
The table.
Table, my lord, which I produced, my lord.
As per the table, it's 3,47,000.
No, not only that.
They mentioned.
My lord, kindly come to OD account numbers 59. There are 3 accounts. I'll just clarify. One is OD and 2 housing loan. OD account that day, my lord, 18,98,000 plus charges was the outstanding. If my lord can kindly see the sale notice also, which I clearly mentioned.
Your page number 2 of your memo, you have given a table.
Please.
Why did you come to the table so that I'll understand what it is?
Please, my lord. OD account number 5 of 2099. The outstanding as on selling the property 18,98,418 plus charges. In that I mentioned NPA related charges, recovery, legal, auction, paper publication, notice, property management towards the scrutiny, any other related recovery fees, 16 lakh rupees, which I incurred. Because from 2015 up to 2007 years, my lord, the property was in my possession. I put it to security guard, and my lord, I keep on, my lord.
The OD amount of rupees 18,98,418. You incurred the charges of 16 lakhs.
That property which I, my lord, which I was in possession of property, I incurred 16 lakh rupees. Which
There is there can't be any account for that. What is that?
In fact, we have my lord, I'll place all the bill if it's my lord, if my lord passes in order.
It has to be when you're
We'll
filing
produce,
it.
certainly we'll produce.
You should be.
We'll produce, my lord.
You
Bring
should
it back, my
you
lord.
should say
I'm
what it is.
answerable.
There can't be one figure for that.
I got it. No, my lord, here.
So now you are maintaining the property more than the amount of the OD they have taken.
I'll just put it in this way, my lord. When I put,
And more than me and my sister, bank is getting more amount. 50%.
It's not so, my lord. Lord, kindly appreciate, my lord. When I took the possession of a property in the year of 2015, I sold a property in the year of 2022 or 23 after 7 or 8 years, more than 7 or 8 years.
No, you said you sold it in 21.
22. After 7 years of taking the physical possession of property, not, my lord, from
What is the nature of the property?
Property, my lord, it's a house. Residential property, which I took the position of a property in the year of 2015 NPA. But at no point of time, my lord, in fact, there are 4 earlier.
Let's assume that you have kept a security guard. You are taking care of the property. For 5 years, it will become 16 lakhs.
My lord, every month, my lord, I have kept 2 security guard. I have to pay the my lord, salary to them.
Please place before the court.
Every bill, my lord.
What is that amount of?
In fact, all
16 lakhs you have incurred for the property. That is not a small figure. That simply by rounding it off, we can say that's what the bank has.
My lord, I'll definitely furnish. That is one
Please
part. My lord, apart from that, one more submission which I have. Now their dispute, my lord, in respect of my lord, I am going to give my lord 2.75% of interest. One of the petition is accepted, and now they are claiming that I am entitled for higher rate of interest. My lord may direct, my lord, that also we can consider. What is the rate of interest with their entity?
Not only that, my lord. Calculation also they have to give, my lord, supportive with the affidavit.
Then consider the petitioner submits that as on the day when the amount as on due the amount due as on the date of the sale is 44,78,607, and the bank has sold the property for 1 crore and 1 lakh. Now, according to the bank, they'll pay an amount of rupees 20,000 each to brother and
Not
sister.
20,000, my lord, 20
20
lakh
lakhs.
4,737, 20 lakh 4,737 to each.
20 lakh 4,077 to each to both brother and sister. When the council submits that, they've shown the expenses that they have incurred for the property as 16 lakhs without giving any, without any breakup. They submitted that. The money is lying with them from the year 2021,
2022, my lord.
2022. Further, the rate of interest they're giving is
75% of
2.75%. Next, the council for the non-person, the respondent shall place before this court. What is the basis for the arriving at this amount of 16 lakhs and odd for the expenses? Detailed what are the expenses that are borne by the bank shall be in detail be placed before this court, and also then counsel the respondent shall get specific instruction with regard to the rate of interest and the amount is with them from 2021.
Lord, I just one and page number 9, which in fact I given a breakup.
Where is that?
Page number 9 in my memo.
That is paid to some recovery agent.
Recovery
It seems.
agent for the Lord.
My lord, one banker.
Let's see,
Please,
first of all, let's see.
Sun
what he's
enforcement
saying.
agency for their my lord, keeping the position of a property. There's some their bills. If the bills required, my lord, I'll produce before this honorable court. And some legal charges pursuant to filing some suits and my lord before SA and before this honorable court. There are 4
legal charges. Everything you have is you have. I think you have a schedule of how the payments are.
That's all. That's all be a claim.
That you place everything. You place.
My lord, in fact, that we have mentioned also, my lord, 16 lakh. That exact amount, my lord, is coming in tabular.
Then how much you are incurring for this crores of rupees loans you are giving? How much expenses you are incurring for the other loans?
If I am able to sell it, my lord, immediately, like you know,
no, generally that won't happen.
The present, my lord, he is victim of.
No, generally it won't happen. You will be holding it for years together.
But I'm mandated to, my lord, recover the entire whatever money I spent.
No, that's what I'm saying. For a small property,
Sometimes
you are incurring 16. That means more than the amount outstanding. You will be
Sometimes
incurring
it is in crores also, my lord, because it is not in my hand. I have to keep the property, my lord. I have to give some security, and I have to, my lord, secure the property. Therefore, my lord, I have to incur.
So you have to take care of the property like the property is yours.
No, it's not so, my lord. I have to keep.
It is.
Banker can't.
It is.
Banker can't.
It is mentioned in surface.
I have to keep 2 security guards. I have to pay the salary. Some expenses which are required to incur from my end.
Yes. Can you?
Great.
When can you file?
After 2 weeks, my lord, any day.
Yes, Mr. Matter on 12th of November.
Great.
Yes, next.
Praveen Kumar, Nirvani for petitioner, Jai.
Petitioner, my lord.
I am appealing for the respondent, my lord. 13-2 notice was issued on 21/5/2025. The same is received by them on 29/5/2025. For that, postal records are there, and 13-4 was issued on.
How can you make that kind of a statement before the court that you have not received?
I have been informed, my lords. That is the one of the ground, my lords, that I have taken.
They have a acknowledgement for that.
Lords, I have not been received, my lords. Even after that, my
Your
lords.
postal record shows that it has been received.
Even after that, my
Yes, my
lords.
lord, I have it here, track record by the postal department.
Lordship, I am for the petitioner, Lordship. Their contention is notice has been served, Lordship, but no, personally, no notice is served upon me, Lordship. Just except the postal records which they are placing. Let them provide the postal acknowledgement, Lordship.
Yes. Have you
No,
received
no,
it or not?
13-2 and no, Lordship. Personally, it's not been served upon me. If it is so, let them produce the postal acknowledgement, Lordship, instead of tracking
No,
report.
at the last minute, we can't stall the auction on that ground.
No,
when
Lordship,
they say
I'm
that
not,
it is already sold.
Lordship, one fair submission which I'm making before this honorable court, Lordship. I'm not denying the repayment of the amount, Lordship. Just sought a 3 months time for 3 installment to regularize the loan amount, Lordship. I'm ready, Lordship. Tomorrow only I'm ready to deposit certain amount, Lordship. Tomorrow only I'm ready to deposit certain amount, Lordship. Just only six installments is due, Lordship. Let me, madam, 1 nimisha. Only 6 installments are due, Lordship. Out of that 6 installment, I'm ready to deposit for 2 installment tomorrow. And rest of the installment, this honorable court may be fixed the time frame for that. I'm ready to do.
What is that amount, 2 installments?
Lordship, the one installment is about the 2 lakhs and all, Lordship, and the 6 only is due, and this honorable court may fix the time frame for that, and we'll do it, Lordship. This week we'll do it 2,
What's
and
the amount due?
next month we'll 2, and then 2, Lordship. Every month I made an 2 installment with an regularization of.
1 minute, yes.
Please.
My lord, the amount due as on today is 3.4 crores. My lord, we can't regularize this account for the reason that it is not for the first time we have regularized this account. N number of opportunities have been given, N number of times we have regularized. Every time they will regularize and they'll bring it to the NPA. The moment it comes to the NPA, they'll come up with these grounds. We have given them an opportunity to regularize, to continue to pay the EMIs, but they are not choosing to do so. For that reason, we had to initiate the proceedings under the SURFACI Act. Now, at this point of time, my lord, the company is not ready to regularize because the petitioner herein is like making a lot of troubles to the respondent. And if they want to, my lord, like we'll not be able to stop the auction tomorrow. It is, my lord, like that is the submission, my lord. We'll not be able to stop it.
Lordship, if I'm not able to make a single installment, Lordship, they used to trouble me, and they used to keep on calling me, and they comes to the position also, Lordship. Lordship, one fair submission is if they are not, let them regularize it, Lordship.
Between the bank and the borrower, we are not concerned. You have come before this court saying that the notice on the 13th
Auction may be stalled, and Lordship,
13/4 is not received by you. According to them, you have received. They have an acknowledgement. They will file before the court. If that is the case, there is no question of this court interfering in this matter. So we cannot.
One respectful submission, Lordship. Lordship, one respectful submission, Lordship. Kindly appreciate me, Lordship. I'm not denying, Lordship. Okay, I'm short and time for regularization, Lordship. Just 2 months, 3 months may be provided, Lordship. Thereafter, Lordship, if they are not willing to continue with the account over there, I will transfer it to some other bank, Lordship.
Respondent shall come up with shall file the counter.
Any time frame may be fixed, Lordship, for repayment.
Yes, sir. Listed on 18th of November. Shall file their objections. Yes.
Sale number 13.
Lordship, at least sale may not be confirmed, Lordship. I'm apologies, Lordship, for intervening the Lordship proceedings. At least sale may not be confirmed.
Yes.
Lordship, please come to my petition, Lordship, where I'm trying to find it before this honorable court, Lordship. My point is very simple and very clear, Lordship.
With the objections, let them come up and see. Yes, 13.
13.
No, Lordship, if they sell the property, nothing is else, Lordship. My petition will be infructuous, Lordship.
Wherever your remedy is, you please go there.
No, Lordship. When on humanitarian ground, one opportunity may be provided, Lordship. I'm not to put a pressure on this honorable court to do, Lordship. But he suffered suffered in a business, Lordship. Hence, he could not pay. This is since central government also is there is a due to recover some amount from there. Where, Lordship? I'm doing a solar business, Lordship. I'm facing the financial crisis. That's why I'm for this honorable court, Lordship.
Yes, next.
13. GB Nandish Gowda.
Appearing for the respondent bank, my lord. My lord, in this, in fact, as per the copies that are served today, we have proceeded against both the borrower as well as the guarantor's property equally throughout from the demand notice stage. And my lord, so his contention that we were not proceeded against the borrower is absolutely false. Throughout, it has been proceeded against, my lord.
Present,
and in fact, the possession notice, they have only produced the possession notice.
At present.
Even paper publication also has been done. Procedure has been followed. This is the 5th time the notice has been, sale notice is gone. 7 crores. And my lord, his property is a commercial property, prime commercial property. And also the borrower's property, in fact, is a house of which we are in physical possession. So, my lord, the remedy lies elsewhere, my lord. 7 crores is the due.
My lord, at present, my lord, I am agreed, my lord, the notice issued under Rule 8. There is a statutory requirement, my lord, the 30 days advance notice has to be given.
If it is first, it is 30, otherwise it is 50.
So the first sale notice was issued on 30/3/2022.
My lord, it is, my lord, the submission has been made, my lord, the 5 times, my lord, the property has been brought for action. Not even a single time, my lord, notice has been served to the guarantor. They have managed, my lord, no notice has been served to the guarantor. I would like to take my lord.
No, you are only on the point that 15 days notice is given instead of 30. In this case, that 15 days notice is sufficient because they are bringing the property to the auction for the
My lord,
fifth time.
may make my lord the principal.
Please go to the,
principal
go to the
debt-
DRT,
make
you have
one
an alternative
submission.
remedy.
Principal debtor, my lord, as on today, my lord, have not deposited any amount. It
Your
is the guarantor, my
liability,
lord. Yes.
the liability
My
of the
lord, it is
principal
the
debtor and the
guarantor, my lord.
borrower is
Yes,
coextensive.
my lord, it is
They
the
have every
guarantor,
right
my
to
lord, have deposited
proceed against
80 lakhs as
you.
on today. At present, my lord, I am ready to deposit, my lord, 20% of the entire claim amount. My lord, instead of proceeded against the property of the, my lord, the principal debtors, my
When you
lord,
have signed, when you have stood as a guarantor, you should know this.
My lord, both properties, sale notice is very clear, my lord, both properties. Lord, item 2 is belonging to the borrower, item 1 is guarantor. Both properties throughout. So this, that we are not proceeding against the borrower is absolutely wrong. Both properties have been brought.
there is a statutory requirement, my lord, as required, my lord, the sub rule 6 of rule 8 and also 9(1).
Lord, 9(1) has a
The
proviso.
mandatory there is a statutory requirement, my lord, the under sub rule 6 of rule 8 and 9(1), my lord.
Correct. 9(1)
Mandatory,
has
my
a
lord, the
proviso, my
30
lord,
days
if the
notice has
sale.
to be given. I would
My
like
lord,
to
9(1)
I am
has a
repeatedly
proviso.
telling you,
He's
Mr. Counsel, it is not 30 days in this case, it is 15 days.
Statute says, my lord, 30 days.
My lord, we kindly see proviso. My
Yes.
lord. Provided further, 9(1), my lord, of the security interest enforcement rules. 9(1), my lord, the proviso, provided further. My lord, if my notes is founded.
Yes.
Yes, my lord. Provided further, if the sale of the immovable property by any one of the methods specified under sub rule 5 of rule 8 fails, and if the sale is required to be conducted again, authorized officers shall serve a fixed published notice of not less than 15 days. So second sale is always 15 days, my lord. It's only the first sale which is 30 days.
Even first,
My lord,
my lord,
also-
even first sale is taken into consider. Let them produce an acknowledgement, my lord, having served notice on the, my lord, the guarantors. Not even single times, my lord, notice has been served to the guarantor. My lord, the submission has been made,
But
my lord,
those
the notice has been served. Let him.
I'll not, let them bring it, I'll not grant any interim order. Let them bring it.
Yes.
What is the respondent?
And statute says, my lord, the service of notice, when there is failed to serve the notice on the guarantor, my lord, they cannot proceed. Whatever, if the sale has taken place, that sale has to be declared as, my lord, in the null and void.
Yes.
In absence of service of notice.
Yes.
Till number 15, Arvind Kamat, Nirmala Ashok Shinde.
May I please your ladyship? Would you mind me here? All my papers are here.
Yes.
I appear for the respondent bank.
Number.
He wants to follow what is followed in Supreme Court.
No, I'll go there. No, absolutely no problem. All the papers are here.
You can continue, no problem.
Yes. No, my lord, I am on a pure question of law. I am not raising any factual disputes. If I raise a factual dispute, then the question is which is the forum where I can raise this. So I have sought a declaration that the MSME Act and the notification dated 29/5/2015, which creates certain rights and obligations in addition to what is recognized by common law and contract, and certain disabilities on me, the MSME, the borrower. And since the statute has not prescribed any forum for adjudication of disputes or redressal of grievance in respect to this enactment, the civil court jurisdiction, the civil court jurisdiction is not ousted.
No, what is
The impugned order is entire proceedings under the Surface Act. And my grievance is on a very narrow frame that no recovery could be initiated or continued except in the manner contemplated by para 543 of the notification. I produced the notification along with my writ petition and may take your ladyships to page 83 at the very bottom, page 83. Page 83, would your lordship be pleased to, ladyship be pleased to look at page 83. Page 83 at the bottom. So I'm not saying that Surface cannot be invoked. I'm not saying that IBC cannot be involved. I am not saying that RDDB Act cannot be invoked. I'm only saying all that can be invoked subject to the condition laid down in para 543 at page 83. Your ladyship will find recovery, page 83 of the petition, recovery. Once the first two options at A is rectification and B restructuring, above are seen as not feasible, due recovery process may be resorted to. The committee may decide the best recovery process to be followed among other various legal and other recovery options available, with a view to optimizing the efforts and results. Now, the decision of the committee is amenable to correction in terms of the notification itself. May take your leadership to page 90, paragraph 15. Page 90, paragraph 15. This option is open to both of us. Review. In case the committee decides that recovery action is to be initiated against an enterprise, that is in my friend's favor, such enterprise may request for a review of the decision by the committee within a period of 30 working days from the date of receipt of the decision of the committee. A request for the review shall be on the following grounds: a mistake or error apparent on the face of record, or discovery of any new and relevant fact or information which could not be produced before the committee earlier despite the exercise of due diligence by the committee, etc. So therefore, this is Order 47 Rule 1 CPC. So this committee, my humble submission, is a statutory body. And it is a judicial body, not a quasi-judicial body even. The distinction between a quasi-judicial body and judicial body is a judicial body's decision is authoritative and binding. And my lord, I take your leadership to the notification at paragraph 6. So at page 82, yes. Page 82,
Yes.
subparagraph 4, yes. Subparagraph 4, 10 at page 82. At subparagraph 11, yes. So subparagraph 11. On and from the date of, your leadership got it? On and from the date of the coming into operation of the corrective action plan, the plan shall be binding on all the parties to the corrective action plan. The doctrine residicata comes, right or wrong. Residicata pro veritate accipitur. Because the mechanism here.
Before going into that, what are the facts of the case?
Now, facts of the case, yes, I registered as an MSME. I'm an MSME, and an MSME Act does not even mandate a compulsory registration. It's a misconception. They may take your leadership to MSME Act. Madam, you have a copy? I can't have a copy. Yes, just have a copy. You don't have a copy? Yes. MSME Act, you can take it. You have a copy, yes. MSME Act, page 7, para 7. Section 7, yes. Yes. Yes, sorry. Section, page 8, page 8, section 8, sorry, yes.
Section 8 of?
Section 8 of the MSME Act. This is the book, yeah. MSME Act. Page 8, section 8.
Yes.
Bottom, page 8, section 8, at the bottom.
Yes.
Memorandum of, leadership got it? Yes.
Yes.
Page 8,
Yes.
Memorandum of micro, small and medium enterprises. Any person who intends to establish a micro or small enterprise may, at his discretion, or a medium enterprise engage in providing or rendering services may, at his discretion. A medium enterprise engage in the manufacture or production of goods pertaining to any industry specified in the first schedule of the Industry Development Regulation Act of 1951 shall file a memorandum. So what is mandatory is only those industries which are engaged in the production or manufacture of goods specified in the first schedule to the Industry Development Regulation Act. Now, my lord, this registration is not at all required. But the myth was created. If there's ever so many judgments which are under per incuriam and sub silentio which says registration is mandatory. And without, my lord, I take your leadership very briefly to the entire scheme of the act. This scheme has, the act has two.
Going to the scheme of the act, What is the grievance of the petitioner?
No, my lord.
Petitioner is registered as a.
My claim is I'm an MSME. The bank could not have initiated or continued any recovery except with the permission of the committee constitute under the or contemplate under the notification dated 29/5/2015. And my grievance is that they did not constitute any committee. They did not identify incipient stress. They did not notice that whenever there's a default in an account, they are a duty bound to consider create a SMA 1, then SMA 2, then consider committee, make an application to the committee, and the committee has to issue notice to all concerned, including operational creditors, government and financial creditors, everyone. There can be only one committee. I may have taken loan from 10 institutions. Then the committee make an assessment, take a decision. After hearing, it is just like what was BAFR. This act came, in fact, I had a small role in the constitution of this the notification, because I worked for the MSMEs, was represented them. Therefore, BAFR was repealed in 2003. And before that, the companies were protected. Then the government came to the opinion that MSMEs has to be protected. And therefore, in consultation with the Ministry of Finance, Ministry of MSME, Indian Bankers Association, MSME Association, and it took 9 years for this notification to come into existence. And the mechanism is, before a recovery could be permitted, before an MSME allowed to be liquidated, and one opportunity should be made, effort for the resolution of stress should be made. And the committee felt, the government felt, that the responsibility should be vested on the bankers primarily. The committee which is contemplated under the notification is primarily a collegium, of which out of the 4, 2 are bankers only. And then the committee, apart from the bank officials, an independent expert, subject expert, and a representative of the state government are parties to the committee. Then committee make an effort. Committee, if committee finds that, say, if we furnish further funds, advance further funds, it can be revived. That is called rectification. Suppose committee finds that there is no need to advance any further funds, only restructuring is involved, it need to be extended. Say, like instead of 6 months, the loan be made to pay in 12 months, or you give a moratorium for 3 years, then ask them to make the payment thereafter. So it is for the committee to, on the facts of that particular case, to commit to take a decision, take a call, what to be done, whether restructured or should be the corrective action plan should be made applicable, or allowed to the recovery, allow the company to be liquidated. So therefore, no such committee was ever constituted. I'm not disputing the SARFAESI Act is not applicable. SARFAESI Act is certainly applicable, but that can be triggered only when the committee after due consultation and after even a review or an opportunity of review, even that too is denied or lost at then only it can be initiated. So they did not constitute any committee. They did not make any effort for resolution of stress. The entire recovery proceedings are illegal and void. And the MSME Act is a preventive legislation. The purpose is to prevent MSMEs from falling sick. Is a remedial legislation to bring to life those MSMEs which has fallen sick. Is a benevolent legislation. Is a welfare legislation. But still, I'm not asking for any such interpretation. I'm asking only for an interpretation which the letter of the law, literal interpretation, the plain words employed by the legislature. This notification has received the assent of both houses of the parliament. It was laid before it, and therefore it is a statutory instrument. It is an act of parliament, and it is as effective, as binding and authoritative as an act of parliament. Therefore, I am only asking for the benefit of this notification on a very strict interpretation. No benevolent interpretation, no remedial interpretation, no. There are concepts like Uttaras Majis, Valiant, Calm, period, Usairivas, actors, none of these concepts I'm invoking. A plain literal interpretation That is first principle, golden rule of interpretation. Absolute sentential, expository, non-intelligent. A literal interpretation. What the legislature has intended has to be.
We'll ask.
Yes.
Yes,
My lords, if your lordships will take page number 78, my lords, at annex.
78. Yes.
In bold, my lords, in the first paragraph, framework for revival and rehabilitation of micro, small and medium enterprises. The notification deals with a framework for revival and rehabilitation.
Which
Rehabilitation
page,
of
my friend is reading?
page 78, Annex C of your petition.
My petition, unnecessary.
So they are relying on this circular to say that the bank should have given them a scheme of rehabilitation before proceeding under Surface Act. That is in sum and substance, that is what their argument is. If a lordships will take, my lord, this notification is further clarified. The applicability is at page number 93. Annex D, my lords, it begins at page number 91, issued by Reserve Bank of India. Now your lordships may come to page number 93. Eligibility. On top, there is framework for revival and rehabilitation of micro, small and medium enterprises. Eligibility. The provisions made in this framework shall be applicable to MSMEs having loan limits up to 25 crores. In this case, my lords, the petitioner has a loan limit above 30 crores. He won't get covered under this Annex C notification which he has shown, my lords. So therefore, all their contentions is based on Annex C notification, which is not applicable to them. Even assuming, my lords, it's applicable to them, my learned friend has appeared in the Supreme Court. Supreme Court has considered the very same arguments which he has advanced. It's covered by two judgments, my lords. One is in Pronits. In both the cases, he has appeared. So it is covered by.
Yeah, we are producing.
Pronits is produced. The second judgment is not produced.
Yes.
I'll take your lordships to the first judgment which they have produced at page number 170 of the writ petition, my lords.
170.
Yes, my lords. The very same contentions were raised before the Supreme Court. Paragraph 16, my lords. Page 170, para 16.
Judgment starts with.
It starts at, my lords, page number 157. 156, I'm sorry. Annexure N, it starts. The relevant portion is at page number 170, my lords. Paragraph 16. We may hasten to add that under the framework for revival and rehabilitation of MSMEs, the banks or creditors are required to identify the incipient stress in the accounts of the micro, small and medium enterprises before their accounts turn into non-performing assets by creating 3 subcategories under the special mention account category. However, while creating such subcategories, the bank must have some authenticated and verifiable material with them as produced by the concerned MSME to show that loan account is of a MSME classified and registered as such under the MSMED Act. The said framework also enables the micro, small and medium enterprises to voluntarily initiate the proceedings under the said MSME by filing an application along with the affidavit of an authorized person. Therefore, the stage of identification of incipient stress in the loan account of MSMEs and categorization under the special mention account category before the loan account of MSME turns into NPA is a very crucial stage, and therefore it would be incumbent on the part of the concerned MSME also to produce authenticated and verifiable documents materials for substantiating its claim of being MSME before its account is classified as NPA. If that is not done, and once the account is classified as a NPA, the banks, that is secured creditors, would be entitled to take recourse to Chapter 3 of Surface Act for the enforcement of security interest. So what the Supreme Court has held is, at the very first stage, before the classification of account as a NPA, you should bring up this issue that you are covered under the circular and take benefit of the circular from the bank. Now, in this case, my lords, demand notice is issued. Now, 5 times sale notice is issued. This is the 6th time sale notice is being issued. They have filed writ petitions. They have filed appeals before the DRT, my lords. DRT are granted an interim order subject to deposit of 8 crores. They have failed to comply with that interim order. I have produced that with my objections. They have not disclosed that fact also in the writ petition. Without disclosing all these facts, at the fag end, when the bank is on the verge of selling under Surface Act, they have filed this writ petition, my lords. And the second judgment, my lords, if your lordships will see the list of citation which I just passed. At paragraph 6, my lords, page 4.
Yes.
It reinterprets pronits. The way Mr. Nedumpara urges us to read the notification and the terms of the framework, if accepted, would lead to the conclusion that every lending bank secured creditor under the SURFACE Act would be obliged to find out in every event of continuing default, likely to give rise to classification of relevant account as NPA, whether the borrower is an MSME to which the framework applies, whether its business has failed, or whether it is suffering from any disability to pay its debts upon receiving a response to apply the terms thereof, by inter alia including the account in the special mention account for the claim for a corrective action plan to be considered by the Committee for Stressed MSMEs. This could not have been the intention behind the introduction of the framework to aid the MSMEs, which for reasons personal to them is unable to clear its debts and requires revival and rehabilitation that the framework envisages. If indeed it is only the obligation of the lending bank secured creditor to identify incipient stress in the account, subparagraphs 2 and 3 of paragraph 1 would be rendered redundant. An MSME, despite finding that its business is failing or that it is unable to pay its debts or accumulation of losses equals to half or more of its entire net worth, and classification of its account as NPA is imminent, it would rest on its oars, believing that it has no responsibility and that its account will not be classified as NPA because it is the entire obligation of the lending bank secured creditor to what the framework requires. We would read and interpret the seemingly confusing terms of the framework harmoniously to ensure that a right under the MSME Act is not destroyed by the SURFACE Act or vice versa. In our reading, the terms of the framework do not prohibit the lending bank secured creditor, assuming that it has no conscious knowledge that the defaulting borrower is an MSME, to classify the account of the defaulting MSME as a NPA and to even issue the demand notice under section 13(2) of the SURFACE Act without such identification of incipient stress in the account of the defaulting borrower. However, upon receipt of the demand notice, if the borrower in its response under 13(3)(a) of the SURFACE Act asserts that it is an MSME and claims that the benefit of the framework citing reason supported by an affidavit, the lending bank secured creditor would then be mandatorily bound to look into such a claim, keeping further action under the SURFACE Act in abeyance, and should the claim be found to be worthy of acceptance within the framework of the framework, to act in terms thereof for securing revival and rehabilitation of the defaulting borrower. That is, at least when the demand notice is issued, they should have replied saying, no.
When was the 13(2) notice issued?
The 13(2) was issued, my lords, on 31/7/2024, my lords. They have produced it at page 104. So after we issued it, they have not replied saying we are covered.
What happened after 13(2) notice?
We have taken symbolic possession on 20/11/2024. 20/11/2024. And then we have also taken physical possession, my lords. It is at Annex G, page 113, on 14/2/2025. We have approached the learned magistrate and he has passed an order under section 14. Thereafter, my lords, multiple sale notices have been issued.
When is the first sale notice?
On 9/1/2025, my lords.
Then?
Just a moment. So I'll just give the dates. The first sale notice is on 9/1/2025. Second sale notice is on 25/2/2025. The third sale notice is on 24/3/2025. The fourth sale is on 19/5/2025. The sixth sale is on 24/6/2025.
Fifth sale is?
Sixth sale is on, fifth is on 19/5/2025.
No, that is the fourth one.
Fourth, thereafter 24/6/2025. Then 19/7/2025.
That is sixth.
Sixth. Now recently we have issued, after this writ was filed, we have issued one more sale notice on 29/9/2025. And the auction is on 17th.
29/9/2020.
Yes.
Auction is on?
17th, my lords, of this month. That is not placed on record. They have not amended the writ petition to challenge this sale notice, my lords. That is not brought on record by them.
What are the proceedings initiated by them?
By them. My lords, they have filed a essay before the DRT, my lords. Essay number 111 of 2025. They have also filed a writ petition, my lords, 7795 of 2025. 95 of 2025. Then with my objections, I have produced one more essay, my lord. Essay number 617 of 2024.
600.
One word of interruption. The objection copy, I didn't get it.
We have said soft copy also has been
in
sent.
your copy, I not seen.
Essay number 617
of 25.
Now, where is this order in WP 7795?
That is here, my lords, at page number 118, my lords. 7795 is at 118.
Just give me a copy. If you can.
You don't have a hard copy. Can I airdrop the soft copy? I can WhatsApp it to you, or I can airdrop it. You had sent it to your colleague. It's acknowledged.
What was questioned in this writ petition?
Sale notice was challenged, my lords. It was dismissed because sale did not take place. On that ground, the writ petition was dismissed.
Then essay?
SA 117, even that was dismissed on the same ground, my lords. It's at page number 117. They have produced a copy of the order. But if your lordships will take the statement of objections, my lords, for a moment. So this is the annex.
Where are the statement of objections?
Statement of objection file. Like.
When did you file?
Just give me a copy.
There is no,
Green sheet. My lords.
it's not.
There's
here.
an extra copy of this interim order before the DRT. I'll just pass it across. There's some confusion.
1 minute.
My clerk had filed. It's in
No.
green sheet, my lord. Statement of objection. That's
You
the
complete it.
Yes.
Annexure R1 may be seen, my lords.
Yes.
It's a detailed considered interim order, my lord. The lordships may come to the operative.
My handicap is I don't have any paper.
I've given this, sir. I've given this objection. You have served a copy.
This
Your colleague has acknowledged.
Who? I am the person. I am on record.
With my colleague has
This
served
is
it.
But
interim order.
I am
No,
on
no.
record. I have not received it.
No. This is a order of the DRT. Nothing has given to me. There's only one. There's is objection here.
Anyway, I'm referring only to this. I'm not referring to
Okay, fine,
anything
no
else.
issue. Yeah,
I'm
yeah.
only referring to the DRT's interim order, my lord. The operative portion says they are subject to the condition on page internal page 3 of that interim order.
Yes.
Subject to the condition that the appellant shall pay a sum of 8 crore 40 lakhs within 6 weeks in 2 equal installments. Possession notice was stayed, my lord, subject to this. Then on the next page, my lord, 12/3/2025, both the counsels are present. Counsel for the appellant submits that the appellant has not completed the interim order passed by this tribunal. Counsel for the respondent bank seeks time to file objections. Due to the penultimate parameter, due to the non-compliance of interim order stands vacated. This is not disclosed in the writ petition. This is filed by the managing partner. Other proceedings which he has initiated, that they have disclosed. This interim order which they have obtained and which they have not completed, this is not disclosed. In this essay also, they have not taken any of this contention, my lord. So this is for the very first time they have taken this contention regarding MSME notification being applicable. Neither before the DRT nor in their earlier writ petitions, they have not taken these contentions. So therefore, my lords, at this juncture, these contentions cannot be taken. And even otherwise, the circular is not applicable to them since the credit facilities they have availed is above 30 crores. So therefore, my lords, Annexure C is also not applicable to them.
Yes.
And this is pending, my lord. This essay is still pending. We have filed our objections. It is pending adjudication before the DRT.
Now, my friend has not given me a copy of that. I am not making much of a objection to that. I'll go through it because whatever my friend has said doesn't make anything in the contemplation of law. So first principle, there is no estoppel against law. No, that if there.
The first submission.
No, I'm submitting. I understood. If there is a.
That if it is what the loan that you have taken is 30 crores and the
Yes.
act is applicable.
Yes.
where the
Yeah, I'll
loan-
come. I'll come.
25 crores, man.
Yes, I'll come to that. Now the limit has been enhanced to 50 crore, but I am not on that. The question is whether benefit can have retrospective effect. All those things will come. Now, in my petition, because the limit has been introduced by the RBI. RBI is not a lawmaker. This notification has received by the assent of both houses of the parliament. It's a statutory instrument. Under the notification, the Reserve Bank of India has only been authorized to constitute a committee, and which they didn't do it. They have not constituted a committee. Not a single bank or financial institution in this country has constituted a committee.
That enhanced to 50 lakhs.
That is in 2024, 21 and 24. Yes. Now let me.
That is the case.
No, no, let me answer. There's a legal issue.
Enhanced to 50 lakhs. It's even before you have started the securitization proceeding. The
Now, Lordship, let me take your Lordship to page 71.
Oh, you have initiated the proceedings in the year 2024.
Yes, my lord.
This is by 2024 that this amount is enhanced to 50 crores.
I don't know which notification they are referring
The
to.
Reserve Bank's notification is, I produce here also. Yes. Now, my lord, it has been enhanced. Now, I am on a pure question of law. Has the RBI got power to bring such restriction? And at page 71, I have sought a declaration. At page 71, prayer I, prayer L, page 71. Prayer L. Declare that the circular dated, the leadership got it? 17/3/2016, restricting, nay, completely taking away the benefit of the notification dated 29/5/2015 from MSMEs whose credit limit exceeds rupees 25 crore is illegal, ultravies the MSME Act and the notification, and owe it to that extent, and it takes away such right. Then prayer, without prejudice to relief above, to assure return the nature of mandamus or any appropriate writ or direction, directly RBI to remove the cap or rupees 25 crores which it had imposed by circular dated 17/3/2016, or in the alternative to enhance it with a retrospective effect from a minimum of rupees 50 crore, taking into the account the revision of the definition of MSMEs from time to time, enhancing.
You have taken two contradictory pleas. At one stage, you say that the RBI has no power.
In law, allegiance contraria, known as studiantibus, is not a problem at all. I can contradict. In facts, I cannot say this is my pen. I cannot say the next moment it is not my pen. So allegiance contraria, known as studiantibus. On question law, I can take alternative contention, contradictory contention. So I have said, I stick to, yeah, if your leadership confine, I will stick to this notification is ultravies. And it is not even a notification. It may take a leadership to this is a letter. The RBI has, the officer of the RBI has assumed to themselves a power which nobody has conferred on them. When the parliament has not conferred on them, I take your leadership to at page 91. It is a letter written by the chief general manager at page 91. Annexure D.
Yes.
Para 2. While the prudential norms on income recognition, your leadership got it? Page 9. Asset classification and provisioning pertaining to advances will continue to be as per the instructions consolidated in the master circular on IA, IR, AC norms, etc. and updated from time to time. The revival and rehabilitation of MSMEs having loan up to 25 crore will be in terms of those operating instructions. Restructuring of the loans with exposure of above rupees 25 crores will continue to be governed by the extant guidelines on corporate debt restructuring or joint lenders form mechanism. This is a letter addressed by the Reserve Bank of India to the managing directors of banks and financial. It's not a statutory instrument. The RBI has no such power. And as an alternative argument, if assuming for a mere argument say this is a valid instrument, then there is an alternative mechanism. Nothing has been provided. I am entitled to the whole scheme because look at the object clause of the.
They have issued a notice under section 13(2).
Yes.
Have you given your objections? And
No, now my submission is leadership. My submission is there is no obligation at all cast on me to apply. And the whole controversy, I hand out to your lordship, the judgment of the Bombay High Court, because most of the MSME case I am involved, because I had a role in the framing of this notification and in the litigation also.
Justice Deepak Datta's judgment says so.
No, let me take your leadership the Bombay High Court judgment. This is
no. What do you say about the Supreme Court judgment?
Yeah, coming to that.
Just know what he
Yes,
has said.
see, my lord, I am running a campaign. Burn all law reports, save the justice delivery system. Precedent was useful in the 19th century, 20th century. Precedent today serves no purpose because see, it has led to thousands and thousands law reports running into thousands and thousands of pages. In United States, they face the same difficulty. 20 lakhs reported judgment in 1940s. Then the practice of citing judgment came to an end there. Therefore, only American Bar Association only recommended that alone can be cited. If a judgment is in conflict with the statute will prevail. If no judgment can be read as a statute, no judgment can be read in substitution of the statute. All judgments, I would say, were with respect to the facts of that particular case. The judgment doesn't lay down the law for all, because in the first principle, only Parliament has got the power to enact a law which is binding. The principle, this is not my opinion. Thomas Fuller, 15th century, when a Parliament enacts a law, we are all symbolically present. It is with our consent a law is enacted, and therefore it binds all. Record of a court binds all. That is Everest on estoppel, Kasparos on estoppel, Bigelow on estoppel. Record of a court will bind all. Record of a court will not bind only the parties. Reciprocata, right or wrong, it will bind. And others it will not bind. Resinter, alios, acta, altori, nosori, non-debate. Now let me take your ladyship the notification.
I want a specific answer.
I am answering.
For this judgment.
My specific answer is the notification does not at all require me to make any application at any stage. The Pronet also, my submissions were not recorded properly. I filed a review application. I filed an application for correction. That is all pending. I am not relying on Pronet. I am relying only on your ladyship. Whether your ladyship will decide this way or other way, the ladyship record my contention. It is not very important that it should be decided in my favor. That it is my contention is.
Please place all your contentions by way of written argument, so that
My contention is very brief. I take your ladyship to page 70 of the notification. Yes. It offers no difficulty to understand.
Yes.
Any matriculate can understand.
Yes.
At page 70.
Yes.
Identification of incipient stress.
Yes.
The book, page 70. Identification of incipient stress.
Yes.
Before a loan account of a ladyship got it, page 70.
Page 70.
70. So 70 the notification, this book, paper book. So the MSME book. Yes. Yes, yeah, page 70, yes. Identification of incipient stress. Before a loan account of a micro, small and medium enterprise turns into a non-performing asset, banks or creditors are required to identify incipient stress in the account by creating 3 subcategories under the special mention account category as given in the table below. And the notification of the Reserve Bank says how to identify incipient stress in terms of this notification. I may take your ladyship to page number, yes, page number 103 of my writ petition. This notification has been issued by the Reserve Bank of India in furtherance of the notification dated 29/5/2015. Page number 103.
Yes.
SMA 0, signs of stress. There are the illustrative list of signs of stress for categorizing an account as SMA 0. I'm not reading, I only read one, which is simple one, which we can easily understand. Common people like us could understand. Para 3, return of 3 or more checks. These are the illustrative list of signs of stress for categorizing an account as SMA 0. Now, may take your ladyship to the notification, page 70.
Yes.
70. SMA 0. Page 70 of this book. Yes.
Yes. Yes.
Then SMA 0 in that notification also, SMA 0. Principal or interest payment not overdue for more than 30 days, but account showing signs of incipient stress. If any of these 9 conditions shown in this at page 103, illustrative list of signs of stress, the bank notices, then it has to create SMA 0. Then next is SMA 1. Principal or interest payment overdue between 31 to 60 days. Then there is a default. There are 3 scenarios. One is identification by the enterprise. You may take a leadership to two lines down, para 2. Identification by the enterprise. That is a stage where there is no signs of incipient stress. My checks are not bounced. I am paying the workers. I am honoring the commitments, paying tax, everything. There is no signs of incipient stress. But if, as an entrepreneur, I foresee a scenario where I may not be able to meet my liabilities, then at that stage, I can make an application for Constitutional Committee. That is, Sabara 1, Sabara 2, identification by the enterprise. Leadership got it? Yes. Any micro, small or medium enterprise may voluntarily, is not at all mandatory, initiate proceedings under this framework if the enterprise reasonably apprehends failure of its business or its inability or likely inability to pay debts and before the accumulated loss of the enterprise equals, etc., etc. Now, therefore, this can happen only before SMA at the SMA 0 stage. SMA 0 stage is where my default is not more than 31 days. This is a stage where my account is regular. There is no signs of incipient stress which a banker can see, which outside world can see, but I identify it. Therefore, then I have to make an affidavit. Application for initiation of the proceedings under this framework shall be verified by the affidavit of an authorized person. This clause was incorporated in lines with the BAFR because somebody involved with this framing of this notification has an idea about it. Therefore, this is in substitution to the BAFR. A borrower can make an application. Banks are duty bound to make an application to the BAFR when an industry is sick. The same principle was incorporated. The only difference is under the BAFR, it was the all mechanism is in the hands of a judicial authority, BAFR. Here, the responsibility of resolution of stress has been assigned to the banker because bank knows the bank may be in a better position to handle things. So, therefore, the committee, your ladyship will find at page 71, composition of the committee, page para 3. The constitution of the committee shall be as under the regional or zonal head of the bank, who shall be the chairperson of the committee, officer in charge of the micro, small and medium enterprise credit department of the bank at the regional or zonal office level, who shall be the convener of the committee. One independent external expert with the expertise in micro, small and medium enterprise related matters to be nominated by the bank. So out of the 4, 3 is bank only. One representative from the state government concerned. This is, so therefore all responsibility is given to the bank. There is no need for me to apply at all. And then a stage where there is no signs of incipient stress, I can apply. Then next stage I don't apply, but the banker notifies because in the current everything is everything is online. Red flag comes, a check is bounced. The banker is immediately to constitute a SMA account. Suppose there is a default for more than 31 days, immediately SMA 1 has to be constituted. Then if it has more than 61 days, immediately SMA 2 has to be constituted. Then in creating SMA 1 and SMA 2 depends upon the nature of the debt. What is the amount of the debt? There are certain other criteria. So then the banks are prohibited from classifying the account as NPA. That is paragraph 1 says. Before a account of a
You have filed the essay before the DRT. What was your stand?
No, my lord, that's why, my lord, there is, on a question of law, there is no estoppel.
No, I'm not.
No, I was not
It's a
aware.
question of fact I'm asking.
I was
What
not,
was your
my
stand?
lord, aware, my lord, the concept is lex security ignorant. Law protects the ignorant. I was ignorant. Like every other MSME, I was ignorant.
So you have not taken any stand? That's
No, I
what
was
is
not
your
aware.
answer. You
To
know,
very honestly,
whether
when
aware or not
very
aware,
honestly, when I came to a lawyer, then only he came to know that many of the MSMEs came to know that's a benefit available to them.
so without even questioning all that 5, 6 sale notifications have gone.
No,
Not
my
the
lord,
seventh
that's
one.
therefore, Lord, there is something. There's a the pure estoppel is an odious doctrine. It's a technical doctrine. My lord, estoppel, if I'm barred by estoppel, which has to be construed very strictly, I'm out. For the doctrine of estoppel to apply, to be applicable, I'm quoting from civilians. There are 5 conditions, 6 conditions to be applied. Si omnia sut idam corpus, idam quantitas, idam jus, idam omnia, sorry, idam sut petendi, and idam quantitas personalia. So this is what I'm referring to, but this is the Ulpian. The all concept come from
Mr. Johnson, no, you have referred to a circular issued by the RBI.
Yes,
No, as he submits, it's an act.
One word, may I add one word?
Correct,
Yes.
Act doesn't say about uh, this cap of if the loan is 25 lakhs, if the loan is 25 crores, 30 crores or 35 crores. Under which authority this
The
particular?
notification itself, my lords, page number 82.
Yes.
Page number 82, Annexure C. That provides the powers for the RBI to issue that.
Let's see that. That
81, my lords.
the source of power should be under some provision of this act. But not, there can't be any independent authority for the RBI. If the act provides that RBI can formulate particular guidelines
Yes, ma'am.
from time to time, that has to be from the act and the rules. But not about, you said 80?
81, my lords. Page
Let's
number
see.
81.
Let's see. What it says? No, this circular starts with
Subclause 4, my lords. Page number 80. It starts from
to be published in the Gazette
78.
Extraordinary, Ministry of Micro, Small and Medium Enterprise, dated 29th May 2015.
Yes.
You're referring to page number?
81, my lords.
Yes.
Subclause 4. The eligibility criteria and the grounds for filing an application and the time limits within which such application shall be made will be in accordance with the regulations prescribed by the Reserve Bank of India, and only applications meeting the said eligibility criteria and ground shall be admitted by the committee. So the notification itself says that the RBI has power to set the criteria to make this notification applicable, and grounds on which the benefit under the notification can be made use of.
This is issued by the ministry.
Yes, my lords. The power, my lords, it's at page 78.
Page 78.
Yeah. In exercise of the powers conferred in section 9 of the MSME Act.
Section 9.
May I read section 9, my lords?
Yes.
Measures for promotion and development. The central government may from time to time, for the purposes of facilitating the promotion and development and enhancing the competitiveness of micro, small and medium enterprises, particularly of the micro and small enterprises, by way of development of skill in the employees, management and entrepreneurs, provisioning for technological upgradation, marketing assistance or infrastructure facilities, and cluster development of such enterprises with a view to strengthening backward and forward linkages, specify by notification such programs, guidelines or instructions as it may deem fit. It's for the benefit of MSMEs, the power is there to issue notifications and have programs or guidelines. So under this section 9, the notification at Annex C is issued. And the notification itself says that RBI has the power to set the criteria and grounds on which the notification will become applicable. Therefore, my lords, it's not applicable. Even assuming Annexure C is applicable, the law is well settled, my lords. Two judgments of the Supreme Court. Pronates is considered in the second judgment also, and it upholds pronates, and the law is well settled that it should be taken at the earliest point in time. The onus is not on the bank, not only on the bank, but also on the borrower. So they have not taken it. And the second judgment says at least when the demand notice is issued, they should have raised that objection, which they have not done. In the earlier writ petition, this ground is not taken. In two essays before the DRT, this ground is not taken. Nowhere this ground is taken.
And what do you say about the then how this a particular act, the account is declared as a NPA?
90 days. My lords,
Because now, according to you, because it is above 25,000, you don't have to follow all
yes,
this.
I don't have to.
So
That's
like any other account, if there is any
Correct.
default, you will.
Yes, my lords. Yes. That is also from documents I can show, my lords, that the facility is above 30 crores. It is, your lordships may take page number 107, my lords. It is part of the demand notice, 107 of the writ petition. There, my lords, Schedule A, details of the credit facilities availed by the borrower. The very first credit facility is above 30 crores. Then there are various other facilities which I'm not going into, my lord. So therefore, the circular and the procedure laid down therein is not at all applicable to this borrower, my lords.
Yes. When is the auction?
17th, my lords. More than 30 crores is the outstanding liability, my lords, as on date.
So we'll do one thing. You, both of you, you please give your written arguments also. And we will, you let the sale go on.
No, my lord, let me.
Let it not be finalized till the order is passed.
Let me briefly answer them. Two things he has said. He said that the notification is binding. For a notification, assume for argument's sake, the power is vested in the Reserve Bank of India, and such a restriction can be brought. Then such a notification has to come from the board of directors of the Reserve Bank of India. And when unlike except a court, all other bodies have to, in this order, disclose the source of authority. You look at the MSME notification. The notification itself says in exercise of the powers conferred by Section 9 of the MSME Act and the notification. Yes. Yes. In exercise of the notification says everywhere. In exercise of the powers conferred in Section 9 of the MSME Act, etc., and all other notifications or subsequent notification, everywhere the source of power is disclosed. And under the Surface Act also, yes, the securitization, reconstruction, etc. In exercise of the powers conferred by subsection, etc., the central government. In exercise of the powers, etc., exercised by the Reserve Bank of India. Here, yes. The securitization companies and restructuring companies guidelines and directions. I don't have a copy of leadership. I read it. The Reserve Bank of India considered it necessary in the public interest and having satisfied that for the purpose of enabling the Reserve Bank of India to regulate the securitization company or restructuring company from having conducted in a manner detrimental to the interest, etc., I'm not reading, etc. Hereby, in exercise of the powers conferred under Section 3, 9, 10, 12 or the securitization, etc., issue to every securitization company the guidelines and directions. Just be passed on. Leadership understand this. So the source of power has to be disclosed. That only is a fundamental principle of jurisprudence. All courts don't have to disclose the source of power, except a court. Every other authority exercising a administrative judicial power or notification has to disclose the source of power. Assuming for argument's sake, the notification has delegated such power, delegatas, non-purtus, delegare. Therefore, my lord, the sovereign legislative function, lawmaking function, which is vested in the parliament, has been delegated by the parliament to the government in terms of the notification dated 29/5/2016, exercise of Section 9, to the government to frame a notification, because Parliament has no time to go into the details. So that notification was placed before the both houses of the Parliament, and it received this under. So the notification dated 29/5/2000 itself is a delegated legislation, and that the legislative power cannot be further delegated. And in the substantive, I am willing to concede for argument's sake about how a format has to be prescribed. Some technicality, some clerical matters, there can be some guidance. I am not opposing to that. But when curtailing a substantive right, and the Reserve Bank, my lord, every authority which makes a law conducts a public hearing. And who has the power to make a law? It is not the Chief General Manager of the Reserve Bank of India. It is not the General Manager. It is not the Executive Director in charge of MSME under the Reserve Bank of India. The power is vested, if at all, in the Board of Directors of the Reserve Bank of India, and that is the reason why I made the Board of Directors a party. My lord, I brought the Board of Directors of the Reserve Bank of India party because the Reserve Bank of India, Board of Directors of the Reserve Bank of India has not issued any such direction, any such notifications. It is one rendered ab initio. That is, my second respondent is Board of first respondent is Reserve Bank of India. Such a power, the Reserve Bank of India, the very Board of Directors have the Reserve Bank of India has no such power. The Board of Directors of the Reserve Bank of India has not issued any such notification. The notification is at the hands of a Chief General Manager. It has no statutory force. It has nothing. It doesn't bind anybody.
Respondent number 5 is auction purchase.
Yes, my lord. Some of the properties have already been sold.
Yes.
So respondent number 5 represents.
Then how will you interfere with the auction that's already conducted?
No, my lord. Auction will lead to creation of third-party rights. That can never happen. It will lead to litigation. And your ladyship.
No, I'm asking about this.
Your ladyship, I tell from my experience at MSME, conduct MSME lawyer. See, when I raised the issue of MSMEs, I received a very hostile approach from the courts. Any number of petitions I was dismissed, quoting Kodak Mahendra versus Girnar Industries. Give the judgment. And the issue there was, my taken ladyship was to section 26 of the SURFACE Act, section 26C. So the MSME Act has two chapters, chapter 3 and chapter 4. Chapter 3 is about protecting MSME.
Yes.
Chapter 4, MSME Act, ladyship. MSME Act.
All that now it is not necessary, Mr. Counsel.
No, very briefly.
No, like already I have given you enough time.
No, let me.
I can't spend more time on this case. I understood.
No, only one word, very briefly.
I can't spend more time on this case.
No, the whole issue is not, these issues, if these issues need to be, that the counter affidavit has to be filed.
Yes.
The Reserve Bank has to file a counter affidavit.
Not stall the auction. I'll not stall the auction. I'm not convinced.
No, then the whole issue, ladyship, your lordship, ladyship will, see, I have left to as a lawyer, I'm happy if it is not straight. Because that will lead to difficulties only. It doesn't help in fact, it doesn't help them also. Because third party rights will be allowed to be created.
The auctions were conducted so far. Let the 7 also go on.
No, then there is one reason. See, what I wanted to say is, what is in your ladyship's mind is, what I understand is, that I had, filed essay, many auctions were allowed to be conducted, and therefore there is some kind of a stop or adjudicate, I came late, etc. No, that is completely wrong. There is one thing, why I said, when I said I will not utter a word on facts, because this court has no jurisdiction to go into the entire facts. A decision, your ladyship takes a decision in dismissal case. What consequence it will have? It will have zero consequence. The reason is there is no termination of this. Listen. The Bombay High Court has passed an order. I take a copy of that. There is no termination of this. Justice Suman Shyam that his lordship accepted it, para 38. Yeah, no, para 38, para 18 of that. See, after the judgment is, this case is dismissed. But I tell the court has, the DC has not culminated in a termination. All issues are pending. Auction will conduct, further things are, further action, the Surface Act or another laws will continue. There is no termination. So there is no end to litigation. Interesto Republico ut sit finit litium. It is in the interest of the Republic that there is finality of litigation. Nemo debet bisvexari pro uno et idem cosa. No man shall be vexed on the same question more than once. No, 1 second.
I do not require all those submissions.
No,
Please
no,
understand.
leadership, I have not even dismissal also. I have no problem. No, but leadership, I wanted your leadership to have a look at para 18. This is the calamity. Para 18. Para 18. I'll give a copy. Give a copy to my friend. I'm read out to my friend. Yes, I'll give a copy. Para 18. After, so therefore I pointed out the court. There is no terminus. The adjudicator come. There must be a complete termination of the list. Yes, para 18. For the reasons stated, my leadership. For the reasons stated herein above, your leadership got it? Para 18. For the reasons stated herein above, we are of the view that there is no scope for this court to entertain the writ petition. The writ petition therefore stands dismissed. Interim order passed earlier also stand vacated. Liberty is therefore granted to the petitioner to avail appropriate legal remedy in accordance with law and in terms of the leave granted by the judgment dated 11 January 2024, that is Evan Navindra Bombay High Court, as well as the decision of Pronitz Supra to similarly situated MSMEs, if so advised. What is the next result? There is no termination. All litigation starts again. Therefore, if you decide a case properly, then there's an end to litigation. Otherwise, multiplicity of proceedings. Multiplicity of proceedings. Interesto Republico ut sit finit litium. It is in the interest of the Republic that there shall be finality of litigation. And it is also a fundamental principle of law. Nemo debet bis vexari pro uno et idem cosa. No man shall be vexed on the case, same question more than one. I don't want me to be, made to convert to litigate again. I am kind to my friend. I don't want him to be brought to the court again and again. But that is possible when there is all parties, all controversies are brought before one forum and is decision final and binding, right or wrong. CPC, order 1, rule 1 CPC, order 2, rule 2 CPC. Section 8, the doctrine established that one should examine the CPC. Section 10, stay of suit. Section 11, Rusticata. Section 12, Section 12 is stay of suit. Then order 1, rule 1 CPC, order 2, rule 2 CPC, order 1, rule 8 CPC, order 20, sub rule 3 CPC, section 34 and 49, 41, 39 and 41 on specific relief act. So therefore, all the legal system can work and justice can be delivered only if all controversies are brought before one forum and this decision, right or wrong, is final. And that is my prayer in the writ petition. I sought a declaration. May take my prayer. May take your leadership to my prayer. Yes. My prayer at page 66. Yes. 66. Yes. Jurisdiction of this. Yes. They declare that. Yes. Page 66. Declare that leadership got at page 66.
Yes, I've seen all the prayers.
No. Did it. Declare that MSME Act, insofar as it has not created a special forum or tribunal to enforce the interstate rights and obligations and remedies, which it has created in addition to those rights and obligations remedies recognized by the common law, the jurisdiction of the civil court is not ousted. For it is impossible to oust the jurisdiction of the civil court without providing for an alternative forum or tribunal to adjudicate the interstate disputes between the parties who are governed by the Act. And further, as far as a corollary thereof, the DRTs, NCLTs created under the RDDB Act, Companies Act are invested of no jurisdiction to adjudicate the dispute arising out or involving MSME Act. So dismissing my case is not going to have any solution. That is many,
Who told
many
you that
cases,
the court is-
therefore, that is, therefore, what is, what you are- the, my lord, there has to be, the comes, this comes from Ulpian. I am reading out from the Ulpian, may just pass on this book.
Mr.
The
Counsel,
leadership, just pass on, the court officer may pass on.
I do not want
No,
to
no.
waste further time.
My lord,
Please come.
yes, so,
The writ petition is filed, seeking several reliefs, running into from
no,
A
no,
to
leadership, one second.
A to M.
Leadership, one second. I have no hurry. This matter, I am not raising any factual issues here because this court has no jurisdiction to go into factual issues because there is another forum. Either the civil court is this court hold that no, DRT has jurisdiction is fine, but DRT has no. If DRT has no jurisdiction, then this court now the parties we together cannot confer it. So therefore, these issues need to be gone into in depth. It cannot be, we cannot examine these issues in a very, it has to be taken with a much greater seriousness and it has to be gone into a depth. And the parties, the source has to be crossed, battle lines has to be drawn, notice has to be issued to the Reserve Bank of India, to the RBI, they have to file a counter. It cannot be decided, somebody saying something across the bank.
Mr. Counsel,
Pardon me?
that's what precisely I'm
Ah,
going
yes,
to do.
yes.
If you hear to the court with
Yes,
all
yes,
your
yes.
experience, you
Yes,
will
yes.
understand.
Yes,
We could
yes.
have, we could
No,
have,
no,
we
but
could have
leadership,
saved lot
I
of time.
consider
So
lawyer
many
has
people
a,
are waiting for the court to hear
yes,
their matters.
lawyer has a duty to
But
protect the
is
court from
awarded
committing mistake.
all
That is
further
also.
proceedings against the petition, therefore the Surface Act, RDB Act, particularly the auction is scheduled on 13/8/2025. Looking at the reliefs that are sought and particularly considering the submissions of the land counsel appearing for the respondent, that this is the sixth sale notification, sixth or seventh?
Sixth, my lord. Seventh.
Seventh notification.
We do not know, nothing on record. How can he say? It is, what he says is not gospel truth.
That this is the seventh sale notification that is issued. And already the party, the petitioner has approached the DRT by filing SA number 617 and also SA number 111 of 2025 at this juncture without looking at the objection, without the respondents filing the objections and considering the same in the light of the reliefs, the prayers that are sought, this court is not inclined to pass any interim order. Notice to, you appear for whom?
I appear for the bank.
Which respondent?
Just a moment. Bank. I'll just.
Reserve Bank R1.
R2 and R4, my lord. I appear for
R2
R2 and R4.
R2 and R4 you appear?
Yes, my lord.
Anybody else appearing? You appear for R5? You appear for? 6 and 7. Then 8, who takes notice on behalf of 8?
AG.
AG. The Reserve Bank of India? So you who? Respondent number 1 is already represented by Mr. Manik BT. And 4 and 5 by Mr.
2, 3, 4, my lord. I'm sorry. 5.
2, 3 and 4 by
Mr. Rukoji Rao, my lord.
Mr. Rukoji Rao. 5 by Abhinav R. 5 and 6 and 7 are represented by
BM Kushalappa.
BM Kushalappa.
And R8 is government represented by
R8 is already represented. All the respondent shall file their objections. This matter on December 25th, no, November 25th. Yes, next.
Serial number 9, wish number 3. Wish number 3, serial number 9, pass over matter.
The petitioner's case, my lord.
Yes.
Petitioner.
List number 3, serial number?
9. City Malay.
Yes.
Yeah, ladyship, one thing, I noticed your ladyship said the auction shall not be confirmed.
No, I didn't say no. Yes.
Yes, I heard it.
No, no, no.
Yes.
Yes.
My lord, the petitioner's husband who filed a divorce petition before the family court.
The item number?
9, my lord. List number 3.
Yes.
He filed a divorce petition before the family court, Bangalore.
What is the impugned order?
Impugned order, lordship may kindly see, he also filed a GNWC petition before the family court on 21/9/2024.
Where is the order?
There is no order, my lord. From past more than a year, my application in respect of child custody has not been considered or any orders have been passed.
Which year is the GNWC or the
GNWC
MC?
is filed on, my lord, on 21/9/2024.
Hmm.
And along,
Filed?
sorry, my lord, husband.
IA is filed.
IA is also filed on the same day along with the petition, my lord.
Which court is this?
This 6th Family Court, Bangalore.
Learned counsel the petitioner submits that GNWC is filed in the year 2024, which on 21/9/2024. Along with that, IA is also filed seeking interim custody.
Please, visitation.
Interim custody oblique visitation of the child, and so far no orders are passed by the court. The Registrar Judicial is directed to call for a report from the concern why an applicant, in spite of repeated orders passed by this court on judicial as well as administrative side, why an application for interim custody is kept pending from 21 for almost a year. This matter on 24th. Yes, next.
Please.
List number 1, finally.
October. Yes.
List number 1 for final, for judgment. Sale number 52.
Do that.
I appear for appellant in 52.1, my lord.
Yes, Mr.
I
Ramesh.
appear for the
Why is it set for judgment? Who said so?
My lord, insurance company have filed an appeal on the ground that they are not liable.
may I?
Yes.
Insurance company have filed an appeal on the ground that the check which was cancelled, the intimation was not, that was the case, my lord. I've given the citations kindly, please, my
Yes,
lord.
yes. Give the citation.
It is there in the
Now,
file.
what about
Yes, my lord.
given?
On the last hearing date,
You also given one judgment.
Lakshmama, yes, my lord, please. That, and following that, Supreme Court has recently.
What about the compensation? There
Yes,
is-
please, my lord.
Yes.
For that also, I've given a judgment, my lord. Chetana and others versus Babuji. It's there in the file, my lord. On last occasion, I've given.
I'm saying what are the grounds for enhancing the compensation?
My lord, minor death, my lord. So he was working. So on that, I've given the judgment on the last occasion, my lord. It is there in the file.
It's a case of minor's death. What is the law on that? What is the?
Kishan
No, my
Gopal
lord,
is
he was
applied.
working, my lord. According to this one, my lord, Child Adolescent Labor Prohibition Act, Section 3 of the judgment says that. Please.
Judgment.
Yes, my lord. It is there. I've given in the judgment.
What will happen to the Supreme Court judgments? Kishan Gopal and all. Yes, Mr. Ravi Samprati. She's relying on in case of a death of a child.
The Rajendra Singh, there is a subsequent judgment to Kishan Gopal, wherein 35,000, I think they have considered on 35,000.
Kishan Gopal, it is 15,000.
I think in Kishan Gopal.
Have they referred to those two judgments?
Please, my lord.
Have they referred to those two?
Yes, Kishan Gopal was referred in Rajendra Singh's judgment.
Which year is that?
Just I don't have a copy.
In this case, Apex Court held that recently, any death age is not criteria. WC Act
Actually, there is a judgment of Justice
That's got
Sanjay
recently.
Karol. In that, there is no reference to. They only have referred to Kajal's case. In case of a death, they refers to Kajal's case.
Taken up tomorrow or day after.
Oh. Yes.
No, I have Sarla Varma's case, my lord. In that, multiplier starts from 15.
Recent judgment is there, my lord.
What is the age?
Age is 8 years age, my lord. Taken WC Act, whatever the date of accident, that,
I know that's Justice Sanjay Karol's judgment.
yes, my lord.
May I please?
Kishan Gopal is also cited in that.
Where is the judgment?
Judgment is 2025, my lord.
Please
Recent
get
judgment.
it
My lord,
after
I have
tomorrow.
Sarla Varma case, my lord. In this, multiplier starts from age of 15, my lord.
Let's see. This matter on 29th.
Please, please.
Salem, final hearing matter.
Much obliged, my lord.
Hearing for my lord, respondent number 1 claimant, my lord.
You're on what ground?
My lords, my ground is that it's on liability, my lords.
On the ground?
On the ground that, my lord, the rider, the driver of the, my lord's vehicle did not possess, my lords, valid and effective driving license.
What is the evidence in that regard?
Lords, we have given evidence of
Charge
the.
sheet is filed under the Projects of Motor Vehicles Act.
Yes, my lords, it is in fact filed under section 3, but later on, my lords, he produces learner's driving license. Though he has produced, my lords, learner's driving license, my lords, he was not accompanied by a, my lords, a person instructor as contemplated, my lords, under rule 3 of the central motor vehicle rules. Therefore, my lords, there is a violation of that, my lords, policy, terms and conditions of the policy. And in fact, my lords, the learner's driving license contemplates that he should always accompany with an instructor.
Then in that case, pay and recover.
Pay and recover, my lords, would arise.
That's
Yes.
the only ground.
Yes. And also, my lords, quantum also I have not question.
So now we will deal with the quantum.
My lords, in fact, the
You have a against which MBC these cases are filed, because there are how many? Four
are there. Lords, in fact, the owner, my lords, is representing owner, my lords.
Who is representing?
My lords, MB Chandrachud, my lords, I am told that he's unwell.
List all
Because
these
he is
matters
representing, my lords.
as parted on 4th of November.
Please.
Cell number 54 for adjourned, 55. Cell number 55.
The case of injury.
Hmm.
The respondent
appears?
is served, my lord.
Tata AG General Insurance, who appears?
One Pradeep is appeared.
Huh?
Pradeep.
Where is Pradeep? Apart from Pradeep, who else appeared?
Lord Hegde Mulkund. Hegde Mulkund.
Ravi S. Samprati is also appearing. Yes, Mr.
Now I don't appear for that.
You don't have.
Hegde Mulkund is there. Hegde Mulkund.
Lingraj is there. Janardhan Reddy.
Mr. Janardhan Reddy is ready to take notice on behalf of the respondent insurance company. Counsel of the appellate shall serve the copy on the counsel for the insurance company. This is matter on 12th of November. Next 56.
Cell number 56.
Yes.
This case, my lordship, one number 2. Sumitra was sustained accident in the road traffic accident, and during the pendency of the claim petition, she was died, and the legal heirs are brought on record as the LRs of the deceased Sumitra. And court below has dismissed the claim petition on the ground that without awarding any compensation except awarding the medical expenses. In the ground that there is no nexus
What is the
between.
evidence on record that that accident has accidental injuries
There is no
has led to the
postmortem
death?
report is conducted, and
No second FIR, no postmortem, no PM report, and there is no
intelligence of
doctor
this-
evidence also.
I seek intelligence of this court if the matter was remitted to the tribunal one for giving one more
So how
opportunity.
can you
If
get
they
it
are
now?
producing some
Postmortem-
documents, sir.
Postmortem has to be done. Please come.
I make another submission, my lord. She is inpatient for the period of 10 days,
Let's see, where is that amount? How is it granted?
and medical expenses I have
1 minute.
para 26, 25, my lord.
20?
25 onwards. Discussion with regard to the nexus, which is in para 22.
The total medical bills were mentioned as
7 lakhs
12,000.
12,000.
3,96,500 only countable. Other bills
That
are
is
not.
only awarded. I have.
And that is only the proper bills.
Proper bills, it has to be calculated in that manner, but I have produced the medical bills to tune of 7 lakhs 12,000. He was inpatient for the period of 10 days. And taking treatment at two hospitals, at Mangala and Sparsh Hospital at Bangalore. So marginally, the compensation towards the medical expenses is liable to enhance my lordship.
How it will be enhanced? There should be some basis. We should show that this is not accounted, this is not considered. Just like that, we cannot.
I produced the entire medical
Might have
bills.
produced, looking at it, what is the additional amount, under which category you are entitled, that you have to tell, under which bill it is not considered, what is it?
Exhibit P16 is final inpatient summary bill. That is only the 3,96,314. For other
Therefrom, he
bills,
has
there is
got the
no-
remaining amount.
there is nothing is there in evidence.
And towards the loss of income during later period, other rates, no compensation is awarded, though it is to be considered towards the.
No.
No death occurred in her house.
That is secondary.
No, this incidental expenses, he was there in hospital.
Yes, my lord.
For how many days?
For 10 days, my lord.
10 days. On that count, we'll grant 10,000. Then loss of income during the later period.
That is required to be awarded, my lord.
Which year is the accident?
2018, my lord.
12,500.
20 death.
Huh?
2000.
He was in later period is during that accident
Yes,
is 2000?
Yes, my lord.
18. $37,500 3 months, 10,000 plus 10,000 legal expenses. Altogether, it comes to 57,500. Yes, come. Agreed with award passed in MSC number.
And incidental expenses is liable to be enhanced. Incidental expenses because he is
10 days he was in hospital. 10,000 is
taking treatment, transportation from Assam to Bangalore.
No, she was
shifted in ambulance.
Court has considered that incidental expenses.
She was not suffering. She herself only discharged.
And by rounding out the same, the agreed with award passed in MSC number 6251 of 2018, dated 22nd February 2023, whereby the court had granted compensation of an amount of rupees 3,96,500. The claimant is before this court. The counsel appearing for the claimant submits that the father of the claim, the father of the claimant has sustained injuries and
Father is not the. He was the driver at that time. He was the accused.
And
she does not awarded to him.
Sumitra sustained injury, my lordship.
who died?
Sumitra is died during the pendency of
What
the
is
wife.
Wife of the wife of the appellant
Yes, ma'am.
died during the pendency of the wife of the appellant had sustained the
First appellant is the accused. He was driving the car at that time.
the wife of the appellant had sustained the. How can he file then? How can he claim all this?
Yes, my lordship. He's the first appellant is the husband, second appellant is the daughter and son.
You should have preferred an appeal.
No. He was the accused at the time of accident.
That's what I'm saying. You should have preferred an appeal for this. Questioning this. It is submitted that the counsel appearing for the claimant submits to the court the accident has occurred after because of the accidental injuries. The wife of the appellant has died, and the court has not granted any compensation. When the medical bills are amounting to 7,12,863, court has only granted 3,96,500. They submitted that the incidental expenses and the loss of income in the later period is not granted. Mixed para.
And my submission is loss of dependency is not calculated because there
Okay,
is
loss
no-
of that's what I said. Loss of dependency is not calculated. Plan counsel. I'll not record that contention of yours.
That one,
The land council was
loss of
respondent
dependency
submitted
will
the
not
court.
arise, my lord, because.
The court has rightly
I
granted the
make my
compensation
submission.
and rightly granted the compensation. There are no grounds to interfere. This court has perused the award passed to the tribunal, has rightly observed the tribunal. There is no nexus between the accident and the death of the deceased. The basing on the evidence on record, court has rightly granted an amount of rupees 3,96,314 towards the 3,96,314 for the medical 3,96,500 for the medical bills towards the medical expenses, and this court finds no reasons to interfere. Accordingly, dismissed.
Cell number 57.
If he's going to enhance 50,000.
Not after what he said.
57. Arsimurthy GV.
Is Mr. Ravish Benny?
Ravish Penny.
No representation on behalf of both the parties. This is matter on
His
9.
submission is false, my lordship. He is making a wrong submission. Because they are proceeding in a car driven by another person, not by the husband of the.
No, husband was only the driver.
Illide.
It is very clearly shown in that judgment. You see.
Show it.
It is very clear, my lord. The liability. Regarding liability, offending car bearing number 90 was charge sheeted. Issue number 2, in this case, the driver of the offending car bearing was charge sheeted. Further, there is no dispute about the validity of the insurance policy, and it is awarded. As already discussed in the issue number 2.
The charge sheet is there.
He is the owner of the vehicle.
Allah, they are traveling. It's not driven by the husband.
For him, award is not given now because he is the driver.
Where is it? That's what I'm asking.
Basuraj was the driver. He is the husband.
What is the appellant's name?
Basavaraj Chirant.
Basavaraj Chirant.
He is the driver. He was the driver at that time.
Yes, next. No representation list on 9th of December. Yes, next.
Cell number 58. Harini Shivanand. Tippeswamy PC.
This is also no representation on both the parties. Same day.
Cell number 59.
I appear for appellant, my lord.
For
In this
responding.
case, LCR required, madam, because liability in dispute.
All these are forces for file hearing without calling for the DCR. Call for the DCR, list is matter of the DCR is received. 60.
60. Pradeep B.
Appearing for the appellant in this case.
Yes.
This case
Honor
will-
served.
Served. Injury case. Challenge, I'm questioning the quantum of compensation. Lord. The income considered 14,500 as per the chart. My lord, only 25% future prospects has been added. 19% whole body disability has been considered by the MSME. That is wrong.
What is the doctor's?
57% to the limb, my lord.
Then?
19% as rightly considered by the MSC.
Then what is wrong?
Future prospect 25% added.
25% is granted. What is the age?
48 years.
Then how
No,
much?
my lord, case of injury, my lord. 19% future prospect would not
below-
arise as per consideration.
That's the only ground.
Please,
So 14,500 into
19%
12 into what is the multiplier?
multiplier 14 minutes. No, sorry, my lord, 13, 48 years.
Into 19 by 100. It comes to 4,29,780.
Please, ma'am.
Court has granted
5,65,500.
5,500.
500.
That is 1,35,720.
There is a 4 fractures, my lord. A pain and suffering 30,000 awarded.
Where is the result?
Para 17, the fractures has been mentioned. Para 17, fracture of left and right wrist and fracture of scapula
How many fractures?
4 fractures.
So 60,000 or
Please.
70. Pain and suffering 70. How many days was in hospital?
Was, hospitalized 13/12/2022, 24/12, 11 days.
How much is granted? Incidental expenses another 1,000.
Loss of immunity is 10,000 awarded.
That has to be enhanced. Loss of amenities another 10,000, 20,000 plus 30,000. Then loss of future earning 14,500 into 12 into 13 into 19.
4,29,780.
4,29,780. Then loss of, that's it, all are covered.
Laid up
Laid
period
up
2 months.
period.
2 months awarded.
How much is awarded? 29,000.
29,000.
It's coming to 9,52,201. Please come. Agreed with the award passed in this is number 523 of 2021. Dated 6th November 2023. Whereby the tribunal has granted 10,28,921 as compensation. The claimant, the insurance company is before this court. Then counsel appearing for the insurance company submits that as far as the future loss of future earning is concerned, that's where the insurance company is agreed. It is submitted that for a disability of 19%, court had granted, taken 25% disability, and ought not to have taken the same. Next paragraph. The no notice is served on the respondent. No wakalat is filed on their behalf. As this court, though there is no appeal is filed by the respondent claimant, as this court is looking at the revisiting the compensation, considering the pain, considering the 4 fracture injuries and the head of pain and suffering, this court is granting 70,000. The medical expenses as it is, incidental expenses, considering the 11 days of hospitalization, 11,000. Loss of amenities is considering the 90% disability, 30,000. Coming to the loss of future earning, as rightly argued by the land council, court ought to have granted 25% at future prospects. 14,500 into 12 into 13 into 19 by 100 is 4,29,780. Loss of earning during the period, court has granted 29,000. This court has not interfered. Altogether, the claimant is entitled for 9,02,201. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 9,02,201 from 10,28,921 to 9,52,201. Amount in deposit shall be forthwith transferred. Any excess amount deposited, the insurance company is at liberty to withdraw. Yes, next.
Cell number 61, Girish B. Baldare.
Appellate, my lord. Para 26 of the judgment, my lord. Seeking enhancement of the compensation towards the damage caused to the bullock cart or while carrying the sugarcane and bullock. And in the said accident, one who died and the compensation is properly awarded. I am seeking enhancement of the compensation only towards the bullock and repair of the bullock cart. Observation is made in para 26 of the judgment, my lord. Where as per the estimation exhibit P9, 10 and 12, 75,000 towards the repair of the bullock cart and 40,000 towards the injury sustained to the bullock So compensation was meagerly awarded by the tribunal only to the extent of 20,000, my lord.
What do you say, Mr. Vijayakumar?
My lord, another 20,000 may be awarded. I don't think they have not examined the author of the document so that we can cross-examine all those requests.
75,000, my lordship, and as per the
The bill is not examined. They have not examined the for having repaired, purchasing the material. Nothing is available. Even
What,
those.
who will, their
But even
exhibit
ownership
9, 10,
ownership also not.
author of the said documents were not examined before the court to establish that they spent rupees
They're not
75,000.
examined, my lordship. They produced the
Yes.
wound certificate and also estimation report.
So the bullock died.
Yes, my lordship.
Bullock died.
Bullock is not unfit for using for the
Photo is not
agriculture purpose.
produced.
The wound certificate I have produced, my lordship.
Exhibited, sir.
Exhibit P9.
9, 10, 12 months ಇದೆ, but it is not there.
ಇದೆ.
Exhibit 9, 10 is the IMB report. 10 is a certified copy of the certificate ಅಂತಿದೆ. Then 12 is the
Exhibit
identity
P11.
card.
P11.
Next page is the
Wound certificate.
estimation
Wound
issued by the
certificate.
engineering works to repair towards the bullock cart that is in Kannada, my lordship. In the last stanza, it is stated how much required amount is required.
Another 20,000 may be awarded.
That is total 40.
Yes, my lord.
Yes.
20 already awarded, another 20.
No, another 40. Agreed with that.
My lord, there is a delay of, my lord, one submission. There is a delay of
When is it?
345 days delay in filing the appeal by order dated 16/1/25. My lord, the interest is denied. 16/1/25.
Agreed with the award passed on embassy number 1732 of 2019, dated 26 April 2023. The claimant is before this court only seeking enhancement as far as the compensation towards the loss of bullock and bullock repair and bullock loss of bullocks and repair of the bullock cart. Land counsel appearing for the appellant claimant submits that in the accident, the bullock cart is completely damaged and the bullock have injured and they have spent an amount of rupees 75,000 towards the repair and 40,000 towards the as the value of the bullock as it is insured. It is not fit for any other purpose. The court, without considering all this, has granted only 20,000. Then counsel appearing for the respondent insurance company submits that the court has rightly observed that the claimant had produced exhibit P9, 10, and 12. However, the author of the said documents are not examined for the court to establish that they have spent rupees 75,000 for repair of the bullock, and the value of the bullock was rupees 40,000. Hence, the nominal compensation of rupees 20,000 is awarded. No interference is called for. Further, learn counsel for the petitioner, the learned counsel appearing for the sunset. And there is a material on record. It is an admitted fact that the bullock cart is damaged and the wound certificate shows that the bullock is completely injured as rightly for an amount of 75,000. No person is examined in that regard. However, considering the fact that the bullock is injured, and however they must have spent some considerable amount towards the repair of the bullock cart, this court deems it appropriate to enhance the compensation by 40,000 towards the loss of bullock and repair of the bullock cart. Hence, the total compensation comes to 22 lakhs 66,800. Yes. The petition is not entitled for interest, so and so. Yes, next.
Cell number 62. R. Shashidhara, B.C. Shivanagowda.
Case of injury. The fracture of navicular bone and the third and fourth left metatarsal. Doctor assessed disability 19.4%.
Internal page 17.
So how many are the injuries?
3 fractures.
3 fractures. And 15 days he was inpatient, my lord.
14 days. 14 days.
60,000.
14 days.
How many days was in hospital?
14 days.
14 days.
14,000 incidental expenses.
Income is taken, my lord, at
Loss of income during later period. Which year is the accident?
2021, my lord, MSCT has rightly considered 15,000 as per the chart.
20?
21.
21.
15,000 is considered. How many months it is considered?
15,000 has been awarded, 1 month.
Only 1 month.
That will grant it 3 months.
Disability, my lord, a little bit. Only
Towards
7% is
loss of income during loss of future income.
Future income, my lord, the doctor
7%
has
disability is considered.
As per the doctor.
19.14% to the limb.
Uh,
7% is considered. That's right.
Then what do you want?
She is a mason by profession.
That is very amount of 7% is, so we'll take it as it is. For the permanent disability, 2,26,000. Then loss of amenities, how much is granted?
10,000.
That will enhance by another 10,000. Is coming to 3,75,800 against
2,91,900. 800.
come. Agree with the award passed in NDC number Appellate of 2022 dated 4th December 2023. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the claim petition is filed seeking compensation of an amount of rupees 10 lakh for the injuries sustained by the claimant in the road traffic accident. The tribunal has awarded the compensation as per the table given below at patient para 25. The land council acquiring for the claimant submits that he had sustained 3 injuries and the court had granted only an amount of rupees 30,000 at the head of penal suffering. And he was in hospital for 11 days, but the court has granted only 10,000 towards loss of amenities, loss of income during the later period. The amount that is awarded is not reasonable. It is submitted that even under the head of permanent disability also, the amount needs to be enhanced. Then counsel appearing for the insurance company submits that the court had rightly granted the compensation, particularly under head of loss of future earning. Court had rightly considered and taken 7% disability as the doctor has stated that 18.4% is a disability to the whole body. It is submitted that there are no grounds to interfere. Next, having heard considering the 3 fracture injuries, this court is granting 60,000 at the head of pain and suffering. Incidental expenses as he was there in the hospital for 14 days, not 11. I said 11 in the 14 days, 14,000. Then loss of income during the later period for 3 months, 15 into 3, 45,000. Loss of future income court has rightly considered, and this court finds no reasons to interfere. Loss of amenities considering the disability of 7%. This court is granting 20,000 legal expenses in the light of the law laid on so and so 10,000. Altogether, the claimant is entitled for 3,75,800. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 2,91,800 to 3,75,800. There is a delay of 157 days, 137 days, which is condoned by order dated, and they are not entitled for interest as per the order. Yes.
Till number 63.
Anyway,
Done,
it's not
Raj
there.
K.
This is matter on 20th of November. Yes.
Till number 64. Gurdev Prasad.
Tata General Insurance. Mr. Pradeep is directed to take notice on behalf of the respondent and counsel the appellant should serve the copy of the plea memo.
Case of death, one multiplier has to be in place.
This is matter on 28th. 65.
65.
My lord, I am for appellant, my lord. Case of injury, my
Mr.
lord.
Where is Mr. Venkatesh?
AM Venkatesh,
Yeah,
No
my lord, only
representation.
calculation, my lord.
Don't say no representation. This is matter on 4th of November.
Till number 66 adjourned, till number 67,
7 also in the month of December, December 8th. Yes,
till number
68,
68,
Chandrasekhar Swami. No representation, no, don't write no representation, give a date.
Yeah.
19th of November. Case
till
69.
number 69,
I am appellate in this case, my lord.
Kaya
Case
Abdul
of
Support,
Yes,
For the respondent too, my lord, kindly it may be taken up next week.
this is matter on 6th of November.
Pleasure.
till number 70,
FI for appellant.
KV
Claimants appeal
Nayak,
for announcement. Case
second
of injury.
Yes,
Case of injury, my lord. Page number 9, para 15 of the judgment, my lord. Injury.
there is no table.
no table, Your Lordship. But in the synopsis,
That's what we'll go to that.
My lord, kindly synopsis, my lord. I will. Page number 9, para 15, my lord. Judgment.
How many are the injuries?
My lord, suffered head injury, right FTP, acute subdural hemorrhage with temporal contusion with mass effect, midline shaft to left. My lord, 2 injuries, my lord.
Court has granted 65.
65,000, my lord, severe head injury, my lord. My lord,
Maximum another 5,000, not more than that. 70,000. Next,
my lord,
medical expenses.
medical
as it
expense
is,
1,87,676, my lord.
1,87,676. How many days he was in hospital?
5 days hospitalization.
Huh?
5 days.
5 days, sir.
5 days.
5 days.
Court has granted 90,000.
Yes.
No, Your Lordship,
Ma-
under the head
one-
loss of income during treatment period, court has awarded 90,000. It has been wrongly
My lord,
mentioned.
main ground, my lord.
And 40,000 to 30,000 towards later period, Your Lordship.
Loss of income?
Loss of
30,000.
income during treatment period.
How much
6
is-
months, 6 months was considered, Your Lordship.
Oh. What is, which year is accident?
2022.
2022, Your Lordship.
Is 15,500 is considered.
15,000 was
15,000.
So we'll consider 15,500 into 6. Into 6 is 93,000. How many days he was in hospital?
5 days.
5 days, Your Lordship.
Ada,
Incidental expenses 5,000.
my lord, main ground, my lord,
Then,
appeals, my lord. He was working as a
What
agriculture.
is this 90 plus 30? For that I'm not able.
30,000
It is wrongly
towards-
stated.
Yes, my lord.
Yes.
Oh, then
My lord,
what is it? The loss of future income?
future income is not
Not
awarded, my
considered.
lord.
The reason being, he himself has attended the court and has deposed before the court and he has faced the cross examination as well. And the doctor who has not at all treated the patient has assessed the disability to the extent of 10% without any basis. And he has
Already loss of ability is 40,000 is granted.
40,000 has already been
My
awarded.
lord,
And how
my
are you
lord,
entitled for any
And
enhancement?
6 months was
one more
considered
submission,
later.
my lord. My lord, he was PW5 is the doctor neurologist, my lord. He was suggested the 40 to 70% disability, my lord. Whole body 10% neurological disability, my lord. The tribunal is not taken the disability.
No,
not,
if he
my lord,
comes to the
severe
if
injury.
he comes to the tribunal and gives evidence, does it mean that they are not entitled for the amount? When the disability is there,
The court has discussed that he is completely normal and he has faced the class examination.
So,
And he has
they-
not suffered any
Kindly
financial
see, my
loss.
lord, doctor evidence, my lord, para 4, my lord.
loss of future income.
My humble submission is, Your Lordship, 6 months later period was considered instead of granting loss of future earning capacity.
Loss of, if you want, we
There
will not consider
different
that,
acts,
we'll
my lord.
grant loss of future income. So 15,500 into 12, what is the multiplier?
Multiplier 15, my lord. He was aged about 38 years, my lord. He was suggest craniectomy surgery is done, my lord.
Comes to 2,79,000. Loss of amenities, how much is granted?
My lord, 40,000 granted, my lord.
Another, we will, how can it be, because we have increased it there, we will give only 30,000.
Future medical bills, my lord, not yet awarded, my lord.
What are the future medical bills?
Your Lordship, the doctor has clearly stated that presently he is not under any medical care or treatment. Class examination, and the same is observed in page number 11
Will
of the
not
judgment.
grant. How much is granted by the court?
My lord, 4,12,676 criminals granted, my lord. 4,12,676.
It's coming to 7,14,676. Is come.
Your Lordship, one submission, Your Lordship. The basis of assessment of disability of the doctor is impaired memory and intelligence. And when he has attended the court and has faced the class exam, kindly see the class examination part, Your Lordship. He was very.
Yes, we'll hear it. This is matter on, keep this. This is matter as part heard on 3rd of November. Yes.
Cell number 71.
I appear for the panel.
Irimalaya.
Climate appeal.
This is matter on 11th of November.
Cell number 72.
I appear for appellate.
This also on the same day.
Cell number
73.
73.
I am for appellate in this case, my lord. Appellate in this case.
He's not there. This is matter on 6th of November.
Cell number 74. K. Chandrasekhara.
74 on.
That's 73.
You're here.
I am here.
He's ready.
I'm ready.
Take that.
Cell number 73.
73.
The main ground in the appeal is the court has granted around 4,09,200 rupees towards the loss of earning capacity. I request your lordship to kindly turn to the exhibits, the wound certificate and the discharge
With
summary.
all that, we'll see tomorrow. This is
TCR
matter
is not there.
Yes, next.
Tomorrow.
TCR not there. Call for the TCR. The registry is directed to secure the TCR and this is matter after the TCR is secured. 74.
Cell number 74.
And for the second respondent insurance company.
10. 10. November 10.
Cell number 75. Venkatay Gowda.
Climate appeal for enhancement.
List the matter on 6th November. Yes. Tomorrow, this MFA should be the last list.
Then DRT first list, FC second, third.
No, DRT should be the second. The petitions first. The petition, second the DRT, third RPFC, fourth MF.
Sir, 72. How date?
November 11th.
Okay.
Sir, 74 ಏನು?
ಹೇಳಿ ಸರ್. ಟಾಪ್ ಆಫ್ ದಿ ಕಳ್ಸಿದೀವಿ ಸರ್, ಕಳ್ಸಿದೀವಿ. ನೀವು ಅಲ್ಲೋಗಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು. ಹಾ.
ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆ ನಿನ್ನೆ 187 of 20 RPF. ಆಯ್ತು, RPFC 184 of 25 7. ಹಾ ಅಲ್ಲಿ ಮೆಮೊ ಹೋಗಿಲ್ಲಮ್ಮ, ಪೆಂಡಿಂಗ್ ಹೋಗಿದ್ದೆ.
ಅಲ್ಲೇ ಇದೆ, ಟೇಬಲ್ ಮೇಲೆ ಇದೆ. ಮುಗ್ಸಲ್ಲ ಮುಗ್ಸ
ಮ್ಯಾಕ್ಸಿಮಮ್ ನಾನು ಅದೇ ಮಿನಿಮಮ್ ಇದೆ.
ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ನಪ್ಪ ಮೇಡಮ್ ಅವರು.
ಇವ್ರು ಯಾರು ರಿಸರ್ವ್ ಮಾಡಲ್ಲ ಅಲ್ಲೇ. ಹೌದು.